Hey guys, it is closing time. It is closing time. We had some predictions from the state yesterday saying they think their closing will be a total of 1 hour. Remember, the state will get to go for an opening close, like the first closing argument, and then they'll also get a rebuttal closing after the defense does their arguments. And the defense estimated 45 minutes. So let's see how that goes. Um, I anticipate that from the state, we're going to hear, look, you heard from Dr. Carney. This was an extraordinary amount of cocaine. And I expect that this prosecutor's going to incorrectly characterize this extrapolation as if it was an instrumentation measurement of a level of parent cocaine in some blood sample. And that's not really what happened in this case. But I feel like the prosecutor is going to say there was an extraordinary amount of parent cocaine in Jade's blood at the time they did this 1031 blood draw. And it's something that you cannot explain by recreational, intentional use, something that likely wouldn't even be explained by like an intentional, like suicidal OD, something that wouldn't be explained by taking a counterfeit pill voluntarily, but it had something in it that you didn't expect it to have. And then they'll pair that with the information that you have this testimony you heard from Apple, that this is his pattern. This is what he likes to do. You saw him texting Xavier Winford the night before this, asking her, do you trust me? I love you and I need you to love me back. You have the testimony from Najah Harris, who we know there was a phone call. So how did I call her Harris? So Najah Jackson is corroborated. We know there was a phone call. She told us there was a phone call where she heard her friend, her dying last words, telling us that you poisoned me. What did you put in my drink? What's in your pockets? Let me see your pockets. Clearly talking to somebody who was there in person. And then the defendant doesn't call 911. He calls his dad. And then he interferes with the EMS, trying to prevent life-saving care to make sure the deed is done. And I think we're going to get all of that, right? What I think the defense is going to have a struggle with, and I'm hoping they stick to the 45 minutes, is, and I'm assuming it's going to be Miss Hollins doing closing. She's going to have to explain why there is such a huge, huge reason, a valid reason. Despite, I've seen a lot of commentary that the defense has just thrown up spaghetti on the wall to see what sticks. They've had very good witness testimony. Their experts have done a great job showing why, one, we have reliability issues with the initial sample that was used for Dr. Carney's extrapolation, and two, that the extrapolation that Dr. Carney didn't even follow the correct formula that she should have been using. She did a 1-to-1 weight ratio using the metabolites of cocaine to extrapolate backwards what the concentration of that blood sample could have been at the time it was drawn. That's not the formula. It's supposed to be done in molars. And if we actually did the correct formula, the extraordinary amount would become even more extraordinary. Something where, based on Dr. Carney's calculations, you heard it, you would need an elephant's amount of cocaine. That would be the expectation. We'd have to do 4 to 16 8-balls, depending on the purity, to get, based on the state's theory of the ingestion time frame window when Blaise was present at the house, through the time that she had the reaction and 911 had to be called. To get there, you would have to guess that 4 to 16 8-balls would be necessary if we go with the extrapolation that Dr. Carney did. That's unrealistic. And yet that number would actually have been higher if she did the correct extrapolation. Is it realistic to think that somebody snuck in a higher amount of cocaine in somebody's drink than 4 to 16 8-balls? And that's, again, based on a sample that goes outside NMS's standards for stability. We didn't use a gray tube. And that means we don't have the sodium fluoride preservative that would help prevent some of the metabolization from ongoing, the hydrolysis, and we don't have the anticoagulant. And that's a problem because when you pipette a quantitative amount of volume out of a sample, if there's clots, there's going to be things that are clumped together, and the free liquid that you're going to withdraw for your testing might not be a properly mixed, homogeneous, representative sample from what Jade's in vivo blood would have been at the time. Major, major issue. And again, we heard that NMS receives a sample from the hospital chem lab. It was already at the chem lab, and we have no idea if or any testing was done. We don't know if it was refrigerated. We don't know what the original volume in the vial was. We just know that by the time it gets to NMS, it's 1.75 milliliters, which is above. They only need 1 milliliter for their cocaine testing. Here's their standards. This is NMS, specifically for cocaine panels. Now, they met this volume, but their criterion for clinical samples, and why we heard Dr. Carney say this is a once-in-a-lifetime collection opportunity for us to try to extrapolate some amount. This should have been rejected, but it wasn't because it was so important to try to have an early draw for Jade. NMS's criteria for max stability windows, 1 day at room temperature. If a vial's at room temperature for longer than 1 day, according to their criteria, at least as far as it concerns a cocaine panel for a whole blood sample, and then even if refrigerated, our ceiling is 7 days. But NMS didn't get the sample until 37 days after it was drawn. So not only do we have issues with the extrapolation, which if we trust the instrumentation and the reliability of the sample, there's the problems with the extrapolation that Dr. Carney used to determine this quote-unquote extraordinarily high amount of cocaine. But then we have the problems with the reliability of the sample and the chain of custody, and we don't know what happened with this blood sample. And they're going to have to explain that. They're going to have to keep it simple and not lose the jury's interest and tie together some very complicated expert testimony without eyes glossing over. But I think there's a chance they could do it. And then, of course, they'll get into the other things. Like we saw that there was conversations where coworker Lauren, the first person that goes into the house, make sure she timestamps a photo in that house. You know, Jade was seemingly okay playing Adderall transport middleman between NJ and her coworker Lauren. And her coworker Lauren and her significant other were also going through Jade to pick up different controlled substances in the days leading up to this incident, very near in time. And law enforcement totally ignored Danny Weed. If they had looked earlier, perhaps they could have determined who the Snapchat user that sent the 7:01 p.m. Snapchat message saying, "I'm already effed up." Maybe they could have determined who that was. Maybe they could have determined who the other 3 unknown Snapchat messages were from. Maybe we could have known more. Maybe we could have tested the hair strand. And they could have proven to you and eliminated the idea that, hey, there's all these text messages about drugs and prices and whatever it is. But maybe a hair strand would have been helpful here, but the state did not give you that, and that's their burden. Right? So, I don't know. We'll see what we see. But I really think the defense has done a great job going after the heart of the issue in this trial. This is called the poisoning trial, based on Dr. Carney's extrapolation and conclusion that because her extrapolation took the 78 nanograms per milliliter of cocaine, and she added that as a 1-to-1 weight ratio, not molar, which is the formula, but as a weight ratio to the 7,800 nanograms per milliliter of the EME, she goes, oh, well, since that's a metabolite, I'm going to conclude that there could have been 7,878 nanograms per milliliter as the concentration of cocaine, parent cocaine, in Jade's blood at 10:31 p.m. on February 25th. And I think if you follow the testimony and even some of the questions that were asked of Dr. Carney and Mr. Kratulski and the NMS Midthin, I think the cross-examination through those witnesses tackled the reliability of the sample, tackled issues with that extrapolation coming from that sample. And I think the defense has done a great job to say, hey, we actually have not proven beyond a reasonable doubt. In fact, it's highly questionable. It's really bad science. The sample we used defies the criteria that we would typically say we need to reject the sample entirely. We can't use the sample, but we chose to use it here anyway because it's all we had. And that means the state hasn't proven beyond a reasonable doubt that there was a extraordinary volume concentration of cocaine in Jade's blood, which might mean that she never ingested a highly extraordinary amount that you would find to be consistent with poisoning and no other explanation. And let's see if the defense can argue that. So let's see, we've got action in the court.
All right, anything before the jury's brought down?
There was one thing, Your Honor, in regards to the exhibit that we discussed on yesterday.
One thing about the charge?
No, sir.
Oh, okay.
It was about the exhibit from yesterday that we went up there. When I looked at the exhibit list,
The one that was introduced?
yes.
60, from the deposition?
No, sir. It was in regards to the text that we discussed at the end of the day yesterday.
That the state said we would have asked a whole lot of questions of your phone
Yes.
person. What about it?
I didn't understand yesterday. I thought that you were entering it, or were you just accepting for offer of proof?
Offer of proof
Okay,
marked
that's all
with
I
those.
need to know. Okay, thank you.
All right, let the jury step down. All right, good morning to you, ladies and gentlemen. Let the record reflect all that yours are here and present in closing argument on behalf of the state.
Yes, Your Honor.
Here we go. If she's quiet, we'll turn it up, because remember, openings are really quiet.
You did this so something would happen to the baby.
Turn her up.
Jade Benning, she did not call 911. She did better than calling 911. Jade Benning called the one person who knew where she was, knew who she was with, would know that she was calling scared and for help. Now, Jada Jackson said as soon as she heard her best friend's voice, she knew she was scared and she needed help. Jade Benning did better. She made sure that Blaise Taylor was not the only person to hear her last words. She made sure that you heard her last words. She called Nijaya Jackson and said, Blaise, you're scaring me. Nijaya heard him say, you're scaring me. I know you put something in my drink. I knew my drink tasted funny. Let me see what's in your pocket. Let me see. I know you put something in my drink because I can't even walk straight. I can't feel my legs. You put something in my drink. You did this so something would happen to the baby. I think I'm about to pass out. Jade Benning ensured that you heard her words that night where she was so excited to be having a date night with Blaise Taylor. Her best friend came over. They were the only two people there. Dr. Aaron Carney gave a very specific medical explanation that Jade Benning would have gone pulseless within 30 minutes of ingesting that concentration of cocaine dissolved in a liquid. There were only two people there. The proof and testimony that you have heard over the last week from Jade Benning's family and friends, the pictures, the things in her phone, she was so excited to be having this baby. She was so happy and planning for her baby girl to be born. I submit to you that it does not matter how many questions were asked about fentanyl or cocoethylene. It does nothing to change the evidence and proof that you have.
The most critical evidence.
That Jade Benning did not want to harm herself or her baby. She wanted the opposite of that. The proof and evidence from Nijaya Jackson and Dr. Aaron Carney is proof beyond a reasonable doubt for counts 2 and 4 that Blaise Taylor intentionally put that cocaine in Jade's drink to kill the baby. And Jade Benning was killed when he did that. You also have the proof and testimony of Apple Denny. She described to you an event that happened several years before in 2017, but when she heard about what happened to Jade Benning and that Jade Benning was dating Blaise Taylor, she knew immediately. She reached out and contacted people because she knew she had information that it was him. She testified, told you about very personal things that happened to her, but she described what happened over a period of 2 days. Her testimony was she had to talk him out of putting something in another girl's drink who was refusing to have an abortion so that he could cause the abortion without her knowing. Blaise Taylor chose cocaine. He chose what to put in that drink. He chose a substance that you have heard from multiple witnesses is known to cause spontaneous abortions. Dr. Carney described that it is known to cause a placental abruption. And she also testified that that did not happen to Jade Benning. It did not happen because he killed her. I submit to you that there is proof and evidence that you have heard over the last week that proves beyond a reasonable doubt all 4 counts of the indictment, including the first-degree premeditated murder of Jade Benning. Blaise Taylor chose this. You saw when he got back in touch with Jade Benning, they had a conversation that explained what happened back in November of 2022. This is kind of a somewhat joking conversation, but Jade Benning said, "You gave me a crazy ultimatum." Apple Denny testified to that same ultimatum. You have Jade Benning's decision to the ultimatum he gave her. She chose her baby. She did not choose Blaise Taylor. She did not make the choice that Xavier Winford made back in 2017. She chose her baby. Apple Denny gave that same description of the ultimatum, and you have that there was no contact from November 6th to December 31st of 2022. Jade Benning was planning for her baby. Her life was going on. But you also heard from her family and friends that during that time, she was not posting anything about her pregnancy to social media. She had not posted anything to social media about her pregnancy on the day she was murdered. It was not publicized. When Blaise Taylor comes back into Jade Benning's life, this is the evidence that you heard was not he came back welcoming this opportunity with open arms. He tells her very specifically in these messages that your life is changing. This is going to be a thing for you. At no point does he say we, me, ours. This is going to change Jade's life. And he is not portraying it as a positive, telling her she shouldn't be so optimistic. And Jade Benning, just as her friends described her, always optimistic, still said, okay, but I'm going to be able to make this work. Blaise Taylor did not go to any of her pregnancy appointments with her OBGYN. Not one. She asked him very specifically, sending him the calendar event, and specifically saying, I really hope you can make it. I would love for you to be there when I found out the gender of our baby. If it's going to be a boy or a girl, I want you to be there. And he did not go. And even when they saw the shadow and she had to have follow-up testing and then another follow-up appointment, he didn't go to any of those. Jade's stepmom, Andrea, she went with her the day that she found out she was having a baby girl. And Jade was still so happy even though he wasn't there. You also have proof about why Jade wasn't posting, about why everybody didn't know that it was his baby. He was the father. You have a message where Jade is saying, I talked to my mom and let it be known not to bring up you or my situation to anyone. She is defending him and his request that no one know that he's the father of the baby. He responds, but it's all good as long as we are on the same page moving forward. Everything is cool, but I appreciate it. The day
Of course.
before Jade Benning
Xavier's
is murdered.
text. Here comes
The
Xavier's
day
text.
before, the night before she
Here we
is
go.
murdered, Jade Benning wanted to see Blaise Taylor that night, and he didn't. He is texting Xavier Winford, who he's had some kind of relationship with since 2017. He's texting her and saying, you should never doubt anything when it comes to us. And she says, I'm doing my best. And he says, I know, I'm trying to reassure you. She thanks him. He says, I'll do anything to help you. That's what I'm here for. She says, I trust that true. And he says, good, do you trust in us? She responds, yes. Good, then you have nothing to worry about. Everything is going to work out. She says he's glad. He says, me too. I love you. And I need you to love me back. And be in love with me. She responds that she loves him, and he says, good, I just want us to be happy together. We are going to be just fine. We just need to stick together. And she promises him that they are going to stick together. The next night, he goes over to Jade Benning's house for date night. The date night that she's planned. She has canvases so that they can paint pictures for the baby's room.
You're gonna call it a black hole? Oh, they're not
He
doing it.
goes over there to the date night with cocaine to put in her drink. He goes to the date night. The testimony that you heard from Nigella Jackson and from Keontae Jones about them stopping by, that whole time that he's shuffling those Uno cards, he has the cocaine to put in her drink. He gets there at 7 p.m. They show up at 7:30 for 30 minutes talking about spades and having random conversation. And he has it. He does not call 911 until 9:29:27. I'm sorry. The call that Jade makes is at 9:29:27. EMTs don't get to her until 9:50. Dr. Carney's testimony is that Jade was given the cocaine that she ingested orally 30 minutes before. You have this photograph from 8/29 that shows the progress. She has not been given anything at that point. The next image that you have is at 9:10 p.m. It is somewhere between this point and the next image of their progress that she has to have been given the cocaine in her drink. (9:24 p.m. is the next time that there is an event. It is after that 30-minute mark She has finished the painting. You heard Dr. Carney's testimony about how the symptoms would start off not severe, but it would escalate really quickly. And 9:24 to 9:28, you have 4 minutes. 4 minutes after he has put this in her drink. He is there and knows what he has done. And for 4 minutes, takes picture after picture with Jade Benning. Blaise Taylor went there with a plan. There was a plan. He has already poisoned her, and he is taking pictures with her. Blaise Taylor did not plan for Jade Benning calling Nyjah Jackson. That hadn't happened yet. The last event that happens is that deleted picture, and within 45 seconds, Jade is calling her best friend. What did you do? She is calling her best friend scared, and she is not talking to Nyjah. She is talking to Blaise Taylor. 6 minutes and 9 seconds. He is there. Jade is telling him, I can't feel my legs. I can't walk straight. He is there, and he is not saying anything to her. Like, Jade, what is wrong? What's going on? Let me help you. Come on, sit down. What is happening? You seemed fine just a second ago. What can I get you? Do you want me to call someone? You didn't hear testimony of any of that from Nyjah Jackson. You also heard Blaise Taylor tell Detective Smith that third interview. He was describing what happened that night, and he said that Jade was trying to lay down. He didn't tell him, so then I helped her. He says that Jade was talking to him. Talking to him. And then he says she wasn't saying stuff right. Maybe she was kind of talking to Nyjah. Now, at this point, when he tells this to Detective Smith, Nyjah Jackson has already told everybody exactly what she heard her best friend said. She's told the people at the hospital, the first officer, the second officer, the detective, family and friends. She's told Blaise Taylor to his face, like, you didn't tell them what she said. He stood there for 6 minutes and 9 seconds knowing that he put cocaine in her drink and she drank it. Well, she said these things to him of, I know you did this. Stood there for 6 minutes and 9 seconds and did nothing to help her. At some point, Blaise Taylor figured out that Jade called Nyjah. He tells Detective Smith that he was there when she called her and that he spoke to Nyjah on the phone. And Jade told Nyjah she wanted her to come over. Nyjah Jackson's testimony was unimpeached about what she heard her best friend said and about what happened that night. Blaise Taylor did call 911. He did. But he already knew that Nyjah had been on that phone call. because this is before Nigea has gotten back to the apartment. She hasn't told anyone she heard what he said. She hasn't called him. She doesn't call him until 9:47:11 when she calls back to Jade's phone. That's when she talks to him. But 5 minutes before that, after he's called 911,
no. If you look at the phone, I think one of her friends along the way told her. You right there? No. If you look at the phone, I think one of her friends along the way told her.
Blaise Taylor is telling the 911 operator that one of Jade's friends is on the way. He hasn't spoken to Nigea Jackson yet, but he already knows she's on the way. I submit to you that call to 911 by Blaise Taylor is because Jade messed up the plan. He knew Nigea was coming. That's why he called. And even then, after 6 minutes and 9 seconds of Jade Benning's last words on earth, he doesn't even call her immediately. He doesn't call 911 immediately to get her help. He waits 2 minutes and 37 seconds, and then he calls his dad, which that's a 30-second phone call. There was no testimony as to whether or not that call even got answered. It's 3 minutes and 28 seconds after that call with Nigea ends before he calls 911. There was no cup with any cocaine that was collected in that apartment. There are 3.5 minutes before he calls 911. You do have his statements with Detective Smith. Blaise Taylor tells him, oh, there's no alcohol whatsoever. No, 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 no. And we both drank the same stuff. And then he's asked if he cleaned up, and no cleanup. He says that Jade cleaned up some, there was some cleanup by her, but he was not cleaning anything in the apartment. And when asked if they went back and got the glasses, if the lab would test positive for anything, and he said, no, it won't. Now, there's at least 2.5 minutes before the 911 call, and that's just the call to his father. There's this time of what's happening. This cup ends up over by the sink. Detective Reese testified that it appeared it had been washed out. The camera, that is after Nigea Jackson moved the camera back to where it normally would have been. This is from 3 days before. This is what the camera would have captured. If someone went over to the kitchen island and did anything to any of the cups, it would have been on that camera. But that camera was not where it normally was. When her friends, thank goodness, went to her apartment to secure it and make sure that the evidence was collected, that's where they found the camera. In her bedroom with the blinds up, in a place that would not capture anything that happened to Jade Benning on her bed, and anything that happened in the kitchen. You notice the selfies that they took for 4 minutes while the cocaine was clamping down on her blood vessels before it could make her heart stop. They were all off to the right, not in that camera angle. The 911 call that happens 3.5 minutes after the call to Nigeria ends. Listen to the call and where he is.
February 25, 2023, 21:38 and 58 seconds.
911, what is the location of your emergency? I'm not sure if I'm bouncing back. I'm at a friend's house and I think she's having an allergic reaction. So, what's the answer? So, how else is there some way you can find her? I don't know. It's an apartment complex. Is there a nail with her? With the address, I'm looking around. I'm looking around. I don't know what's going on. I think she did bad. Give me 1 second. Okay, are you on Donald tonight or are you on Lebanon here? Lebanon? Yeah, Lebanon. It's apartment 107. What is it? Is it 5040 Lebanon Place? I don't know. It's not Burger King. I do know that. I'm going to find the building to get it's a condo / apartment. Yeah, so okay, is there a council of the corner there, sir? Is there a what? Is there a council of the corner? I'm not sure. I just passed it. I'm going to, the Ontario, 1522-1550 Lebanon Pike, the Ontario. 1522? Yes. The Ontario, 1522-1550 Lebanon Pike. So the Ontario 1522, she's in apartment 107, and she's having an overdose, is that correct? I don't know, I think she's having a reaction. We were eating cookies and pain, and she said she was feeling it, and I went back to the room to check on her.
I'm running back to the room to check on her. He's outside.
Because you asked him to
It
find out
might
where he
not be
was.
the pink cup by the sink. He's had all of this time. He's running around outside. He's not there with Jade. He told the first officer, the second officer, Detective Smith, everybody. She threw up, called my dad. He told me to hang up, called 911. He is running around outside, not even with her.
No, and what's the thing you disconnected while you're up there? What's the callback number that you disconnected? This number right here. Is it 877-35738? Yes. Okay, how old is he? 23, 24. Okay, is she awake right now? Yes. Okay. And you think she's having an allergic reaction to food? I don't know, we got cooking and pasta. I don't know what she's done, if she's done anything today or anything, but everything's fine, and then, I don't know what's happening. So we got 6 1 out of my she's shaking. So you think possibly reaction to not knowing food, is that correct? I think so, I don't know. I don't think she's allergic to anything, I don't know. I don't think she is or not. It could be an allergic reaction. So are you next door? Next door? Yes, sir? Yeah. Okay, does she hear me breathing normally? Yeah. Okay, does she have any difficulty swallowing? I don't know. I
It sounds like she's snoring. Dr. Carney explained that that's agonal breathing, that she is very close to full cardiac arrest. Mr. Taylor describes her as being breathing and conscious the entire 911 call. I submit to you it's unclear if he is giving any information as it happens or if he's just describing what's already happened. He calls 911 knowing that Nigea Jackson is on her way and she is going to find Jade Benning pulseless. He called knowing what he gave her. When they found her, she is face down on her bed, her mouth on the comforter with pink vomit that tests positive for cocaine. I submit to you, it doesn't matter what was in the drink. It doesn't matter if there was something else mixed in with it. That doesn't matter. The proof and evidence in this case is that Blaise Taylor put whatever it was in Jade Benning's drink. He did it and then stayed for 30 minutes. He did it thinking he would be the only one that would hear her words. He did it thinking you would never hear her words. Jade Benning said, "You put something in my drink. You did this so something would happen to the baby." Blaise Taylor is guilty of the first-degree murder of Jade Benning. He is guilty for the first-degree murder of her unborn baby girl. The proof and evidence in this case proves that beyond a reasonable doubt. He is guilty of both counts of felony murder because he chose to give her cocaine, he chose to put it in her drink, and he chose to kill both her and her unborn baby girl. And we will ask that you return a verdict of guilty on all 4 counts of the indictment.
Closing argument on behalf of Mr. Taylor.
Yes.
What if they just said no closing? Oh, they're going to use the mic'd up podium for us. Love this. That was kicked out of the court at the very beginning of the trial. In case it's loud with the mic, we're going to turn it down because we turned it up for the micless opening. Let's see. Got yellow legal pads. Let's go.
Good morning.
She's walking away.
Standing here at the end of the trial and trying to put everything together is always, for me, very difficult because the burden is always very heavy. And your jobs are never, it's just never easy. Never easy. But we're here. And one of the things that I want to talk to you about is the words that you guys gave us. Not just me, but the state as well. Not just Mr. Taylor, but Jade's family as well. No matter what happens as a result of this, it is still a tragedy. It is still a very awful incident that occurred. And there is only one question that we have to answer. Is whether or not Blaise Taylor, in your minds and in your opinions, is guilty beyond a reasonable doubt. There is only one question or one thing that we will ask of you, that I will ask of you, that Blaise will ask of you, that his family will ask of you. And that is to keep your word. Keep the word that each one of you gave us. And that is that you could follow the law. You cannot, we cannot build a justice system based on emotion, based on sympathy, based on just the mere fact that a tragedy occurred. Every time a loved one leaves this earth, it is sad and it is a tragedy. But that in and of itself cannot drive our justice system. What we cannot do is say, because someone lost their life, that we don't have to follow the law, that we don't have to hold the state to its burden, because otherwise this system collapses. We could talk about the pain that a mother feels when she loses a child. We can talk about a beautiful young lady and her daughter who is no longer with us. And if you're not human, you won't hurt. But if you are human, you will hurt. But that should not play into your decision making. In order for this thing that we call the Constitution to work, you have to set that aside. And that's the word that you gave us. That's the oath you swore to take. There is a burden here. And I bring it up because that's why we're here. I'm not bringing this up as a facade. I'm not doing that. I'm just reminding you what the law is. I'm just reminding you what governs this trial. Every defendant has a Sixth Amendment right to a fair and impartial trial. Every citizen charged with a crime should get a fair and impartial jury trial. And at the end of the day, when those jurors make a decision as to whether or not he is innocent and or guilty, they must use their burden of proof. And they must hold the state to it. What you can't do is say, well, then what happened to her? If he didn't do it, then what happened to her?
They gotta prove it.
Well, I don't know. Well, I don't either. Well, then he must be guilty. Because he didn't prove to us that it wasn't him. But remember, we don't have to do that. That's not the burden. They must prove to you what happened to Miss Bennett. They must prove to you beyond a reasonable doubt what happened that night. Not us. Not the defense. So then you ask yourself, well, what happened? If he didn't do it, what happened? You're going to say that a million times because that's just a natural reaction to what we're dealing with. But remember, as you are going along that journey, deliberating back there, going through the evidence. Remember, they must prove it to you. You cannot ever place that burden on Blaise. You cannot. The minute you do that, that Sixth Amendment right to a fair trial collapses. And once that collapses, the system collapses. And once the system collapses, you have people wrongfully convicted and sitting in jail for a very long time, trying to prove their innocence. And that's not the way it was designed to work. That is not the way our forefathers meant for it to work. So with that being said, let's talk about it. Remember, as we came in here on June 22nd, 2026, we dealt with an official finding of undetermined, the manner of death in this case, by the state's own medical examiner. She had the option to choose homicide. She knew the facts. You heard from Dr. Carney way before you did. And she couldn't figure out what the manner of death was. She landed on undetermined, and she's still on undetermined. Now you're tasked with whether or not you can take it over the hump and move it to murder beyond a reasonable doubt. I want to talk to you guys first about the facts of this case and what you've learned since you've been here. What I don't want you to do as we take this journey is come into this environment and say to yourselves, I want to live in La La Land. I want everything to be perfect. Life isn't perfect. And the older you get, the more you learn that. The older you get, the harder it gets. Trust me when I tell you that. And those of us over the age of 50 can tell you about things that we experience in life that are good, that are ugly, things that we've learned along the way. How we treated people in the past, how we interacted with people in the past, how we respond to people in the past, and how we respond to people now. You learn along the way. But what life isn't is a perfect cookie cutter La La Land. That's not life. So let's talk about Blaise and Jade. They met on Hinge. They dated for a little while in terms of, I shouldn't say date, they interacted for a little while, but never really met up. And remember, these are young people. They had casual relationships, not just with each other, but with other people too. And it wasn't just Blaise that dated other people, they both dated other people. They were adults, they were consenting, nobody did anything wrong because everybody agreed that you can date someone else and you could date someone else. We may not want to live our lives that way, but that's the way they chose to live their life. So when you hear the facts about Blaise texting someone else, that was nothing against Jade because she was okay with it. So don't let the state make you think that because he was dating someone else and he texted that other person, that that was something nefarious or wrong. It wasn't. He didn't have to hide that. She knew that. Najee told you that. She said it to the police officers. She said they weren't dating like that. They weren't exclusive. So no matter how many times the state tells you that Blaise was texting another woman, there's nothing nefarious about that. And that has nothing to do with whether or not he committed murder. So don't go down that road trap. Stay focused on what you're here to do. And I want to be clear when I tell you that when we're talking about facts, if you remember, in voir dire, I had a slide up, and it had facts and blame. And I asked each one of you, would you be okay if sometimes facts were ugly, but I needed to share that with you so that you could have all the facts to come to a decision? It would be unfair to Blaise if you didn't have all the facts. So don't think that those facts that we're putting before you are there to put blame or shame on anybody, because it's not. But it would be unfair for you not to have all the facts so that you can come to a conclusion, one that makes sense based on the evidence in this case. Because that's how you get to a solid verdict, is because of evidence, not of sympathy, and not of being angry because I want to give you facts. That's all I want to do. So when they're dating in this casual relationship, they knew each other for less than 90 days. That's a fact. They met up in August, and before the end of the month, they were having sex. That's a fact. And they were having sex without a condom. That is a fact. And we know that because otherwise she wouldn't have been pregnant and thought it was Blaise's. So when she finds out that she's pregnant, she and her best friend are trying to make a decision about who the father was. Because at that time, she wasn't sure. And we talked about that with Najee. And to me, I think that that is a crucial fact for you to consider. Because if she wasn't sure Blaise was the father of the baby, neither was he. So you would then have to believe that he would kill her and that child, not even knowing if it's his or not. That's a fact. And so she tells him she's pregnant. And he's not happy about it. She is. And that's great. There's nothing wrong with that. But Blaise, on the other hand, with only knowing her for 90 days, maybe he's not happy about that. I guarantee you he is not the first human being that in his 20s had a unexpected pregnancy pop up and he's not happy. I guarantee you he is not the only human being who's ever felt that way. And they want you to believe that that's just a horrible fact that would give him motive to kill her and the baby. Most folks in their 20 years, who is in their 20s, who get someone pregnant that they don't know within 90 days, I'm willing to bet at least 50-50, are not happy. That's real life stuff. That's not a nefarious fact. That's just real life stuff. And that's what I'm going to talk to you today. about. It's real lifestyle. Because if you remember, you heard from Nigeria, they were talking about possibly going to Indiana for an abortion. Remember, Nigeria was saying it was 2 weeks, 8 weeks, you better make a decision and make it quick if that's what you want to do. And she said, yeah, I do. I need to make that decision. You heard that testimony. Eventually, she landed on having the baby, which she has every right to do. But somehow, it's okay for her to consider abortion. But it wasn't okay for Blaise to consider it. That's not fair. Don't let them turn that into a nefarious fact that will automatically get you over to murder. They both considered it. It was just her window was shorter than his. And it would be unfair for you to punish him if you don't punish her. So at some point, they talk about it. Apparently, Blaise was still in the position that he was in, even though she had changed her mind. And she, with the strength that obviously she has, or had, said, look, I'm not changing my mind. You've made your decision. If you don't want to be part of this baby's life, kick rocks. I'm good. And he said, okay. You don't see after that, because Najee, I asked her those questions. You don't see after that Blaise constantly calling her, trying to convince her to have an abortion, trying to manipulate her into having an abortion, blowing up her phone, smoothing her out. Because if ultimately his plan was going to be to try to kill the baby, it would have made way more sense to do it up front than wait till she's almost 6 months pregnant. Why would you wait until somebody gets 6 months pregnant if that was your plan all along? Remember, she came back in contact with her December 31st. So he's going to drag it out and let that fetus get 2 months bigger? That would make sense. He could have done that a whole lot sooner. That would have made sense. That would have been easier. A miscarriage within the first 90 days, that makes sense. Some people don't even tell people they're pregnant for the first 90 days until they're sure that they get past that first trimester. But he'll wait until she's 6 months? So she makes a decision. She says, you go your way, I'll go mine. And he honors that. He honors her wishes. Now, if he was cooking up and stirring up this evil plan, why wouldn't he start the manipulation right off? Najee told you that she liked him. She wanted to be with him. So it would have been easy for him to do that. But he didn't. And I think that's a very important fact. Because if you remember that text message that they read, to you, I want to remind you of that text message. This is Jade. Remember, they read this to you. Next time I'm tagging along for the adventure. LOL. Blaise says, LOL, okay. That's if you want, of course. This is Jade. LOL. He says, gotta still have a job first. And second, you probably ain't doing much traveling for a while anymore. When next season rolls around, I don't think you'll be able to just make impromptu trips on the weekends, considering you'll have other responsibilities. Not trying to be negative or nothing, but just being realistic. I mean, it would be great if you could, but it's unlikely. What does that mean? That means next time this year, you're going to be a mother. She's 23, 24 years old, 24. You're going to be a young mother. And that comes with a whole lot of responsibilities. So start getting your mind right. And if that's going to be the mother of his child, let me give you a little advice. Men who handle their business, they want women, the mother of their children, to handle their business so that they can set a good example for the child that they're raising. Don't let the state turn that into some kind of, oh, he was so mean. No, he was telling her the truth. And those of us that are mothers, we know the responsibility it takes to raise a child. There are often times you miss trips because you got to stay home with your child. You don't get to go away like you used to when you're single. You need to start thinking about those things. The lifestyle that you live, hanging out with your friends and drinking and having a good time, that's going to change. And that's what he's telling her. Not to be mean, but to be real. What's wrong with that? Then he goes on to say, or she says, LOL, okay, didn't mean to make it all serious, but yes, responsibilities will be different, but living life will still be happening as well, just living differently. And I understand the realistic thinking of it as well. It's part of the big change, she says. And he says, yeah, especially for you. I remember getting pregnant. And my mother says something I'll never forget. It goes a long way. She said, honey, that's going to be your baby. Because it's nothing like a mother with their child. Daddies love their children, yes they do. But they don't love them the way the mother does. That mother gets up every morning. That mother got to comb hair. That mother has to get that child out there. And yes, the father should participate as well. But the reality of it is, men don't come close on the daily activities that a mother does with their child. That's real. It's probably something he saw every day with his own mother. And she says, of course, wasn't trying to get into a serious talk for us, sorry. He says, but we don't got to be super serious. I just didn't want to sell false dreams because, yeah, it would be great if you could come on my work trips. But I just feel like it's not realistic from a financial or just a feasible ability to randomly catch a flight and get away for a weekend. We're young. Money's already tight. We can't just spend money on getaway trips on the weekend and this baby is coming. And I could lie to you or I can keep it real with you. Blaise wouldn't have been able to win here. It didn't matter. If he would have sold her a dream and lied to her on here, they would have been telling you that. But now he's keeping it real with her, being honest with her. And now that's wrong too. Would you rather him lie? The man was trying to be honest. The man was trying to be responsible. And somehow, that's wrong too. It's no big deal. I know you wasn't meaning it that way, but I just didn't want to be like, oh yeah, I'll bring you on the next one, next year, knowing that it's probably a lie. She says, totally understand, babes. It's not like it can never happen because I'm having a baby, but realistic, it wouldn't be able to on the fly. Planning out things will always be an option. Life doesn't just stop because of it though. Laugh out loud. We're still going to have one, just living different. He says, I hear you, but you can't minimize how much things are going to change for you. You've got to be realistic that things are about to be hella different for you and will change drastically. Your day-to-day life is not going to be the same. Yeah, life goes on, but it's forever altered and changed in a drastic way. I'm not saying it's over or anything, but it worries me sometimes when you downplay it and act like it's no big deal. And I know you always want to be super optimistic and stuff, but I feel like you need to be honest with yourself about the situation and know what's down the road for you. Now let's back up with that. He says it was downplayed. It has gone on in the past that has caused him. So there's something going on there that made him feel like he should have this conversation with her. If that's going to be the mother of his child, what's wrong with that? In fact, that might be good. And then he says, I just want to make sure you understand the gravity of the situation and you're preparing for those realities. That's all. She says, I'm not trying to minimize things, and sometimes I can be super optimistic. She's admitting to it, about things which can be scary. But I do sit and process that there will be drastic life changes and prepare myself for the tough realities as much as I can that are to come. I'm not just trying to make it seem like everything is going to be all peaches and cream. I am hearing and understanding everything you are saying. He liked it. And then he says, hey, what time are you going to work? She says around 3. So she wasn't upset about the conversation. And if you remember, Mr. Devlin, when he was testifying about some of the text messages between them, do you remember when she said that it turned her on when he talked serious with her? That's what this is. That came out of her mouth. It turns me on when you talk serious to me. Some people like to date people and be with people that motivate them to be their best. People who hold their feet to the fire. Iron sharpens iron. And I always say, I never want to be the smartest person in the room because how can I get better? So when you're attracted to people who are responsible and that's who you attach yourself with, you're hoping that it makes you a better person. All of our parents have told us, watch your friends. Watch who you hang out with. Look at the 5 closest people in your life and you'll see your future.
Is she going to segue?
So she wouldn't have said that she's turned on by having serious conversations with him if she wasn't. And so that was the nature of that conversation. Now, there was so much talk about how Blaise just totally disregarded the baby, totally disregarded her pregnancy, as if he was just pushing her off to the side, waiting for the perfect moment to kill her and the child. Because if you notice the tone of that text message conversation, it was talking about the future. Why talk about the future if your plan is to kill her anyway? You wouldn't even have to have those conversations. You could just continue to make her feel peachy and creamy. You don't make plans and you don't try to help the person become more realistic about what it takes to be a mother if it's not your intention for her to be a mother. That doesn't even make sense. So I wanted to show you a few things because we didn't get to show you everything in the phone, because if you remember when I asked Mr. Devlin, was there a whole lot more in there? He says, yes, we only provided a sample. So some of those text messages were, Blaise told me last night he signed up for monthly subscriptions of diapers from this company, Kudos, LOL. Why would he do that if it was his intention to kill the child? Didn't you ever state at occasion you knew that he and Miss Benning talked about naming the baby Jim? Do you remember when I asked Nigella Jackson that? And she says, yes. I said, well, that would be involved with the baby, wouldn't it? She says, yeah. Because remember, her name is Jade, his name is Blaise, and so they were going to name the baby Jim. That's being involved. It may not have been to the level that she would have wanted it. And I guarantee you yet again, if we're talking about real life, there's a whole lot of women out there who would love for their significant others to be a little bit more involved with the child. I certainly know that I would. Here, does Blaise rub your belly? LOL. Sometimes. If he's planning names, buying diaper subscriptions, and rubbing her belly, then what we're really talking about is that he wasn't doing it on the level that maybe she wanted it. It wasn't that he wasn't doing it at all. Let's go now to the day in question, because we know how they've met. We know how they dated. We know what the understanding was. We know they both considered abortion at one time. One changed their mind quicker than the other. They got back together. They're having realistic conversations. And remember I told you about before, during, and after. Because no one saw Blaise put cocaine in Jade's drink. Nobody saw that. That's undisputed. Nobody saw Blaise give her alcohol. And we're going to talk about that a little later. Nobody saw that. So what that means is, this is a circumstantial case. And in order for you to come to a conclusion that is proper in a circumstantial case, because those are the most dangerous ones, because nobody sees what happened, you have to consider all the surrounding circumstances. Most of the time, the crime is in the cleanup, and I'm sure you've heard that before. So you have your before bucket, your during bucket, and your after. What we do know, and like I said, I'm not doing this to shame anyone, because if I was, I would have a ton of text messages up there about drugs and all kinds of stuff, but I'm not doing that. The only reason I'm sharing this information with you is so that you can have the facts as they really are. So when we talk about before, there was only one person involved with drugs, and it wasn't Blaise. You didn't hear any evidence of Blaise purchasing cocaine, smoking weed, doing mushrooms, getting drunk, drinking alcohol. In fact, it was the exact opposite. The evidence you heard is that Blaise does not drink and does not do drugs. However, what you did hear is that Jade does drink to the point that she gets drunk and she does drugs. So that's before. Remember, this is circumstantial, so you consider all the facts surrounding it. Jade invites Blaise over. This is important because Blaise didn't know that Jade was going to invite him over that day. He had just seen her the day before. Remember, they had gone to the Waffle House. So there were 2 days before that he was with her, that he could have pulled off the elaborate plan, but he didn't. And so spontaneously she invites him over again. This is the 3rd day in a row now. And so you see here also, will you be free around 7 o'clock? Yeah, I fell asleep watching Outer Banks, then woke up to gun firing on the show. But yeah, I should be. LMAO, woke up confused, ASF. Okay, I'll have plans for us. You can come dressed, comfy to my house. Okay, sounds good. Sweet, I am getting off now, she says. And that is at 3:50. And he says, how was work? So now the spontaneous plan is 3:50. He has 3 hours to cook up the elaborate plan to kill her. Because remember, he didn't know she was going to ask him to come over that day. So he comes over. When he comes over, it's 7 o'clock, he's there, and then Nigella and Keontae shows up. He didn't know that, right? Now, if all the while it was his plan to kill her that night, you would think that once Keontae and Nigella showed up, if he had any kind of sense, he'll abort the plan. But no, he's brazen. Even though her best friend came over, saw him in the apartment alone with her, almost 6 months pregnant, 25 weeks, I believe the autopsy said. He decides, I'm going to go ahead with the plan and kill her anyway. I know they saw me in here. Doesn't matter. I'm going to do it anyway. And so they eat. Nigella and Keontae, they come, they talk, they interact. He invites them to stay. He invites them to stay. Why would you invite them to stay if it's your plan to kill her? So you can have witnesses? No. So they stay, they talk, he's shuffling Uno cards because the murderer who doesn't drink or do drugs plays Uno and then kills pregnant women on his downtime. And then they leave, and then they talk and they dance. They take selfies, and then the call comes. It's 9:29. The first call from Nigella. And the reason I wanted to lay this out this way was because there's been so much talk about this elaborate cleanup that he must have done. And I wanted you to see that there was no time for that. Because now we're in the during phase. And so 9:29, Nigella calls, and that call lasts 6 minutes, 9 seconds. That takes us to 9:35 and some change. And I think the interchange between that time and when he calls his father at 9:38 and 12 seconds is about 2 minutes. Now, mind you, Jade is having a medical emergency. All kind of things are going on. She's foaming at the mouth. She's shaking. She sounds like she's snoring. They tell him to get a towel, go wipe her mouth, put her on her side. He's trying to tend to her. But he's being punished for that. And if he wouldn't have tended to her, he would have been punished for that. But even still, as he is calling saying, or in the call at 9:29, when Nigeria says that she's saying, you put something in my drink. What did you put in my drink? Do you remember the text message that Nigeria sent as a result of hearing you put something in my drink? Are you talking to me? I want everybody to think about your best friend. And your best friend calls you on the phone. I want you to envision that. And you pick up the phone and you say hello. And they tell you, on the other phone you hear, you're stabbing me, you're shooting me, you're killing me.
And then you don't call 911.
Are you going to say, are you talking to me? You know they're not talking to you. You're going to say, what's wrong? What's going on over there? Do I need to come get you? Do I need to call 911? That's a natural response. But instead, you send a text saying, are you talking to me? Remember, nobody else heard exactly what was going on that phone call. Nobody, but Najee. So let's look at the facts surrounding that. As much as she says that this was the worst thing she's ever heard, her friend was in so much danger, so much distress. It was horrible. It was scary. She knew, because she just left there. She knew that he was in that apartment. She was in that apartment alone with the man who was trying to kill her, according to her. But she doesn't call 911. Instead, she calls Keontae, who only met Jade twice. And apparently he gets on the phone. They're talking. At least he says he could hear her trying to talk. So if she's trying to talk, Dr. Ola Sugar told you she has to be breathing in order to do that. Remember, Keontae actually said he did hear her voice. But even with that, as dire straits as Nigeria explains that it is, he goes out with his buddies anyway. Think about that. If it was as horrible and dangerous, why would this guy put his clothes on and go on out anyway? And then remember, Nigeria, immediately after hanging up, called Jade's mom and shares with her what she heard, what Jade said. And notwithstanding that, Jade's mom sends Blaise a text and says, oh, the baby's good, the heartbeat is okay. If it was as serious and people believed Nigeria or believed in the credibility of her, do you think that Jade's mother would text that man and tell him and give him an update about the baby? Are you going to text the man who's just been accused of killing your child and give them an update about the baby? Are you going to do that? There's something not right about it. But that's what happened. And so, right after that phone call, he calls his dad, on the phone with him for 30 seconds, because that's what he told the police officer, that he talked to his dad, and his dad said, call, son, hang up with me and call 911. What are you doing on the phone with me? He does that, and within 60, so if that call lasted 30 seconds, that takes us to 9:38 and 42 seconds. And at 9:38 and 58 seconds, Blaise is on the phone with 911, and you heard that call. You heard the desperation in his voice. He didn't know the address to give the man. You remember that interchange. So the only way to get the address would be to run to the front to get the address. And if you remember what he says, I want you guys to pay attention to this. He said the address is 1522-1550 Lebanon Pike. Most of the time when people give an address, it's only one numeric value. it makes sense that he ran to the front of the apartment or the condominium complex because that's the exact address he gave them. So then, after that, I went the wrong way. Then he gets off the phone with 911 and she calls back. So if it was 6 minutes and some odd, I'm sorry, the 911 call was almost 9 minutes. So that would take him right around to 9:47 and Nigeria calls back to Jade's phone. And he answers. He didn't have to answer. It was Jade's phone. He could have said, I was dealing with an emergency. But he picked up the phone and gave her an update. Doing the responsible thing. Then after that, that call lasted about 2 minutes, she says. That takes us to around 9:49. EMS arrives at 9:48. If you look at that slip from the EMS, because you'll have the right to look at the evidence, it's going to show you that EMS arrived about 9:48. And you heard him say, I can hear the sirens. I think I can hear the sirens. And then he goes out and runs to get them. Remember, on the call, the man says, put her on her side. So he did that. Then if you remember, as much as she didn't want to, she told you that Blaise ran out to meet them, at least at the door. So perhaps she rolled over while he was gone. We don't know. But nobody's calling 911 and doing all those things to help, only to put her on the side and try to kill her. So by now, EMS is there, so the time for cleanup is gone. Where was all this time for him to clean up? It's not there, because remember, those selfies was less than 60 seconds before the emergency call. The time just isn't there. So that's during. So when we think about during, there was only one person who called 911. Only one. As sick and as dangerous as it was described to be, only one person called 911. Frantic, running to get the address, doing everything that he could do. That's during. Now let's talk about after the investigation. Listen. What's unfair is 3 years later, Blaise is now held responsible to try to prove himself innocent, when one, that's not the law, and two, a lot of the evidence is gone. That's unfair. How can I prove my innocence when Detective Reese said he let the video surveillance camera get erased? How does the lead detective not get that surveillance camera that would have showed Blaise coming and going, Najee and Keontae coming and going? If he really ran to the sign, we would have seen that. If he came there with something in his hand, alcohol and or cocaine, perhaps we would have seen that on the video. If somebody else showed up there that day, perhaps we would have seen that. But they allowed it to get destroyed. Blaise didn't know that. Remember, he didn't get arrested for a year later. If he knew the burden was going to be shifted from what the law was, then maybe he would have done the investigation himself. But he was trusting the police to do the investigation, because that's their job. And we know that she met with the drug dealer that day, albeit it was for Mario or whoever it was for. If this is a drug overdose, I really want y'all to think about this. If this is a drug overdose, why wouldn't the police officer go talk to the drug dealer? If it was a financial crime, you chase the money. How in the world, in a drug crime, you don't bother to speak with the dude who sold her drugs that day, whoever it was for, whether she met up with him or not? That's not for us to have to figure out. But he didn't. So now you don't talk to key witnesses. And there were other drug dealers in her phone too. They didn't call any of them. You let the surveillance video get destroyed that possibly could have exonerated him. But we'll never know that. And now he will be punished for it. You let the cup that was supposedly the missing cup, the crime scene investigation team, they didn't see it. It was on the counter. Somehow we missed it. But all along, there was this missing cup that Blaise must have taken. Because he cleaned up. We already seen there wasn't time to clean up. And he had taken the cup with him. The whole time, Detective Reese had to tell you, we missed the cup. It was there the whole time. Well, perhaps if Blaise knew one day he would be sitting here facing felony murder charges, he'd have had the cup tested himself. But he can't do that now. And he shouldn't have to do that now. Because that's not the law. That was their job. And if it was cocaine in it, they would have known it. But they did take a bunch of glasses. They took all kinds of things from out of their dishwise. And there wasn't anything on it. Anything. And think about this. Remember how they talked about all this cocaine? One thing they cannot get away from is that she had cocaethylene in her system. They can't get as much as they would love to. They told you first it was coming from vanilla extract. Don't do that. Don't believe that. Or two, because of some of the treatment she got at Vanderbilt. There is no treatment at Vanderbilt that leaves you with cocaethylene in your system when cocaine and alcohol come together. That means, think about this, that means that he would have had to put cocaine and alcohol in either her water or her lemonade. And the chefs have sensitive palates. They taste food. That's what they do. They'll taste something and they'll tell you what ingredient is in it because they're trained that way. She didn't taste alcohol or cocaine. Neither one of them. And the amount that they're saying that he gave her. Does that make sense? How do you do that? How do you put that much cocaine in somebody's drink and alcohol? And they come out saying it tastes funny. It's going to taste a whole lot worse than just funny. You're not going to keep drinking it. And according to the state, it was so much that it caused this overdose. So she kept drinking cocaine and alcohol, the chef, and never, ever noticed it? No. So then we go to the fact that first, Lauren Weber went to the scene. Now remember, police are all through that hospital now because they get to the hospital at 10:12. That's going to be on your sheet.
Oh no, no, feed. Why are you doing
Remember,
that?
12. That's going to be on your sheet. Remember, 5. So that's over an hour or so later. You got Officer Fish, Officer Pfeiffer, Detective Martin. You have all these officers who are now interviewing Najee, interviewing Blaise. And Najee knew it, and I guarantee you, Ms. Burks knew it, Ms. Franklin knew it, and Lauren Weber knew it. And we know they knew it because Officer Fish told you that Miss Burks was on the phone when she was talking to Miss Brown. And she said that they told them the detectives are coming that night. But Lauren Weber remembers the significant other of Mario, the one who asked her to go get drugs.
Mario Gutierrez.
The first person in there is Lauren Weber. And she said, don't get lost on it. She said, all I did, I didn't touch anything. I grabbed the keys, blew out a candle, and left. But Officer Reese told you that she said she removed belongings too. And that she looked all throughout it. You can't do both. One of them is not true. Either you went in and grabbed keys and just left, or you went in there and grabbed belongings and looked all throughout it. And if you did that, why lie about it? Just say what it is. Unless you had something to hide. Or unless you went to get something. Then notwithstanding that, now you have detectives on the scene. And Officer Fish told you that she told Miss Burks and Miss Browning, this scene is on lock. Nobody in, nobody out. But the truth is, nobody should have had to tell you that. Because if he did it and you think he did it, you want to leave that scene just the way it is. Because he may have made a mistake. And I want those officers to be able to catch that mistake. I don't want to touch it. Jade doesn't need to go back there that night. She's in the hospital. We're going to lock this thing down because we're going to catch him. I know he would have made a mistake. They went in there and they removed evidence. And they manipulated evidence by moving it from here to here. Why would you do that? And they said, oh, well, the officer gave us permission. And then you remember Detective Martin getting on the stand? And then he said, oh, I may have given them permission. And Mr. Joyner said, well, didn't you send me an email yesterday saying that you didn't? What changed? Oh, well, this morning when I got here, things changed. Okay. Don't allow that to happen. That's not right. Because what detective would tell a woman and 3 young girls, y'all go do the investigating for me, let me know when you're done and what you come up with? That doesn't happen. That doesn't happen. And then you had the only other eyewitness, the only other person in that house. He should be just as important as Nigel.
All right, Ms. Hollins, you need to be wrapping up your argument.
And Detective Reese, yes, sir. Detective Reese said, I like to bring people in to talk. But I didn't bother to have Keontae come down. I just called him on the phone. And Keontae wouldn't tell you the truth about his theft conviction. And he told you, because he didn't talk to anybody there that night, even though he went there. Why not? He said they didn't have security. There it is right there. Why didn't he talk? I don't have a lot of time left, so I'm going to go through it quickly.
You don't have any time left.
May I have 5 minutes? Yes, sir.
You got 1 minute.
I've given you the investigation. That's the towel he took. I got 60 seconds. I'm going to do my best. That's the towel he took. That's where he got it from. If he was cleaning up, he would have fixed those towels. But he didn't. That's the surveillance video. That's that missing cup. It was sitting there the entire time. No one in, no one out. That's the V8 bottle. It wasn't in there. You see the lemonade, you don't see the V8. And on those other pictures, you don't see it either. So, that's the communication log. Cocaethylene is in the system. You're going to have the reports. It's there, and it was there in the vomit. And all of these doctors told you that. And the autopsy report at the end of the day, don't forget what I've shared with you. At the end of the day, even the medical examiner can't come to a conclusion. And with all these surrounding circumstances, how can you? Now, I told you that when you get back there, you're going to be tired and it's going to be long. And you promised me that you would not let anyone change your convictions of what you believe, no matter how long it takes. Because you said if they can't make a decision in the most important affairs of your life, that you wouldn't let them do it for Blaise. I thank you so much for your patience and for being here. And the Taylor family does as well. I won't get back up here and make another argument because we don't have the burden, they do. So when you get back there, you make the argument for me. Thank you.
All right, any rebuttal argument on behalf of the state?
Yes, Your Honor. Ms. Hollins went back and forth between whether or not Blaise Taylor even thought he was the father of this child. She said that Nigella Jackson said she wasn't sure. You heard the testimony. I submit to you that Nigella said she was sure, it's just he wasn't involved. And she was saying that at the hospital because he was telling the people at the hospital that he loved Jade more than her. And she was, that was not true. That's what she testified to about whether or not he was the father. She told all of the officers, he's just the father. He's not involved. But Ms. Hollins argued to you that he wasn't the father, but then she also wants you to consider a text message where Jade is telling her mom that he signed up for a diaper service. You can't have it both ways. Also, Blaise Taylor told people he was the father of her baby. He told Keontae, Nigella, the people at Vanderbilt. He told the police officers. Now, when he calls 911, he's with a friend. But when the police come, that is his girlfriend. He is absolutely committed. And the text messages with Xavier Winford absolutely were not submitted for any purpose of saying somehow Mr. Taylor was a bad person because he was seeing more than one woman. It was for that very purpose. He had someone that he loved, that he was telling, I love you. But also the rest of that thread is that something's happening, but everything's going to work out for them. But it's very much against what he told the police that Jade Benning was his girlfriend. His interactions with her, it wasn't I love you. She also wasn't going to admit he's the father of the child, but yet wants to say that they picked out the baby's name together. Well, Nigella Jackson testified about that, and she was very specific that that was a name that Jade suggested, and he agreed. He didn't disagree with it. But you also heard testimony that Jade's unborn baby girl's name is Ivy. She, just to clarify, I don't know where the Lauren Weber Mario connection came from. I submit to you that the evidence that you heard was that Mario texted Jade Jade texted Danny. Danny wasn't in town. No one met up. Lauren Weber was not involved in that. Lauren Weber went to the apartment, and her testimony was that it seemed too clean. And she told the officers that. That was the first thing she said to them. She went in, and it was so weird to her that she took 2 pictures and she locked the apartment. I submit whatever happened within the police department for officers to not go there that night and seize that scene, absolutely. That is a mistake. That should have happened, and it did not happen. But it doesn't change anything. Thank God for Jade's family and friends that they were not happy because nothing was happening and it needed to happen. And they took care of it. There was nothing that was disturbed. Now, Mr. Taylor in the cleanup, he did not put the camera back. And they put the camera back where it would be, where it would face the door, not knowing if he could come back in because the police aren't there. Ms. Hollins also argued that somehow if he wanted to kill the baby, that he wouldn't be wanting updates from Jade's mom. Jade's mom's updating him because nobody knows yet about the cocaine. That first drug screen in the hospital, it was negative. Nobody knows what's happened. She referenced the cause of death with Dr. Carney, not the cause of death, the manner of death with Dr. Carney. And she put the report up, and it very clearly states that there's a suspicion for homicide because it's possible that she ingested the cocaine without her knowledge. Someone gave it to her. But Dr. Carney's determination has nothing to do with yours. Your determination is reviewing all of the evidence to determine what proof beyond a reasonable doubt. If she determined it was a homicide, you could not consider her determination for your decision. That is for the death certificate. Ms. Holland's arguments to you about Blaise Taylor. We wish we had the surveillance video. Yes, it would be much better if we had the surveillance video, but not to exculpate him. It would show him going in and out. How long was he out there before he went back inside on 911? How many times did he go out there? It would show Jade Benning pulseless the way he saw her being carried out by the EMTs. There is nothing about that that undoes the proof in this case. She argued that a chef would know that there was something in a drink. Jade Benning absolutely said, I knew there was something in my drink because I tasted it. Those are the facts. Ms. Holland's entire argument is asking you to ignore the testimony that again was unimpeached by Nigella Jackson, that Jade Benning said all of these things. She said them to him. It's only the two of them in the apartment. He says it's only the two of them. He says Jade was talking to me. Her arguments to you are asking you to not only ignore everything that Jade Benning said, but it's to ignore that if for some reason it was true and Jade Benning ingested the cocaine herself to kill herself and her baby, and then called her best friend and said these things to Blaise Taylor, Blaise Taylor never tells anyone what she said. He doesn't, when he sees Nigella, say, oh my God, what happened? She said these things. I didn't do anything. We have to figure out what's going on. That is absolutely not true. He didn't tell anyone what Jade said. And when Detective Smith asked him if Nigella would have any reason to make up these accusations, he didn't even say she was making it up. He said, I think she's just in shock, and I was the last one with Jade. There is no explanation because Jade Benning said these things. It is the proof and evidence in this case. Jade Benning named her murderer and the murderer of her baby, and she told you why. The state does not have to prove the why, but Jade Benning told you why. And I submit to you that the evidence in this case is proof beyond a reasonable doubt that Blaise Taylor is guilty of all 4 counts of the indictment. Thank you.
Did anyone do like a deep explanation? I know we're going to have jury instructions, but typically you'll see the parties give their explanation for what these charges mean and what it requires to get there and why you should find them guilty and find that all elements are met. Did either of them distinguish the difference between the felony and the murder 1? I remember the prosecutor said, like, hey, counts 2 and 4 relate to the unborn baby, and you can infer that counts 1 and 3 are about Jade herself. But did we have, like, if you find that maybe he only did this to try to cause an abortion and his intent wasn't to kill Jade, then this is what you should be looking at. That's very odd to me. Very odd to me. So, I mean, maybe the instructions as read by the judge will come off as easy enough to understand, but I don't know. I mean, I thought she had more time, honestly. She could have gone longer. All right, so I'm going to get the final poll up. So, well, first we'll do, did the state meet their burden, right? Different question. Then we'll do the how would you vote? And then we'll do jury predictions once instructions are over.
Members of the jury, count 1 and 2 of the indictment in this case charge the defendant Blaise Taylor with the offense of first-degree premeditated murder. This offense embraces the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. Counts 3 and 4 of the indictment in this case charge the defendant Blaise Taylor with the offense of first-degree murder during the commission of a felony. This offense embraces the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. The indictment of this case is a formal written accusation charging the defendant with these crimes. It is not evidence against the defendant and does not create any inference of guilt. To this indictment, the defendant has entered a plea of not guilty. The evidence and arguments in this case have been completed, and it's my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I've ruled upon the admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, nor any other remarks which I've made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume that the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court. Such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Sometimes in the trial of a criminal case, when a defendant is charged with a crime or crimes, this crime or crimes include lesser included offenses. The law permits the jury to find the accused guilty of the lesser included offense, which is included in the crime charged in the indictment, whenever a course of conduct is consistent with the facts found by the jury from the evidence in the case and when the law is given in the instructions of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The court will now instruct you as to the law applicable to all counts of the indictment. First, it will set forth the laws applicable to the crimes charged in the indictment. Finally, it will describe for you the deliberation process. Counts 1 and 2, first-degree premeditated murder. Any person who commits the first-degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and that the defendant acted knowingly. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of intentionally and knowingly which apply to this offense have been previously explained to you in these instructions on page 6, and you should refer to those definitions as they apply to this instruction. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim as to count 1, Jade Benning, as to count 2, the unborn female child of Jade Benning, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of.
Why is this the second time with the feed? The captions are still going.
Such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Counts 3 and 4, first-degree murder during the commission of a felony. Any person who commits first-degree murder during the commission of a felony is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate an alleged first-degree premeditated murder. That is, that the killing was closely connected to the alleged first-degree premeditated murder and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged first-degree premeditated murder. For the defendant to have been found guilty of first-degree premeditated murder, the state would have had to prove beyond a reasonable doubt the essential elements of first-degree premeditated murder, which have been previously set out on page 5 of these instructions, and you should refer to those instructions as they apply to this offense. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged first-degree murder. The killing may precede, coincide with, or follow the first-degree premeditated murder and still be considered as occurring in the perpetration of the first-degree murder, so long as there is a connection in time, place, and continuity of action. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant unlawfully killed the alleged victim as to count 1. As to count 3, Jade Benning, and as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted knowingly. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established that if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. The definitions of intentionally and knowingly which apply to this offense have been previously explained to you in these instructions on page 6, and you should refer to those definitions as they apply to this instruction. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted recklessly. The definition of recklessly has been previously defined to you in these instructions, and you should refer to that definition as it applies to this instruction. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim as to count 3, Jade Benning, as to count 4, the unborn female child of Jade Benning, and 2, that the defendant acted with criminal negligence. The definition of criminal negligence has been previously defined to you in these instructions, and you should refer to that definition as it applies to this instruction. When you begin your deliberations on the indictment, you must first deliberate on the indicted or charged offense. If you find the defendant guilty of the indicted offense, you may stop your deliberations as to the remaining charges within that count of the indictment. If you find the defendant not guilty of the indicted offense or you have a reasonable doubt, then you must find the defendant not guilty of the indicted offense and next consider the lesser included offenses as set out in your verdict form. You must first deliberate on the greater offense and reach a verdict as to the greater offense before you move on to the next lesser included offense. If you reach a verdict as to the guilt of the defendant as to a greater offense, you may stop your deliberations as to that specific count. If you find from the proof beyond a reasonable doubt that the defendant is guilty of murder in the first degree as to counts 1, 2, 3, or 4, then it shall be your duty after a separate sentencing hearing to determine whether the defendant will be sentenced to life imprisonment without the possibility of parole or life in prison, but you will not consider punishment for this offense at this time. I noticed that some of the jurors appear to be making notes during the trial of this case. Please bear in mind that these are your notes and for your use alone. The taking of notes is simply an aid to memory, and the jury must understand that they are to recall the testimony and to use the notes only as an aid to memory. And any juror who takes notes will use those notes only for that juror's assistance in that regard and not as an authoritative thing to show others. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. The court charges you that if you are satisfied from the whole proof in the case beyond a reasonable doubt that the defendant, Blaise Taylor, committed the crime charged against him, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crime charged, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof or you have a reasonable doubt as to whether he has been identified from the whole body of proof in this case, then you should return a verdict of not guilty. During the trial, you heard expert testimony of Dr. Michael Olashoga and Dr. Kelly Larkin, who is described to us as an expert in the field of emergency room medicine, Detective Tom Miller, who is described to us as an expert in the field of digital forensics, Dr. Aaron Carney, who is described to us as an expert in the field of forensic pathology, Dr. Carrie Midton, who is described to us as an expert in the field of forensic toxicology, Eric Devlin, who is described to us as an expert in the field of digital forensics, Nicole Dowell, who is described to us as an expert in the field of forensic science drug identification, Dr. Alex Krotulski, who is described to us as an expert in the field of forensic pathology, Dr. Melissa Geiger, who was described to us as an expert of the field of forensic toxicology, and Dr. Janice Lindsay, who was described to us as an expert in the field of forensic toxicology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You're to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Direct evidence is defined as evidence which proves the existence of the fact in issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. It is evidence that proves one or more facts from which you find or infer the existence of some other fact or facts. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. An inference is a reasoned, logical decision to find that a disputed fact exists on the basis of another fact. You should consider all the evidence that is presented in this trial direct and circumstantial. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. You are the exclusive judges of the credibility of the witnesses and the weight to be given their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness has sworn falsely. For the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any, are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved in the trial. If from the evidence presented you find that a witness has been convicted of a prior crime, you can consider such only for the purpose of its effect, if any, on his credibility as a witness. The defendant has not taken the stand to testify as a witness, but you should place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Tape recordings were allowed in evidence, and you were provided with a document purporting to be a transcript of the audio tape. This document was provided to you to assist in your listening to the audio. If from your listening to the tape you find discrepancies or inaccuracies between the transcript and the tape itself, you should rely upon your understanding of the tape and disregard those portions of the transcript you find to be inaccurate. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Davidson County, and that it was committed before the finding and return of the indictment in this case. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report that you find the defendant guilty and name the offense according to your previous instructions. On the other hand, if you find that the state has not proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt, then you must find the defendant not guilty. In that event, your foreperson will report that you find the defendant not guilty. You will be provided with a form for all possible verdicts in this case. For each count, the jury will check the appropriate verdict on the form, and your foreperson will sign the verdict form. The verdict form which you'll receive reads as follows. Verdict form. We, the jury, find the defendant Blaise Taylor, count 1, first-degree premeditated murder, and count 1 and 2, the verdict forms are the same. Choose 1. Guilty of first-degree premeditated murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. Count 3 and 4, the verdict forms are the same and read as follows. Count 3 and 4, first-degree felony murder during the commission of a felony. Choose 1. Guilty of first-degree felony murder during the commission of a felony, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of reckless homicide, or guilty of criminally negligent homicide, or not guilty. there's a signature line for the foreperson and a line for the date. When you retire to the jury room, you will first select one of your members as a foreperson who will preside over your deliberations. When you have reached a verdict, you will return to this courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them and have attempted to read this charge so as to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the indictment in this case is herewith handed to you together with the charge and the exhibits in this case. You may now retire and consider your verdict. And let me swear in the court officer. Do you solemnly swear or affirm that you will keep this jury committed to your charge, keep them separate and apart from all citizens, allow no one to communicate with them or communicate with them yourselves on the subject of the trial?
I do.
All right, let the lawyer step up just a moment.
Or was there like a mistake or something? Or maybe he's giving them a chance to review it. Because he did, like, I saw him with his pen. He, like, paused in his words twice and wrote something down. So maybe he's got to approve, like, a typo correction. Probably important to do. And then we're going to try to break down what all of this means.
Regular jurors, if our four alternates, I'll speak to you in just a moment, can stand right there against the wall there. The other 12 of you, if you'll step down the hall, we'll get these items to you. All right, the alternates, obviously the court never knows whether we'll need someone to substitute into the deliberation process or not. Would have expected a week ago, Monday last week, that we probably would, but we didn't. So I appreciate your service. You'll be discharged from this case. We'll shred your notes for you, and you can step out with the court officer. All right, we'll be in recess.
All right, so I had a little bit prepared, but I didn't know we were going to have all these lessers. So I was sitting over here trying to take in what he's saying, and we'll watch them walk out before I show you this. And I'll finish panic scrambling to add in like this voluntary manslaughter, criminally reckless homicide, and all of that. That way we can go through that and how a jury, although I don't see that it would make sense as a matter of what's on the record here, would be able to decide on the lessers that are going back. This is voluntary. And honestly, like, them including these lessers makes me feel like, unless they all go back there and go, yo, this was completely intentional, top charges, we all agree, let's review some stuff. These lessers make it time consuming just to go through the paperwork. All right, so verdict watch is starting at 12:42 p.m. Eastern. Save this timestamp. And so I've got a lot for us to go through here, guys. We're going to go through these counts and the lessers and the required elements for each. But before we do that, let's thank the individuals who are sponsoring that. We're going to say you guys are sponsoring this crazy matrix we're going to go through. Huge thank you. I try not to interrupt when we're in closing arguments because it's important to hear. And then with jury instructions, more than ever, this is not a case where, like when I open the docket, I can't see a place to download files. So there was no way ahead of time that I could go get a copy of a sample verdict form. Or, sometimes when the parties are arguing instructions, we can at least see based on their request to the judge to include or not include something, the standard language that will be left alone versus what they're hoping to include or not include. There was none of that available on the public records for this case. So had to create something that we can work off of. And that's why I was listening very intently to the instructions being read, because that's kind of our only access to them at this point. Maybe they'll get published later on, but who knows. So with that being said, there has been a ton of generosity in the chat, starting all the way back at the beginning with Patty Cakes becoming a member, supporting the channel, supporting the Matrix. We had Kelly Bree say, hey, Kat in chat, what is everyone's guess on how long the jury will deliberate? And like I just said, I think we're going to have a longer deliberation just because I think the paperwork going back is pretty thick based on all of these lessers being included. The main counts again, and before you guys participate in this question in the chat, remember that the top level counts here are count 1 and 2 are both first degree premeditated murder. And it's going to have all the lesser included underneath that. But the first count relates to Jade. The second count relates to the unborn baby. Count 3 and 4 are first degree felony murders. And now this jury instruction, the way it was read, my understanding now is that the way this was indicted, these felony murder charges relate to, felony murder could be, hey, you attempted to assault and batter somebody, whatever. And in that process, even though you only meant to get in this fist fight with them, you didn't intend to end their life. You didn't plan for them to die. They ended up dying. And the cause of that was the underlying assault, which is a felony. Here, the felony they're charging, it's more clear now with the jury instructions. It wasn't something more specific or granular like intent to cause a criminal abortion or intent to poison. It was specifically the felony murder of Jade Tristan Benning was caused by the underlying attempt or successful commitment of an underlying murder attempt against baby Ivy. Same with count 4, felony first degree murder for Jade's unborn baby. If you find that that was caused through the attempt to kill Jade or any of the other lesser includeds to unalive Jade, whether an attempt or successful, right? So it's like a weird matchmaking thing going on there. That's how those counts work. So as you make that consideration for Kelly's question here, and you now know that each of these counts will include all of the possible lessers that Tennessee code allows. Second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide, all of those things. Maybe that'll impact how you answer Kelly's question versus how it could have been answered earlier. So, oh my goodness. Let's see. And again, right on the side of the screen there, you guys can see your predictions coming in. So great question, Kelly. Sorry to get to it late, but I think it's actually better we got to it late. KP very early on came in here late, was like, hey, I'm 10 minutes behind. I got a 1.5 speed. I'm not missing this. And then you eventually caught up. So glad you caught up with us. I think you were caught up when you said, wait, so Najee had to have known that the camera was in the room, right? Remember her testimony was, her camera was always in the kitchen. Camera was always in the kitchen. She always kept it there. I know Jade. That's my best friend. I know everything about her. And in this new apartment, she always kept that camera in the kitchen. And the state pointed, I don't know if they brought it up in closing so strongly, but they did ask more than one witness, like, do you see this picture? And it's a picture that Jade was taking, just cute pictures of herself, days before the incident. And you could see the blink camera near the stove. right? So there's at least one picture showing that that camera was in the kitchen the same time Jade was taking pictures of herself through her phone. So that is one thing that can go to corroborate what NJ's saying. But then I'm convinced she put the camera in the room and moved it back to cover her tracks. How the hell would he be able to get the camera in there? I mean, I don't know. And he would have had to have moved it when he got there. So either he could have moved it way before, but remember he was out of town for a week. And they go to a Waffle House on the 24th after he gets back. But they don't, I think the testimony was something like Jade asked him either about wanting to come over or seeing if he wanted to go over to her place. But the testimony was that that text message was unanswered. So like no plans actually get together. Nobody goes to Jade's apartment that we know. Blaise doesn't go to Jade's apartment on the 24th. He's out of town for the week prior. And the Blink camera was offline. It went offline for some time on February 22nd. So that would suggest that either the camera was moved around or before the 22nd possibly, or by somebody that wasn't Blaise, or it was moved by the time Blaise arrived on the 25th and before like Nigeria and the group would have gone there on the 26th. Because I don't remember Lauren, I'm not sure if Lauren gave us testimony that she remembered seeing the Blink camera on the windowsill. That I don't remember. I'm not saying she didn't. I'm just saying I don't recall it, and I don't think I have anything in my notes about it. But it's a good question because then you have this motion detected activity at 7:08 p.m. and 7:11 p.m. on that Blink camera on February 26th, which would be consistent with the time that the group of girls was over there with Miss Stephanie, and Nigeria says she moves the camera from the bedroom to the kitchen. So, and I don't know why a 3-minute gap, but who knows. And then ultimately they say that the camera wasn't, even though Miss Stephanie was able to look at Miss Burks was able to look at the live feed the morning of the 6th. Remember, she said she couldn't rewind. So by the time she gets Jade's phone early in the morning of the 26th, she's able to look at like a live feed of the camera. But they never subpoenaed Blink to try to get any backlogged storage. And nobody was looking or videotaping whatever happened, even though Nigeria testified that when they shook out this this comforter, somebody was videotaping that. She said she didn't remember who, but somebody was. And I don't remember any video being introduced showing what was going on in the bedroom. So maybe there's a video out there that didn't come in that shows like the camera's still sitting there while they're shaking out this comforter. Who knows? Who knows? But we have that motion detection at 7:08 and 7:11, and that's really it. That's all we've got in the record. So great food for thought, something that both sides can argue in different ways. To me, I don't think an argument beyond a reasonable doubt comes of that. But thank you for the super. Iceman coming. Thanks for becoming green. Thank you for becoming a member. And then we had this mountain of very, very generous gifting. So Sheriff Chuck starting off the party. He's back to the sheriff picture. He was just the Ninja Chuck Norris for a few days there. Thank you for the 5 gifted. You guys already know the drill. I saw some party chucks in there already going on. We had Moses Dupree with the Holy Moly 20 gifted memberships. So big, big thank you to Moses. Moses has been hanging out quite a lot with us for this trial. Also had some great insights when we looked at the Terry and Arnold bond hearing. If you guys want to see some good arguments, I enjoyed that bond hearing. I'm sure Moses would recommend it. If you missed it because you've been following this trial and too busy, but you need something to do this weekend, I think it was a good bond hearing to watch. So highly recommended. Moses, thank you so much for the 20 gifted. Moses also says with the comment here, you can't convince me that at some time Jade and NJ didn't party. Drugs were taken. In parentheses, we have coke, fentanyl, alcohol, resulting in Jade's death. To deflect blame and responsibility, NJ made up what was said to blame Blaise. Or like sprinkled a little truth with a lie could be an option too. Maybe some of the things that were being said were accurate, but some of the rest was misinterpreted, misheard, sprinkled in. I think all of it's an option. I actually think it's entirely possible that Jade could have that Nigeria could have actively heard, accurately, correctly, honestly heard what she says she heard, And that was just Jade's perception. But Jade's perception and her excited utterance at the time, if correctly recited by NJ, doesn't mean that that's an accurate reflection of what was actually happening. You know, if somebody didn't intend, like, imagine this was a fentanyl exposure from a counterfeit pill. I wouldn't think that most people would understand what's happening to them if they're having something consistent with a fentanyl overdose, if they've never experienced that and do not believe that what they were ingesting was containing fentanyl or otherwise contaminated. Right? So she might be, say, her state of mind might genuinely be making those accusations. So, but I agree. I think something that defies common sense for me, and it's something that I thought about because of the state's arguments, is why doesn't Najea call 911? If she really heard that her friend was in danger and her friend is currently with the person who put her in danger and is panicking, she's having a health crisis and she's with someone that's dangerous. You need medics, you need treatment, and you need police. And you don't call 911. And in fact, your explanation for that is that you trusted Blaise to call 911. And then 12 minutes after you hang up on that 6-minute and 9-second call, you're calling back with Keontae on the line, who can't hear, says he heard Jade's voice, but couldn't make out words. You know, I can't wrap my head around that. It makes me feel like what we're hearing. I don't think Jade's recitation of that phone call, that 6-minute phone call, is accurate. I don't want to say dishonest. Maybe she's misinterpreting something. It could go either way. But I just cannot get my head around why you would not call 911 for the health reasons or for the fact that you claim you heard your friend being harmed by the only other individual she's in an apartment with currently. So that's very difficult for me. And it's very compelling to me personally. So big thank you for the food for thought here. Big thank you to Moses again for these generous 20 gifteds. Hannah says her rebuttal was weak. Okay, so this must be talking about the state because it's rebuttal. And reminder, guys, the state in Tennessee, and a lot of states, like almost every state, I feel like, state has the burden. So a lot of states, or commonwealths, the prosecution, they can do an opening closing argument, and then they get a rebuttal closing argument that follows the defense's argument. And really, the rebuttal is supposed to be constrained to what's discussed in the defense's argument. Doesn't always play out that way. And I really might be wrong. I swear the judge is like, I'm just curious how long you guys think your closings are going to be. How much time total? I'm not going to hold you to a limit, but I want to know the estimates. And then we have like 1 hour, whatever. And then today he's like 1 hour is the hard limit. So I don't know. Maybe something changed after they decided to not do jury instructions yesterday. That way the deliberation time would be longer before we have this 4th of July holiday weekend. Because again, my expectation is that court would be closed on Friday in observance of the 4th of July, which is Saturday. So, yeah. So Hannah says her rebuttal was weak. That's why we have a rebuttal from the state. They have the burden. It was only her and Blaise in the apartment, brushing aside NJ and Key coming by. If she had conviction in her case, she'd argue evidence that she didn't. Yeah, and I was honestly completely surprised that her rebuttal was short. She had more time that she could have used. So my prediction would have been off. I thought maybe not as long as her opening, but I thought it'd be longer than it was. So, and she could have gotten into some other points and then she didn't. So my prediction would have been totally wrong. So I'm not sure I stated one out loud, but that's what I thought in my head, and I was wrong. Peter here with the 10 gifted. Let's get some booms in the chat. A big thank you to Peter Ortiz coming in here, holding it down loud and proud for Team Guilty. And I think very excited to have Peter in the chat as we go through these matrices. And he can tell us, like, nope, I'm sticking with the top level only. Not going to go for any of these lesser includeds. And see why or why not that is. That's my prediction there. Big thank you. 10 gifts is super generous. Bittersweets says, thank God I'm not on trial. Some of these people scare me. Where's the evidence? I'll say it's weird. Neither side got into the lab work. And I was sitting here during the state's rebuttal in the beginning of instructions, like, man, as soon as these instructions are done, I'm going to start hanging out with the chat. I'm going to start griping about, hey, I wanted to see this lab work, these tests, all of that. And then I'm like, but neither side really got into it. And I don't think that's just explainable by the judge saying, like, defense, you're out of time. No, you cannot have 5 more minutes. It makes me wonder if, and again, we're in Tennessee. It's Davidson County. It is Nashville area. But the arguments, it seems to me that however this jury was impaneled, values, morality, maybe even religion, I wonder if these attorneys from both sides, the state and the defense, have a read because they got to do voir dire with this jury. We didn't get to see any of that. But I wonder if they both have a read on this jury that, hey, things like abortion, things like drug usage, heavily judgmental. We watched a case out of South Carolina in Horry County with Megan Jackson. It was famously called like the coroner body transporter love affair or something. And a critical element of that case was infidelity. And this idea that we might be in a quote unquote Bible thumping area. So is the defense going to lean into things like you cheated on your wife, so you're not a reliable witness? Is this jury more inclined to make that inference, make that conclusion because of their beliefs, their cross section of this community? And based on the way the state and the defense approached their closings, it's really making me curious if that's their read of this jury. So, yeah, and the Megan Jackson was a time. That trial was certainly a time. So, oh my goodness. But yeah, so I don't know if you guys got that impression or that curiosity. Personally, me, myself, and I, speaking only for myself, I really like to look at expert testimony. I like to see what both sides are saying. I like to see how both parties handle the witnesses that are presented by both sides. And I think the lab work goes to a critical question that's in dispute here. But I wonder if the parties just decided, look, maybe the jury was glossing over that stuff. That doesn't seem to be the most engaging thing to them. Or maybe it's just what we don't want to focus our closing arguments on. Maybe we purely didn't manage our closing argument time for the defense to get to those arguments. Because it even seemed like flicking through the slides, we were going to hear more about the cocaethylene, which goes to the consumption of alcohol, rather than rehashing everything about the extrapolation and what I think, to me, is the most critical evidentiary dispute. Was this even an extraordinary amount of cocaine? And was it only cocaine that was ingested by Jade Benning? And didn't seem to be a focus of the closings, which is very surprising to me. But I can't see the jury. I didn't impanel the jury. I didn't question the jury. So this hashtag here from Bittersweets, it says, where's the evidence? Based on the arguments from both sides, I feel like it's going to a values. And if you think that Jade may have been doing drugs, maybe you'd be more swayed to believe that this could have been an accident rather than using the lab work to get you there. So I don't know. Then we've got, very generously again, Sheriff Chuck with another 5 gifted. Big thanks. Super, super thanks. Get the party chucks going again, chat. And then check in what the chat thinks. No, I don't know if we'll have a verdict today, although it kind of depends on if the court will let them stay late, and they've stayed late on certain days, you know? So they could stay late to deliberate, I would imagine. This, to me, I don't get the impression that this is the type of courthouse that's just like, it's 5 o'clock, everybody gotta go. Everybody gotta go. And then another 5 gifted. Holy moly, Sheriff Chuck. Super generous as always, super supportive. Again, bringing you the Matrix. Yeah, Sarah says, I think the defense ran out of time. And I'll tell you what, I never want to hear the word cocaethylene again. Never want to hear it. Just if we start a trial, guys, and the attorney in openings is like, and you're gonna look at cocaethylene levels, we gotta go. We gotta abandon that trial. I don't know if I can do it again. Oh my goodness. Let's see. Hannah says, drooling while napping at work, listening to him. Yeah, I mean, those lessers made that a much longer set of jury instructions. Absolutely made it a longer set of jury instructions. Um, and I don't know. We'll see. We'll see if we get any questions about the jury instructions. But that's like reading tea leaves. The Stefan Diggs trial that happened recently, that jury question was just, it seemed like out of thin air. And then they come back with an acquittal. Like, I don't know if they just needed to clarify one last thing or what that question was. It just felt like a curveball. But it didn't seem to match the verdict that they came out with like minutes after that. So, I don't know. Even if they have a question about jury instructions, sometimes it doesn't really tell you much. It's just speculative. Also, Peter Ortiz with the super sticker here. Big thank you to Peter. Kiana never wants a forensic toxicologist again. That's going to be hard to avoid. They come up in a lot of trials, I feel like. Yep, and Freedom Ring, I think this is a correct assessment. And while the state is saying that it wasn't an issue of like stability of the sample, integrity of the sample, right? That's in dispute by both parties. I don't really think the defense focused so much on saying that the testing, the measurement by the instrumentation, we did go through the questions like, what's your process? How do you do this assay? What is your procedure at NMS? But it wasn't really the focus. It wasn't like we're going to challenge the instrumentation that you did. It was really focused on this is the method you're using to do this extrapolation, calculating what you would guess could be something. And then the sample you're using for that extrapolation, the integrity was compromised. So it was really a battle of the sample's good, the sample's not good. And the extrapolation was done following the correct formula, whereas that wasn't the correct way to do such an extrapolation. So, and that goes to the claim that really came from the testimony, the questions of the state, and not anybody's testimony. But the prosecutor said, we know that 3 experts concluded that this was like a oral or liquid ingestion. And to me, that was not the testimony by Carney, by Katralski, or Midden. Even if you take the defense witness off the table, pretend they never testified, that still wasn't the testimony of the 3 witnesses. So to me, it's not even a correct assessment for the prosecutor to insist that we know that it's certainty that the 3 experts the state called made that determination. Absolute certainty. And I think that was a wholly improper remark that she made, quite frankly. But yeah, the issues in dispute are the extrapolation and the sample integrity. See. Yeah, Lance is saying the police messed it up. I mean, one of the things that I really hope would be great with a high profile trial is this scrutiny, like the things that are like, why wouldn't you collect the cups? Like, hopefully that knocks some sense into people's heads where that becomes the baseline, that becomes the bare minimum, that becomes the, hey, you know what we think? We're already going into this thinking that somebody drank something poisonous. Maybe we should look for literally anything that somebody might have had a drink out of. And maybe we should swab the surfaces where you would expect that somebody prepared a drink. So the kitchen island, the kitchen counters. I mean, maybe you're not going to go into the bathroom and swab whatever if you're suspecting that somebody poured things into a drink. But we didn't swab to find if there was any residual cocaine. We just assumed that the apartment had been thoroughly cleaned. And I thought it was a very strong argument from the defense to point out not just the timeline of this all occurring, but the timeline in relation to the claim that he must have cleaned up. Because remember, like, there was testimony and lines of questioning that seemed like, hey, this yellow rag must have been to clean, even though it was left there. So if he's going outside to throw things away, why didn't he also throw away this yellow rag? It's like the arguments, you could take one fact, you can argue it this way, then you can argue against that argument, and then you can argue it back. And that's what makes trials interesting. OG says, I don't see guilty on premeditated. Well, I'm excited to talk about this part because to me, the way I see it, because the state's theory is this intentional poisoning, where Blaise brings this whatever concentration of cocaine that he gets by whatever means, and he puts it in this drink at some point in the night. To me, I don't get how that could ever be a like heat of passion, because the only way that'd be possible is if he happened to be carrying this amount of cocaine on him. And there's really nothing on the record to support that. Oh, I'm suddenly like provoked right now. So I'm just going to decide right now, this was not my intent. It wasn't like planned out first degree style, but Jade just did something or like the unborn baby did something to like really suddenly provoke me, and I wasn't in the same state of mind, and I just happened to have this lethal dose of cocaine. Like, they're not saying that there was another mechanism that he undertook to cause these deaths, right? The only mechanism that's in play here for the state is this cocaine going into a drink that was then ingested unknowingly by Jade Benning. So I actually think it'd be problematic, and we'll talk about it as we go through the Matrix stuff, if the jury like compromises, like not all 12 want to vote guilty on all the top, but they compromise through a lesser. I feel like it could be problematic if they come back with like a conviction on like a heat of passion. Because then I would argue on appeal, where's the evidence on the record to support the elements required for a heat of passion conviction? So it's just kind of odd. It's just kind of odd, and maybe that's how this courtroom always does it. Maybe both parties wanted all of the charges to go back. Maybe it's a Tennessee thing. But I feel like in the California and Florida cases that we watch, typically it's like you can send lessers back, and one or two parties often will request lesser charges, but it has to be something that there's at least something on the record to support it. So, I don't know. Might be a tricky way to compromise if that's what it comes down to. Yeah, and it's true, premeditated can happen within seconds. Totally agree. But that would mean you just happen to be walking around with this in your pocket. And that's what makes it unusual to like a split change second where something becomes premeditated before the time where he decides to go over to Jade's house for that night, because how would he have had the means that would fit the state's theory? So I think this is what it comes down to. They're going to be guilty on all. I could see a split in terms of, so counts 1, 2, and 3. Let me make sure this, I could probably zoom in a little bit bigger too, so it's easier on smaller screens. Like this maybe. Oop. I could kind of see like a reckless on a lesser for count 1. Right? So count 1, remember, relates to Jade. So theory being intent was to poison with this extraordinary amount of cocaine for the purpose of no baby. To make sure that something happened with the pregnancy, basically causing an abortion, forcing an abortion. I can see a verdict that could come back where it's reckless, a lesser of count 1, where the actions you partook with the intent to commit first-degree murder for the unborn baby. You didn't intend, but you should have known that the actions you were taking would ultimately cause the death of Jade as well. So I could kind of see like reckless and then coming back on guilty for these. You know, I don't know. Oh, Bob, do you want to come up and go through my matrices on the elements of the different lessers. Ah, that'd be a time. Then we've got also, let's see, Amy. Thank you, Amy Sester, for becoming a member. Thank you for becoming green. Moses says, who wants some Arby's? I read this post the other day. It was like on X, and it was like this long thread about people being embarrassed to say certain things through the drive-through. And someone was like, I'm embarrassed to order horsey sauce because they don't want to say the word horsey. That's Arby's, right? I think that's Arby's. So Moses is getting Arby's for everyone. Thank you for the 2, Moses. Hannah, thank you for the 5. Says the defense shouldn't have included any lessers, first-degree murder or nothing. And then George Pino, if Pino's defense went that route, this case is more reasonable doubt. And I mean, I could kind of see a potential benefit of maybe including the reckless, although again, you can convict somebody. Like I kind of feel like the first degree felony murder of Jade caused by the perpetration or attempted perpetration of first degree murder of the unborn baby kind of like overlaps with the reckless homicide. So I don't know. It's a lot. It is a lot. Jury instructions are complicated. Yeah, Michelle the lawyer says, sometimes juries convict just to throw victims a bone of justice. Yeah, and I mean, I can picture a lesser coming back as some type of compromise. I just think it's going to be difficult, depending on which lesser, if that's the case, to support it with the record from the trial. Allie B, one of our Tennesseans, says, can we re-listen to the defense closing and state rebuttal? I'm shocked there are so many charges. Yeah, remember, so there's 4 counts total. All of the lessers are falling underneath that. Well, inherently they're lessers. But that's why the instructions were so long, even though we're really starting with these 4 base counts. But we could, I don't know how long they're going to deliberate. We can rewatch some stuff. I don't know if you guys would also want to rewatch openings. See what we didn't actually get to hear about. Thank you, Allie. Angelica says, I think Jade called NJ and said, what did you give me? Directly to NJ, and Keontae was made aware because they brought it to Jade, possibly as a surprise. And that's the thing, like, for this to still be a possibility, and is it a reasonable possibility? I think it is. I think it's a reasonable possibility to think that something got in that house. And again, what's sticking out to me is that Jade has played like middleman messenger between NJ and Lauren Weber for Adderall pills before, in text messages as recently as November 22nd of 2022. So this idea that a pill could have came and gone at that point, when we were speaking with Mario Gutierrez, significant other of Lauren Weber, who was trying to get weed through Danny Weedman, who Jade was also going to coordinate. I mean, what if there was going to be a pill exchange too? We know that Najee has the prescription. When there was a shortage, she was texting to obtain some like orange 15 milligrams that Lauren had at the end of November of 2022. Like, there's evidence there to make an inference from. It's not just like this outlandish, this idea that the defense is just making stuff up or being deceptive. It's on the record. I think a reasonable person could make that conclusion that that's a possibility the state has not ruled out. And big thank you, Angelica, for the food for thought. So I'm reading comments. I don't know where it went. Peter just had a comment. This one. Okay. So I think a lot of the chat's been saying it. It's kind of like all or nothing. It's gonna be these top charges or not, and I mean, again, anything's possible, right? But it seems most likely that it's gonna be top charges, not like these random lessers. Again, you heard my explanation on how we could get a reckless um for count one for Jade, if the belief is the intent was to cause an abortion and not to kill the woman carrying the baby. But I don't see a logical pathway to convicting on a lesser for the baby, except possibly this idea that the baby wouldn't have died. It wasn't his decision to take the baby off the support, but the defense didn't really go into that in their closing argument. They just got some stuff on the record, it seems, in case they wanted to make that argument at closing, and then they didn't. So to me, I don't really think it's likely we'll see a lesser on the charges that relate to the unborn baby. Oh, and Hannah says, Kat, on my lesser comment, what I meant is defense made a point to highlight that hanging out was last minute and no premeditation, so why include lessers? I don't know. I think it's just got to be something that may be commonly done in this area, and neither party like cared one way or another. But yeah, I really don't see how, like, I just don't see a way that you would just be there accidentally with cocaine if the theory is you use cocaine, right? You had to have some type of planning to obtain that if you weren't in the habit of ordinarily carrying that type of thing around. Now, if this is a case where that wasn't, that if we had evidence on the record that was like, yeah, there was just a plethora available, maybe didn't bring it over, but it was there. And we have evidence that it was there and he could just go grab it. It's just, the lessers are just kind of like, it has to just be something that this courthouse, this area just seems to do. All right, Dizzy says it's the judge's decision in Tennessee. And that makes a lot of sense. But thank you for the clarification. I think I got you. I think I was just going off on like a food for thought. I'm not saying that you had said that. But still, thank you for the additional food for thought. Oh, hold on, Freedom Ring. Freedom Ring says, can you address the phone that Blaise gave to LEO and that they lost? No text in cloud. I'm confused about why no text from Blaise. To be honest, I don't know. I don't know. And I also think it's odd that we have information of messages from Xavier Cohen, but we don't actually hear from Xavier Cohen. I think there's also plenty of other ways to subpoena text messages if the text messages are missing because we can't get one specific device. I don't know how they weren't in a cloud if other stuff was apparently in the cloud. But maybe if we didn't wait a year to arrest him, maybe we could have reasonably subpoenaed or even asked. Like, some people are willing to be witnesses and say, look, I'll give you all the text messages that this person had with me. And I just don't think that that even happened with law enforcement because we heard they didn't follow up on this property management surveillance footage that they had emailed to them and the email link expired. And then the camera rolled over its storage. They don't subpoena Blink. And I don't know, maybe Blink doesn't keep any backups of footage. I kind of just find that hard to believe though, because I don't know, I just feel like I'm so used to companies keeping information, but we just didn't even try to subpoena. So I don't feel like we can conclude that they couldn't have gotten messages. Let's see. If I search for phone in my notes, I've got that Najee said she got the phone from Blaise and said that she got it at the hospital from Blaise. But that would be Jade's phone. But Bridget said, so I wrote that Bridget said that stepmom gave Jade's phone and keys. And then Reese said he got the phone from Bridget. And again, this is all Jade's phone that I have in my notes. Okay, and then this is Blaise's phone. This is from Sergeant James Smith, that Blaise had a phone at the entrance of the hospital. And then using phone in waiting room. And then the next thing I have is Reese. He just said he didn't obtain a cell phone from Mr. Taylor. Titans tablet in summer of 2023. And then his arrest in 2024, they seize a phone and a bunch of other devices. And that's where we heard, remember Reese said like he flew to Utah to go get the stuff. So they just said that they didn't locate it. I don't think that there was testimony that they collected something and then lost it. Okay, then Detective Reese, the iCloud account. Yeah, so I think they accessed everything that they could have through the iCloud because Reese synced up. Remember, Reese testified that he took what was known from the physical extraction from Jade's phone, where you could see here's Blaise as the sender sending a message, and then Jade's phone is receiving it. He said he synced that up based on what he found in the iCloud. So they were able to find, and even though they didn't have the physical phone that Blaise would have had on February 25th, all that information was synced up in the iCloud. So, because they matched it like from that time period in the iCloud and then corroborated it with what was on the physical device of Jade. So, yeah. Then Freedom Ring says, well, thanks. So they waited a year. I think it's so interesting that they couldn't get probable cause earlier. And I'm not a fan of making probable cause the lowest bar in the world, but I mean, hearing the facts of this case, what was reported initially, it kind of just shocks me that they didn't have probable cause for for Blaise until a year later. I just think that's odd. But yeah, so maybe nothing incriminatory was on it. No news was good news. The problem I have with that is I don't truly believe that these detectives sat there and thoroughly looked through anything. Like, they ignored Danny Weed on the day of the incident. How do you ignore when you say you're searching for keywords that would include weed? How do you ignore the contact name? So, do I have faith that they actually went through his iCloud thoroughly? I can't say either way. And none of it came into the record, aside from like the select set of text messages we heard about. So, I just think overall it's disappointing. Definitely think it was disappointing. Was and is. But thank you again. Great food for thought there. All right, Allie says we should watch openings again. We can do that. We can do that. Alfred Dread says, I was listening to different law tubers' takes. The thing that bothered me was almost everyone assumed it was pure liquid coke, which is almost unheard of unless you're in the medical field, not powder that was put in a drinking vessel. Yeah, and I honestly wish we had more, like, just for curiosity's sake, like, if we wanted to have different scenarios, if we assume the extrapolation was correct, or if we assume that the extrapolation was understating the amount even, and we want to go over stacking versus consuming all at once, I would have liked to just seen some type of modeling generally speaking, not applicable to to Jade and Blaise and the timing that they're both in the apartment together. Of, here is the amount of liquid cocaine that would be expected with this type of purity. Um, and when we think that somebody who consumed this would start exhibiting certain symptoms. And I just don't feel like we got a frame of mind. And then we just have this, they're taking selfies and suddenly everything hits the fan. So to me, like, I don't really understand, would pure liquid Coke, would it need to be something super voluminous? Is it like, it could be so concentrated that maybe the drink will taste funny, but it wouldn't be this idea of pouring an enormous amount of powder cocaine into a drink and expecting it to dissolve in a cold refrigerated liquid and be consumed without somebody like notably, not just, oh, it's a little off. I just don't feel like we had that explained. Maybe in voir dire they have someone with some personal experience that can speak to their life experience to the rest of the jurors. I don't know. I don't know. Yeah, and Julio says, I thought it was weird that neither the police department nor the MSP ran a GPS check on Blaise to track his location. I mean, maybe that's again because they waited for quite a while. It's just, it's one of those, like, it's like a perversion of what I feel like I'm used to seeing. Like, I look at a lot of cases where it's like, we rush into something, it's the wrong person, or we rush into something, but we have a search warrant obtained because it's important, and we go and get this evidence and we make an arrest right away. And then once you have the arrest, you can move to seizing devices, get additional warrants, and then start doing the research through whatever you extract. And here it's just kind of like, it really just feels like twiddling thumbs. And honestly, like, I wish that if somebody came in with something that looks like it could be a bad drug, it could be poisoning. Either way, both of those things, either way, seem like some degree of criminality could be in play. I don't know, maybe it should be a thing for hospitals to take a more precarious sample. I mean, I'm sure they have to put life-saving efforts first, but isn't there like a better middle ground? Like, maybe they can notify if such and such is happening. Maybe there's a faster way to notify law enforcement, and then law enforcement could start the process for getting a search warrant for a forensic sample right away. Like, I don't know, I just feel like maybe that's a gray area that could be improved. Or maybe it's already there and it just wasn't followed here. So I don't know. I don't know. But it seems kind of sucky. Seems kind of sucky. So big thank you for the super here, After Dread. And I see Peter here with another 5 gifted. Big thank you to Peter. Super generous. I gotta update my gift counter here. We are growing. The gang is growing. The gang is growing. Hannah says the biggest mistake by both attorneys is not highlighting the legal elements of each indictment. Defense shouldn't have included lessers. See, I think it seems like maybe the judge determines. Like, I don't know. I feel like although appeals could suck, like, if the jury's back there and they're unsure and they decide on like some, like, all right, we're just gonna do like this lesser, I really feel like that's gonna create a pickle. And I don't know, can you guys foresee a jury compromising via a lesser included? Just like going, well, some of us are like here and we could kind of see beyond a reasonable doubt, but we're not at beyond a reasonable doubt. All right, fine. Well, 4th of July holiday's coming up. Let's just like land ourselves like right here. I don't know. I can see it. And I don't think it would make sense. Like, let me reiterate, I don't think it would make sense. I don't think the lesser includeds are really supported by anything on the record here. Pretty much all or nothing with the exception of maybe that reckless on count 1. Ayana says, so interesting to see so many more in chat believe NJ is not believable. If no one NJ, not guilty at all. I mean, yeah, I think I would say that Apple was brought in to bolster, to give like an explanation of why somebody would choose to do this to somebody when they don't really. To me, the text like back in November, like maybe being hesitant, but then going to the park and being like, well, if you do a paternity test, that park talk could explain a change in dynamic from before and then after that January 1st-ish timing. Although I can also see if it was like that park meeting didn't happen, you could argue the switch up was just to get back in the good graces long enough to, hey, I'm not going to drop this in her drink at the Waffle House. I'm going to wait until I go to her apartment again tomorrow. I don't know. But yeah, I think it's interesting. I think there has been some changes, and something that a lot of commentary on day 2 that I saw involved was this idea that the defense was trying to lie about Keontae Jones. And also, why does it matter? Why does it matter if Keontae Jones, even if he did have a prior conviction? Well, it goes to bias. It goes to your truthfulness to have a prior conviction. It's proper, fair game material for a defense attorney to get into, provided it's, actually on your criminal record. And the way that that played out in front of the jury, I think, was so inappropriate. And that's reflected in a lot of the reactions to that video when, lo and behold, there is actually a judgment of conviction. I think on was Saturday day 5, day 6? I think on Saturday was the day that we heard outside the jury presence that the judgment was going to come into evidence. So I think that was a major issue, the way that that was handled in front of the jury, because it goes to look like defense attorney is lying. So who knows? But I do think it's interesting to change, because a lot of people felt like, oh, why would these individuals have any need to lie, and what difference does it make? What difference does it make? A lot of the state's case, circumstantial, and it relies on the timeline. It relies on largely NJ's word. And then Keontae was used to sort of corroborate NJ, because he was brought into that second call, even though he said he couldn't make out any words. So, yeah, for me, Apple's the mic drop. Apple's the mic drop, and then a little bit of the Xavier text, but they didn't call Xavier personally. So that's a bigger inference. Ayana, thank you for the 5 and for the 20. Says, wanted to share another case for the KNW Collective. Not sure if it's been discussed. Oh, yeah, so this is Ruavaje Valley. I say that name 5 different ways. Prep school starting is the shooting case. Ended in a partial acquittal of more serious mistrial on lessers, and the state wants to retry. So that's been ongoing. I believe they just had a hearing like a week ago. I've been following that through misdemeanor, but I think that's a really interesting case. Again, state wanting to retry something that jury at least found certain charges were not, well, all charges were not proven beyond a reasonable doubt. We also had some unanimous, it was acquittals on some of the charges. But the state wants a second go. And when you can't retry certain things, do you change your strategy? I just think it's always an interesting environment. So that could be an interesting one to look at. I've been following it just as an observer, but definitely very interesting. And also shout out to Miss Janet Demeanor, another YouTube creator, really following that case. All right, let's do this matrix, you guys. Let's do this matrix. And then we'll watch some, I don't know if you want to start with openings or with testimony or what. All right, but we've got the counts again. The first 2 counts are first-degree premeditated murder. One of the counts is for Jade. One of the counts is for the unborn baby. Count 3 and 4 are first-degree felony murder, where an underlying felony results in the death, even though the intent might have just been to commit the felony. But the underlying felony here is the perpetration or attempted perpetration of first-degree murder for the opposite. So felony murder for Jade would involve the underlying perpetration or attempted perpetration of first-degree murder. So, like, for example, if, let's say, Jade died, but baby lived, the jury, with that set of circumstances, if they find that all of the other required elements were met beyond a reasonable doubt, could find, hey, like, that's first-degree felony murder. Maybe we think his attempt was to cause the abortion, even though the baby was saved. She died. We think that her death was caused by him trying to poison the baby and kill the baby. They could get to this through that means, right? So good times, good times. Felony murder is a very interesting time. And then we have these lessers. And I should probably put this in something that's more like a list. And I think I got all of the lessers that he included. Okay, this would be the list. So make it like that so it looks better visually. You have your second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. And then, really, the jury could, on any of the four counts, come back with whatever the charged offense actually was. I'm going to try to zoom because this text sucks. It's like super tiny. Maybe I can do this. Yeah, let's do that. All right, so they could potentially come back and they could say, for all counts, we're going straight down the column and going with what was charged. We're going to go with the first-degree premeditated murders on counts 1 and 2, and the felony murders on counts 3 and 4. All of it. They could come back and say, look, we want to do a lesser included on count 1, top charge on this. Like, they could make any combination. But really, they're only supposed to come back with one determination per count, including not guilty. Not guilty is always an option, and hopefully that's available on the form. Otherwise, we'll have a repeat problem of what we saw in Karen Reed. And I think my enlargement cut out 2 columns here, because now it's too big. And it's like hidden behind this other table. All right, so we're just going to make that smaller. I don't know if that fixed the problem. We'll do that. There we go. Now, the factual determinations, I think this is really what it comes down to. You got to go through all these things. These are the different elements we want to consider. And we'll do this stupid enlargement and shrinking again so we can read it. So an example question that the jury might sit back there and need to decide is, did Blaise place cocaine in something like a pink drink that Jade consumed? And then you'll want to decide, yes, no, or unproven. Yes, no, or unproven. Now, if we say unproven, I think we have a problem. I think the state has a problem. Or no, we also have a problem. If we say yes, then you can conclude, I would think it'd be reasonable to conclude that the baby is being carried by Jade. This kind of overlaps. Did Jade actually ingest that cocaine? Yes, no, unproven. Did Blaise perform the act alleged by the state? So was the ingestion caused by this act by Blaise, presumably putting cocaine into a pink drink? Did that action cause the death? And again, this is what I said earlier where, the defense got it on the record like, hey, the C-section conversation, Blaise wasn't a part of that. The baby could have been viable. So maybe there's a determination here that there is some distance between the decision to not try to save the baby and Blaise being responsible for that ultimate outcome, right? Maybe that's something they'll talk about back there. Was another cause sufficient to create reasonable doubt about causation? So going back to, could it have been something at the hospital in the conversation with these decisions? Could it have been, even though we think that this might be really possible, that something was placed in his drink intentionally by Blaise, could it be explained by something else? So for example, maybe we reject that there really was this extraordinarily high amount. Is it possible that a quick pill that Jade wanted to intentionally ingest, had nothing to do with Blaise, could have caused what we saw happen here? And then we have to get into mental state, which really kind of takes us, if you think all of these other things were done, that takes me back to the question where I don't see how they don't find that it was intentional if they find that everything else was proven beyond a reasonable doubt, except the exception there of reckless on the count 1, if they do not believe he intended to kill Jade. And then they go through, they probably got to check it off. I wish we could see what the forms look like, but we don't. We don't have it. We don't have that. That'd be great. Let's see. Necessary findings would overall be that the defendant killed the alleged victim, that the defendant acted intentionally, causing that victim's death, was his or her conscious objective desire. These are really for counts 1 and 2 to meet the elements for premeditated murder. That the killing was premeditated, the intent to kill was formed before the act and after reflection and judgment. The defendant's conduct caused that victim's death, and every element was proved beyond a reasonable doubt, right? So if they're considering the first degree, all the way at the top, that's what they've got to meet. Felony murder, which would be counts 3 and 4, that doesn't require a separate intent to kill the person that ultimately would die, but the required intent would be that the underlying alleged felony, which here they're alleging first degree murder of the other person, resulted in the death of the other person. So they have to find that the defendant killed the alleged victim and that the killing occurred during the perpetration or attempted perpetration of first degree murder against the other person. The defendant intended to commit the underlying first degree murder. The intended underlying murder was premeditated. If the underlying murder was only attempted, the defendant took a substantial step towards committing it. So merely thinking about it and then not carrying it out wouldn't be enough. But thinking about it and then like pouring some amount but regretting it and trying to change out the drink like halfway through, that you could find that to be a substantial step. The killing was sufficiently connected to the underlying murder attempt, and then every element was proved beyond a reasonable doubt. Now, second degree, and I think this is where we're getting outside some of the territory of what makes sense for the record. Elements are a little bit different. Like the awareness changes, different timing of the intent, although intent can happen in seconds. The defendant killed the alleged victim. The defendant acted knowingly. He was aware that his conduct was reasonably certain to cause that victim's death. His conduct caused the victim's death, and the state proved the elements beyond a reasonable doubt. The manslaughter. The defendant intentionally or knowingly killed the victim. The killing resulted from a state of passion. Now, maybe we could do a formal poll on this, but this is really where I want to see the chat's thought, just on this question of voluntary manslaughter. Do you think there's anything on the record to support a finding that there was a state of passion and that passion is how we ended up committing this thing that resulted in manslaughter, that resulted in a death? Put a 1 if you think there's anything on the record to support this. Put a 2 if you're like, this would not be supported by the record, if we found that this was met. And I can't check these. This is stupid. But pretend I'm checking these. And that's going to be a chat food for thought right there. It's just odd to me to think about. But again, I think this is just going back because it just seems like either this judge or this court or this area, they just send this stuff back. They said, give them all the lessers. And then how would you feel if the jury comes back and they just like, boink, we're going to go right in the smack dab middle. We tried to deliberate. We're going to give a little, but not all of it. I just think it'd be so weird to hear this as an outcome. And then the other amounts, the whole chat is like 2s and no's. It's just an odd consideration. That passion was produced by adequate provocation from the alleged victim. The provocation was sufficient to cause a reasonable person to act irrationally. So this would be like you catch somebody cheating. Like this is where you typically see this pull up. And then the conduct caused the victim's death. So that irrational conduct that a reasonable person might engage in based on provocation ended up causing the victim's death. Nobody's alleging or arguing this anywhere in the trial, in my opinion. But like going through these motions, because the jury's going to have this paperwork in front of them, I feel like they've got to like sort through this, and it takes time to sort through. What was this? This must be reckless homicide. Sorry, I didn't put a title on this one, but I'm assuming it was reckless homicide. Yeah, the elements look like reckless. So let's where's my text bubble? All right, so the defendant killed the victim. He was aware of a substantial and unjustifiable risk that the victim would die. He consciously disregarded that risk. Disregarding that risk was a gross deviation from ordinary care, and then his conduct caused the victim's death. So this is where I'm saying, hey, maybe if the jury doesn't think he meant to kill Jade, maybe we could get this one. Maybe we could get this one here. Just my self thinking to myself. Maybe we could get that for the count one, a lesser on count one. But we don't think he meant to kill Jade. This seems like it could apply. They could come back and be like, all right, well, we certainly believe beyond a reasonable doubt he intended to cause, the loss of pregnancy. We don't think he meant to kill Jade. This one seems to make sense. And then I don't know, maybe you guys will, but I don't really see, I don't see a reckless as relating to the baby. And then I think, oh, okay, so I didn't do one on the criminal because I think it gets less, the criminally negligent makes even less sense to me. So those are some of the things that they're going to have to go through back there. And there we go. There we go. They're also going to have a ton more records than what we had. Even in closings, we heard these hints. And I wonder if some of these hints, like curiosity is a good motivator. If you hear something and the chat reacted to it, the chat picked up on it, these mentions of a text message from Jade's mom, like, hey, the baby's heart rate, it's okay. It's okay. And they weren't that close before that. They didn't really communicate, Blaise and Jade's mom. But Jade's mom ends up sending a message to Blaise. Presumably they exchanged numbers. Maybe they had it in advance and just never took the opportunity to speak with one another. Maybe they got each other's contact at the hospital, since Blaise would be leaving and Jade's mom presumably would still be there. But apparently this message goes out from Jade's mom to Blaise. Now, that being dropped when I don't remember hearing anything about that at trial, but I know that the phone records are admitted into evidence and the iCloud data. I'm going to want to go back and find that. Like, what's going on with that? When exactly were those messages sent? So maybe that was more for the sake of getting somebody curious enough to go and look at this portion and this timeline of what's in evidence, because the jury's going to have a lot more than what we saw talked about at trial, and get them to figure out, like a treasure map, go check out this X on the map. England scored. I always wonder, like, I don't know if somebody would make it like 3.5 hours into this stream later. But we had like a quicker Courtney Clenny video yesterday, and I'm like, oh, maybe someone will watch this, but right before her trial, and they'll come back and they'll see the comments in the chat about the World Cup and be like, oh, this stream must have happened back then. Oh no, DKC says the jury doesn't want to be chastised by the judge, so they're not thinking hung. Oh, they're going to be too pressured, too scared to ask questions. Nah, I hope you have an assertive person who has no problem asking questions if they want to ask a question. Yeah, Tance is saying I'm thinking it's first-degree murder. Well, so trying to kill a baby, if you believe that he's trying to kill a baby as it relates to the unborn baby, would be... So, like, these... in... we'll do blue. Counts 2 and counts 4. Oh, we gotta make that bold. Both relate to the death of the unborn baby. Count 1 and count 3 relate to the death of Jade. So the question you're asking is really a determination on, like, count 2. However, that attempt or the successful perpetration trying to kill the unborn baby could be a supporting underlying felony for first-degree murder of Jade Tristan Benning, even if the mens rea, the required elements to conclude that he intentionally tried to and successfully killed Jade Tristan Benning through whatever means, through the cocaine ingestion, wasn't proven beyond a reasonable doubt. Right? So that's kind of why, I mean, I think that's why the state charged it this way, was to give like a net to catch, like, hey, we don't think that he intended to kill Jade. Yeah, Debbie says others were in the house that night, didn't test the cups, and you shouldn't use guessing games. To me, it's just so, I can't get around the Reese saying like, oh, we didn't think the cups were relevant. We just tested the 2 glasses on the counter. I think they said that that's because that's what Najee said, was that they were drinking, they had the glass. And we didn't know until we saw this picture of the tumbler cup with the straw on the island. But like, if you saw the cup while you were in there, just take all of the vestibules. Honestly, take all of the dishware. Who cares if it was washed? Not everybody is great at washing dishes. Like, just because something's run underwater doesn't mean that residuals are going to be completely washed out, especially like nooks and crannies. Even like the tumbler cup. I pulled the lid off my tumbler the other day. If you're shaking a powder into something, if it wasn't like a liquid cocaine, if you're shaking a powder into something, these tumbler cups have these pesky ridges where this would screw around on the top, and then they've got these rubber seals. So they could have gotten the trace amounts that they needed if they collected this tumbler to say like, hey, look, we found traces of this cocaine substance and maybe no detection of fentanyl in the residual that we're finding. This makes the case so much stronger. Like, why wouldn't we want that? Why wouldn't we want that? Like, why wouldn't we want to do that? Same thing with the hair strand. Test the hair strand, show that there wasn't recent usage. Makes your case stronger. And again, what about a scenario where this case wouldn't happen at all? Like, let's say there was no phone call from Jade to Nigeria, but it was still suspected that there was like this extraordinary high level of dosage. So we're looking at the individuals who were in that home that night, that Jade may have interacted with that night. Maybe she prepared a drink before leaving work. You know, she worked at a restaurant. Maybe she prepared something. Let's speak to everybody she worked with. When you're going through the course of your investigation and we're missing that piece of the Najee phone call, just pretend that's just pretend totally different people, totally different scenario. If you're suspecting high dosage poisoning and you're guessing it happened sometime that day, most likely within the hours leading up to it, why wouldn't you be checking bedroom dressers? Why wouldn't you be checking the nightstand? Why wouldn't you be testing the food? I know they said they couldn't send it to the same lab to test the food, but it's not like you can't just not ever test food. Why not test the lids of the containers? Like, it's just, if this was another scenario, this is the type of thing that would go unsolved completely. They wouldn't even have a viable person to charge. Or they'd be back with another, well, this person was there, so let's just charge them. Like, it's just crazy. Yeah, even touch DNA, and I think it's to the benefit of the investigation that Jade had recently moved into this apartment. I mean, obviously, like, you don't know how thorough the apartment was cleaned before she moved in. I mean, was it an apartment that was newly built and she's like the first resident ever, or, you know, did we know it was cleaned well before she moved in? No, but there's a good chance that when people move, they'll bring some stuff over, but there's certain things that they'll order brand new. Maybe they'll get a new comforter, right? Maybe they'll get new pillows. Maybe they'll get a new plunger. Like, there's certain things that people just typically tend to buy. They'll leave the old cleaning supplies at home, buy new cleaning supplies when they move in. Like, it seems like there could be some possibility, or even like the fridge handle. Yeah, the friend said they went in the fridge, but like, what if there was residue? Like, if you didn't like examine Blaise that night or whatever other person in any other scenario, if the theory is they're going to like put these drinks back in the fridge after they spike somebody's drink, maybe there'd be some residual on their hands when they're contacting the fridge handle. But we don't swab anything at all. But yeah. So with that, just so you guys know, I do have the feed running, so if I like anything rustles around, I'll be able to tell. But did you guys want to rewatch openings, see what we didn't get to see that we thought maybe we'd see? Moses says the Arby's was bomb. Always good to hear. Always good to hear. Did you order horsey sauce? Is this day one? No, that's not day one.
Davidson County, Tennessee, duly impounded, sworn upon their oath to present that Blaise Allen Taylor on the 25th day of February 2023 in Davidson County, Tennessee, and before the finding of hearing, filed against the Attorney General Court.
Client agrees to that indictment.
I'm not guilty.
Okay. All right, does the state care make an opening statement?
Yes, Your Honor. What did you put in my drink? I knew my drink tasted funny. You did this because you didn't want to fake. Those are a few of Jade Benning's last words, heard by her very best friend, Jade Jackson. Words that she heard spoken to Blaise Taylor over the phone 20 minutes before EMTs would find Jade Benning pulseless. EMTs found Jade Benning face down, laying across her bed, not in her bed, across her bed, face down. She was pulseless. When they found Jade Benning, she had this pink, frothy liquid around her mouth, like a spit up. And the area where she had been face down on her comforter, it had that same pink spit up vomit on it. The EMTs did not even know that Jade Benning was 5 months pregnant. They rushed Jade Benning to Vanderbilt Hospital, and when she arrived at the ER, Jade Benning was dead. You will hear evidence and testimony this week that none of the treatment team at Vanderbilt's emergency room had that night of February 25th, 2023, just after 10 p.m. when Jade Benning came to their emergency department. You will hear the evidence and testimony that the blood sample that was taken in the emergency room at 10:31 p.m., the very first blood sample from Jade Benning, that the later testing that came back months later, the concentration of cocaine in her blood was so high, it was unlike anything the medical examiner in this case had ever seen. But it was higher than anything the entire medical examiner's office had seen. You will also hear evidence and testimony that the testing of that pink spit up vomit on Jade's comforter, that it also tested an outrageous level of cocaine. You will hear evidence and testimony from multiple different experts that the physical evidence in this case shows that Jade Benning orally ingested cocaine that had been dissolved in a liquid. You will also hear that Jade Benning was drinking a pink drink that night. Before any of those events happened, Jade Benning was a young 24-year-old, about to turn 25, young woman who was very happy to be 5 months pregnant. Jade Benning was not from the Nashville area. She's from Arkansas. She grew up there with her mom, Bridget, her stepdad, Lynn.
And guys, I just put up, sorry, I can't manage a poll while I'm like also talking on stream. So I just put up the how would you vote poll.
That's where she met her very best friend, Jade Jackson, when she was just 6 years old. Jade went on to school. She was a competitive athlete growing up. She went on to school, but her dream was to be a chef. And she achieved that dream. She went to culinary school, she graduated, and Jade actually had family living in the Nashville area. Her stepmom and dad and her half-sister lived in the Nashville area, and her stepmom's brother owned a restaurant, and he hired her on as a chef. And she was so happy to be living her dream. She had a group of really close friends that worked with her at the restaurant, and that was early 2022. And then in August of 2022, Jade Benning's best friend, Jade Jackson, her very best friend growing up, moved to Nashville to go to school at Mary. They were back together again, and these two girls talked constantly, told each other everything. They were so incredibly close. And it was about that same time in August of 2022 that Jade Benning had been linked with Blaise Taylor on a dating app. They started trading messages, and in mid-August they went out to one dinner at Stony River and went on a date. And they began a casual relationship. It became sexual. It was not a public relationship. They dated, and sometime in late September, Jade Benning became pregnant. Now, she did not find out that she was pregnant until November 2nd of 2022. And when Jade Benning took that home pregnancy test, the very first thing that she did was she called her best friend, Isaiah. She told her, and they started planning to figure out how they could get an appointment to make sure that that was in fact the case. And she confirmed that she definitely was pregnant. Jade Benning reached out to Blaise Taylor, told him that she needed to talk to him in person, and they talked. And then the next day they talked some more. Jade Benning reached out to her mom, Bridget, to her dad, Dennis. She told both of them. She talked to Isaiah a lot about it. She was happy. And on November 6th of 2022, she sent a message to Blaise Taylor confirming her choice to the ultimatum that he gave her. There were no more messages between them. Not any messages until New Year's Eve. Jade Benning went to her November 16th, 2022 ultrasound, and Blaise Taylor was not there with her. She began planning. She was living in a one-bedroom apartment, and she began planning to get a two-bedroom, and she just started doing all of the things that you do to get ready to have a baby. New Year's Eve, she didn't have to work that night, but she still went to the restaurant that she worked at. She went with her dad and her stepmom, and they were there with everybody at the restaurant for New Year's Eve. Blaise Taylor reached out to her on New Year's Eve. And after that night, they began speaking again. And the messages they sent back and forth, it was kind of trying to figure out what was going to be. Jade Benning ultimately expressed that she wanted a relationship with him. Blaise Taylor didn't go to any of Jade Benning's pregnancy appointments. She had 3 in February before she died. He didn't go to the February 2nd appointment where she was going to find out if they were having a baby girl or a baby boy. She asked him to go, and he did not. The week before February 25th, 2023, that day is a Saturday. Earlier that week, Blaise Taylor went out of town on a work trip. And he came back early that Thursday morning. And Jade Benning wanted to see him. And they messaged. She went over to his house mid-morning for a little bit before he went to work. And she asked to see him that night. But he did not make that plan happen with her. And on Friday, she again wanted to see him. She went over and they went and ate at Waffle House. And she wanted to see him that night. And she messaged him. But he didn't return her message. Well, Blaise Taylor was messaging people that night. He specifically sent a message to Cynthia Winford that said, I love you, and I need you to love me back and be in love with me. That is the night of Friday, February 24th. Jade Benning asked Blaise Taylor again on Saturday the 25th if they could hang out and have a date night. And he agreed. And she told him to be at her house at 7 p.m. Wear comfy clothes. She had something planned. And she had already been talking to Nigella Jackson about what she was going to do. She came up with an idea that they would do kind of like a sip and paint, not the sip because she was pregnant and she was not drinking any alcohol, but that they would paint and she would make dinner. She, the chef, Jade Benning, was going to make one of her specialties, chicken Alfredo. Nigella Jackson suggested that meal because it was her favorite. Nigella wasn't eating chicken, but she wanted the Alfredo. She suggested it, and that day Nigella even said, I can stop by and get some food. Because Nigella Jackson, her best friend, when she was 6 years old, had never met Blaise Taylor. And the man that she was having a baby with. And so that day, Jade worked early in the day, but she went home, she got everything ready, she had canvases, she had paint, she took multiple pictures of everything, she cooked the dinner, she took pictures beforehand, and about 7 o'clock p.m., Blaise Taylor came over, and they ate dinner together, and then at 7:30, Nigella Jackson, she had been at school, and one of her friends that she went to school with, Keontae Jones, was with her, and they stopped by to pick up food. They weren't planning on staying. They ended up being there for about 30 minutes, and they talked to them. Nigella got to meet Blaise Taylor for the first time. They did both notice that Jade was drinking a pink drink. They didn't drink anything while they were there. Then they said goodbye. Right afterwards, Nigella starts texting Jade, talking about the cute interaction they had, and they have a couple text messages. And that's at 8 p.m. An hour and a half later is the next time that Nigella Jackson would hear from her best friend. And she did not sound the same at all. During that hour and a half time period, Jade was very active on her phone. She took pictures. There's a picture at 9:10 p.m. where you can kind of see a progress of the painting project. And you see Jade's painting. And she has the words love that she's painted on the painting. These paintings were for the baby's nursery because she was having a baby girl. And you'll see the painting that she has that says love, hope, inspire, peace. And then the digital forensics expert from Metro Nashville Police Department will testify and explain that he can tell that Jade Benning not only was on Pinterest, but she actually searched. She was looking for inspiration for more words that were beautiful words of inspiration. So that's from 9:10 to 9:24. At 9:24, there are a series of 12 photos taken. The 12 photos are all pictures of Jade Benning and Blaise Taylor, and several of them have her painting in it. That last painting was at 9:10, and at 9:24, she has added words to the painting. She has added the words believe and beautiful and hope. Painted them on the painting. It's at 9:28 and 45 seconds. That is the last action that happens on Jade Benning's phone. That last 12 picture was deleted. And then at 9:29 and 27 seconds, Jade Benning's phone calls her best friend, Najee Jackson. And Najee Jackson will describe to you that her best friend was talking, but she wasn't talking to her. So much so, Najee immediately sent her 2 messages. Are you talking to me? What's going on? Because it was not normal. Her friend did not sound normal at all. She described her as sounding wavy, the way she was talking. She had known her since she was 6. She knew it wasn't, I'm not feeling well, something like I feel sick. She described it that her friend sounded scared. Her friend was talking to Blaise Taylor, and Jade Benning said, "What did you do? I can't feel my legs. I can't walk straight. What did you put in my drink? I knew my drink tasted funny. What's in your hand? Show me. Show me your pocket. What did you put in my drink? I knew my drink tasted funny. You did this because you didn't want the baby." She was repeating, "What's in your hand?" At one point, he responded back to her, "Nothing." During this 6-minute and 9-second call, Jade Benning is screaming out to her friend who's not responding to her. She hears her friend say to Blaise Taylor, "You're scaring me." And his response was, "You're scaring me." After 6 minutes and 9 seconds, Jade's phone disconnected the call. Right before that call disconnected, Najee, she was so confused as to what was going on, she merged her friend Keontae Jones into the call so that he could hear it. And at the end, Jade was trying to speak, but couldn't form words. He heard Jade, but couldn't make out anything that she was saying. That call began at 9:29 and 27 seconds. It was 6 minutes and 9 seconds long. At 9:50 p.m., EMTs arrived at the patient, Jade Benning, and she was pulses. Jade Jackson sped to her best friend's condo, and when she got there, Jade Benning was already in the back of the ambulance. They would not let her in to see her friend. She started jumping up and down so she could see in the little window, and she saw her friend, who was gray. Jade Jackson, she goes to Vanderbilt ER, and Blaise Taylor, he goes there too. He had called 911. She goes to Vanderbilt Hospital. She talks to the medical staff. She hears him talking to the medical staff, and he is not telling them what Jade said. She tells them what she heard her best friend say. The first officers arrive an hour later, and Officer Pfeiffer, he hasn't talked to Jade Jackson yet. He approaches Blaise Taylor and asks him what happened. Another officer talks to him, and then a detective talks to him, and when he talks to all three of those people, the scenario he gives is Jade started feeling bad. She threw up. I called my dad. My dad told me to call 911, and then I called 911. He tells Officer Pfeiffer, the first officer, that the person on the 911 call who answered it told him it was an allergic reaction. He will also be presented with that 911 call. That 911 call where the operator says the standard, please give me the address of your emergency. He says, I don't know, it's on Donaldson. I'm with my friend, and she's having an allergic reaction. He goes on to tell the 911 operator that she must be having an allergic reaction to something she ate. He doesn't tell the 911 operator anything about what Jade Benning said. And about 6 minutes and 25 seconds into that 911 call, which he called his dad, 45 seconds before he called 911. It was a 30-second phone call. Now that's several minutes after the call with Nigeria ended. Not a ton of time, but 2 to 3 minutes after that call ends. Places a call to his dad, 30-second call. He calls 911. But again, he's told all 3 people, he later tells all 3 law enforcement. She threw up. I called my dad. I called 911. 6 minutes and 25 seconds into the 911 call, he tells them, I think she's throwing up. He never tells 911 that Jade Benning is his girlfriend. He never tells them she's pregnant. The doctors at Vanderbilt, they were able to return spontaneous circulation, which means they were able to get Jade's heart to beat again. But the damage that was done to her brain, she never regained any brain activity, and she was on life support. On March 6th of 2025, Jade Benning and her unborn baby girl on her 25th birthday, she was removed from life support. Dr. Erin Carney with the medical examiner's office, she performed the autopsy on Jade Benning and her unborn baby girl. Dr. Carney already knew about Jade Benning before she ever died. She had already been contacted about her case because it was very unusual. And on February 28, 2023, she requested Jade's first blood sample, that it be retained and saved for testing. She performed the autopsy and she verified there was absolutely nothing wrong with Jade's baby. Had she remained alive, her pregnancy would have continued and she would have had a baby girl. Dr. Carney will testify and tell you that the cause of Jade Benning's death was acute cocaine toxicity, a level higher than anything she has ever seen in any overdose death. You will also hear from another witness, Miss Apple Denny. She dated Blaise Taylor her freshman year of college. It was back in 2017. She was a freshman in college and she became pregnant. And she was not ready to be a mother at all. And she made the decision. He was with her. She made the decision to have an abortion. And Blaise Taylor went to those appointments with Miss Denny. They explained to her she had two options. And he was in those appointments, they talked about it. And she made a decision to have that abortion herself. Several months later, she will also describe to you a time when Blaise Taylor came to her in somewhat of a panic. And he told her that while they were on a break, he had slept with another woman, Xavier Winford, and she was pregnant. And she was refusing to have an abortion. And Apple Denny will tell you that Blaise Taylor asked her if she would go to the abortion clinic and get the abortion pill so that he could put it in Xavier Winford's drink to cause an abortion without her knowing. Miss Denny told him no, and also told him that wasn't even possible. And she will describe to you that he then began talking about what else could he put in her drink that would cause an abortion. Jade Benning's last words. What did you put in my drink? I knew my drink tasted funny. You did this because you didn't want baby. After you have heard all of the evidence, we will ask you to return a verdict of guilty on all 4 counts of the indictment.
For your opening statement on behalf of Mr. Jade.
Yes, Your Honor. Good morning. As we talked about yesterday, this is a very, very serious situation, as you know. And so again, I thank you. I thank you for coming back. I thank you for coming yesterday. And I thank you for taking very serious, and I know that because of the answers you gave us yesterday, this process in our judicial system. I too want to tell you the story of Jade Benning and Blaise Taylor. But as you can imagine, it's quite different. And you're going to hear over the course of this entire trial, a lot of information. And if any of you are like me, it's easier to compartmentalize things so that as you hear the evidence, you can dump them in a bucket. And that way, at the end of the trial, a week or so later, it won't be so difficult to remember what you've heard. And so what I want you to do is I want you to think about things before, think about during the incident, and after the incident. Think about things before the incident, and the incident is going to be February 25th of 2023. Before the incident, during the incident, and after the incident. It will help you. So let's talk about before. Before, I want you to know who Blaise Taylor was and who Jade Benning was. Blaise is the oldest of two children. He is the son of Eddie and Trooper Taylor. Blaise has a younger sister, Star Taylor. Blaise's father is a football coach, a college football coach. And I've since learned that living a football coach's life and on that level, it takes you around several places across the country. And so they traveled a lot. They lived in a lot of different places because Dad worked in a lot of different places. And Blaise got his education from the University of Arkansas, where he graduated in 3 years with his master's degree in business administration. After that, he began working. And he ended up, after a few jobs, working for the Tennessee Titans as a pro scout. That is where, here in Tennessee, is where he meets Jade. But what's also important to know is that throughout Blaise's life, even when he played football, even when he was in college, he never drank and he never did any drugs. No alcohol and no drugs ever in his life. I want to now show you who Jade Benning is and was. She was a beautiful young lady. She was an aspiring chef. And she too was from Arkansas. And she moved to Tennessee after graduating from culinary school to become a chef and work at Ernest's Hideaway Grill and Bar. But different than Blaise, Jade was involved with alcohol. And Jade was involved with drugs. And that is where they differ. But what they are alike, as you heard, just as Blaise was casually dating young women, Jade Benning was casually dating young men. And so that is who they were before the incident. Now let's talk about Blaise and Jade and their relationship. Blaise and Jade met on Hinge, a dating app, in January of 2022. They exchanged a few messages, but never really hooked up. It went into February of 2022 when Blaise reached out to Jade, but yet she never returned the message. About a month later, she returns the message and says, "Oh, I've been busy, but it's good to speak with you." And then they went dead for a while. They didn't talk again until August of 22. In August of 22 is when they actually met up. August the 10th, they met and they had dinner. And after that, they began a relationship. They began casually dating each other. But they were not exclusive. He wasn't exclusive with her, and she wasn't exclusive with him. You will hear that he dated other women, and you will hear that she dated other men. And they were both okay with that because that was the agreement that those two adults had come to. They had agreed that they would have a sexual relationship, but they would still date other people. And as adults, you will hear that that is what they decided to do. You will hear that they probably started having sex somewhere around August. Remember, they met August 10th. So by August 23rd or so, you will hear that they probably began their sexual relationship. So from August 23rd until November 2nd, they started dating. They would see each other. They would hang out. I believe that the restaurant where Jade worked was very close to Blaise's house, and it was convenient because of their schedules for Jade to go over to Blaise's house after he got off work, after she got off work. And she would spend the night there. He would get up and go to work in the morning. She would sleep late and get up and leave whenever she got up. Now you would hear sometime around November 1st of 22. Jade believes that she may be pregnant. And you will hear that she's having a conversation with Jade. And what they're trying to figure out is who the father is. And you will hear that they weren't sure if it was Blaise's child or if it was some guy named Des' child. And so they talked a bit, and they talked about who she was having sex with the most. And it appeared that Nigeria thought that she was having sex with Des the most. But apparently, you'll be able to hear that ultimately Jade landed on Blaise. And Nigeria agreed and said, oh, well, it must be Blaise's. And you'll hear that it is at that time that Jade makes the decision that she's going to tell Blaise that she's pregnant with his child. And so you kind of deduct, you'll be able to deduct that she did talk to Blaise around November the 4th. And on November the 4th, it is clear that she tells Blaise, this baby is yours and not Blaise. And you'll hear that it's true that Blaise, at that time, was not ready to be a father. With the woman he met less than 90 days ago, who was casually dating other people just like he was. And he did not want to go forward with the praise. That's clear. He was 27, he wasn't married, he really didn't know her. And clearly he suggested alternative methods. And he suggested it to her because it was something that she had agreed to do with someone else in the past. But Jade wanted to keep this child. She wanted to give birth to Blaise's baby. And so what you'll hear though is that they had a difference of opinion and that they were at an impasse. And so clearly they had talked about it from November the 4th until November the 6th. Because on November the 6th, you will learn that it was Jade who told Blaise, clearly, there's no agreement that we're going to come to here, and I'm not changing my mind. So what I suggest is you go your way, I go mine, You don't have to be involved with the baby if that's what you want to do. I will go on and I will love this baby with or without you. My next appointment is on this day. If you want to be there, you can. But if not, this is the decision that I made. You'll hear that that's the decision that Jade made for herself. Now what's important is that after that, what you won't hear is that Blaise was forcing her, pressuring her, continuously calling her or texting her, trying to force her to abort this baby. You won't hear it. You will hear that from the moment she made that decision for herself and told him, you go your way and I'll go mine, that he did not contact her again. You will hear that he honored her wishes. You will hear that he gave her the space that she asked him. But then you'll hear that some time had passed. It would have been enough time to have passed to where she had passed the stage of where abortion would be a viable option. You'll hear that he told his parents, and he told his parents that he'd met a young lady by the name of Jade. She was a chef, and he was possibly going to have a child. And what you'll hear is that he then at that time, after making that decision to tell his parents, he contacted Jade on December the 31st. And she responded via text, I'm at work or what have you. And you'll see that on that very same day, she texted Nigella, her best friend, and said, you won't believe this. Because she had a missed call from Blaise. And that ultimately, on January 1st of 2023, they met up at a park, and Jade's suggestion, she suggested, let's go to a park. And he honored her wishes again and met her at the park. And it appears that they sat in that park and they talked for almost 5 hours. And they had made the decision that they were going to try to get to know each other so that if the baby was in fact Blaise's, because Blaise asked for a paternity test, which made sense, that they needed to know each other if they were going to have to co-parent this child. And you will hear from Nigella herself that it was at this time that Blaise made every effort to do that, to get to know her, to participate. And so remember this is January 1st, so over the next month and a half, 3 weeks until February 25th, they dated, they saw each other, they hung out, they spent time together, and they were getting to know each other. Now you'll hear that Jade did have doctor's appointments, and she did want Blaise to attend. But what you'll hear is that she told him about one appointment, which was, in fact, February the 6th, I believe. And she was going to find out the gender of the baby on that day. And you'll hear that she asked Blaise to come. And Blaise said, I need to check to see what's going on at work. I don't know what's going on at work. And if I can make it, I will. You'll hear he didn't make it. But you'll also hear that the next appointment she had was about 4 days later, but it was for a blood test. It wasn't necessarily another actual visit, the monthly maternity visits. That one was not until March 9th. And by that time, unfortunately, she had already passed. And you'll hear that during this time that they were split, And when Blaise was dating Xavier, Jade, now knowing that she was pregnant, was dating other men as well. In fact, there were 3 other men that she was dating in December. And you'll hear that we know that for sure because she was sending naked pictures to them in December. And there were 3 men, 3 different men, that she sent naked pictures to from December the 3rd through almost towards the end of December. So yes, you will hear that they both were dating different people. Now, we'll go to February 25th of 2023. Now, what's also important to know before we get there, you'll find that Jade was involved with drugs prior to the day that this happened, prior to the day that she was diagnosed with acute cocaine toxicity that caused her death. You'll hear that she was involved with marijuana. You'll hear that she was involved with Adderall. You will hear that she was involved with the weed cartridges. I think they call it resin. You'll hear that she was involved with mushrooms, that she would take mushrooms. And you will hear that she also drank a lot until she was drunk oftentimes. In fact, you'll hear that during maybe a day or so before she and Nigella was having this conversation about who was the father, and it was Blaise's, that she was inviting Nigella to share mushrooms with her. And you'll hear on the same day that she learned that she was pregnant, that Nigella was asking her to call Des to reach out for some drugs. Fast forward to February 25th. On this day, during the incident, you'll hear that Jade, in fact, did spontaneously plan a date night with Blaise, where she was going to cook, where she wanted to do the paint and sip, I believe Nigella calls it. Painting with a twist, I believe it is. And that's the where you paint and drink and have alcohol. But according to Nigella, they weren't going to have any alcohol because remember, even Nigella is going to tell you that she knew Blaise did not drink. And so, as she planned this date spontaneously, she reaches out to Blaise around noon that day. He didn't know that she was going to call him. And says, hey, what are you doing tonight? Will you be free? And he says, yeah, what do you want to do? What's going on? It was a little cold that day, so he wanted to know, what did you want to do? What should I wear? She says, dress comfortably and come to the house around 7. And he says, sure, I can do that. Now, what you hear when she was planning this date night, she was planning it with Nigella. What should I cook and what should we do? And Nigella says, well, I want some chicken Alfredo. So why don't you cook that? And Jade says, okay, that sounds good. Now, what's important to know is that Jade was a very ambitious young lady, and she had her own business, JTP Eatery, which was like a small catering company. And when she would cook, you'll learn that some of her food would be infused with marijuana. In fact, you'll hear that her chicken Alfredo she would sell would be infused with marijuana. And cookies and brownies and things of that sort. So she makes the decision to have this date night with Blaise, and she and Nigella talk about it. And then at that point, Nigella says, well, I want some chicken Alfredo too. And Jade says, well, I'll put you some up for tomorrow. But Nigella says, and now we're in the bucket of jury, just so that you're oriented. Nigella says, well, no, I want to come tonight. Even though she's planning a date night with Blaise. She's now inviting herself into Jade's date night. And so she shows up, I would say, we know around 7:22 she sends a message, I'm on my way. And when she gets there, she brings a friend, Keontae, and she tells Jade, I want to bring Keontae too, because he wants some too. So we're both gonna come to your date night. And they show up, and they stay there. But not for long. But what you'll hear is that when they showed up, Blaise invites them to stay. Hey, why don't you guys stay and play cards? And he had a deck of Uno cards that he was playing with. And he says, let's play Uno. And then he asks, well, do you guys know how to play spades? And Nigella says, no, I don't know how to play spades. And so he says, well, you guys should stay, hang out. But Nigella says, well, no, I don't want to intrude. We'll leave. And so we know that by 8:03, she was gone. Because she sends this text after spending that 20 minutes or so with Jade and Blaise. That was a cute interaction. What you won't hear is that she sent any text as if there was anything nefarious going on. You will hear that she describes that moment as a cute interaction. And you'll hear that Jade responds and says, yes, Blaise says, we should hang out again or you guys should have stayed. And Nigella responds, well, no, I did not want to intrude on your date night, so we left. Fast forward to about 9:28. So this interchange went on from about 8:03 until about 8:12. Then you'll know about 9:28, what you're going to find is that Jade and Blaise, specifically Jade, was taking selfies with Blaise. And you'll find that the selfies were them kissing and laughing and joking and having a great time. You'll see those photos. And you'll see that they were taken from Jade's phone. But then less than a minute later, you'll hear that Nigella gets this call. And the call, I want to make sure that I say it right. The call, less than 60 seconds later, Nigella describes it as, it was the most wimpiest voice I've ever heard. Those were her words. The scariest thing I've ever heard. She was freaking out. I never heard anything like it. She was fighting for her life. It was as if she was in danger. She says that she overheard her saying, you put something in my drink. What did you put in my drink? But what you'll learn is that when Jade is making these accusations per Nigella, that Nigella sends a text back saying, are you talking to me? So when Jade is making these accusations, Nigella's response is, oh, are you talking to me? You won't hear that she says, what are you talking about? Who are you talking to? You're going to hear that her response to those allegations are you talking to me? Within that moment, as they're describing, it was as if she was in danger and she was alone, per Nigella, in the apartment with the man that Najee says was trying to kill her best friend, Najee never calls 911. No. Instead, she says that as Jade's voice was whimpering and going down as if she was going to pass out, that Jade had enough voice to say, call Keontae. Call Keontae on the 3-way. But what you're going to find is that Najee says she really didn't know. Jade really didn't know Keontae. But according to Najee, Jade wants her to call Keontae. You won't hear her say that Jade wanted her to call 911 or call her father. But she wants her to call the guy she doesn't really know on the 3-way. And Najee says she doesn't. And after she calls the gentleman, Keontae, on the 3-way, what you'll hear about Keontae is that he will tell you, yes, I was on the call. And her voice was, Jade's voice wasn't really, I couldn't really make things out. But I didn't hear the things that Najee said. I didn't hear those things. And what you'll also find is that with all the danger that Najee described, all these fear and everything that her best friend was going through, Keontae didn't call 911 either. What you're going to find is that there was only one person that night that called 911. Because Jade didn't call 911 either. You'll hear that with all of this medical emergency, all of these things that were going on with this young lady, there was only one person who called the police, who called for help. And that was Blaise. And you'll hear the 911, I promise you. And you'll have the opportunity to hear everything that he said and everything that he did. But you won't hear one 911 call between Jade, Najee, or Keontae. And you'll hear the panic in Blaise's voice. You'll hear where he's running around trying to find the address. Because he didn't know the address by heart that way, just like Najee didn't know the address. Because later you'll find that the police asked Najee for the address too. And remember, she had just been there earlier, and she had to call to get the address. And you'll hear that eventually EMS showed up. And what's very important to know is that when EMS shows up, and they get in that apartment 107, Jade was in a significant or stable enough condition that they did not perform CPR inside of the apartment. So you'll hear that whatever stress, whatever condition Jade was in, it wasn't significant enough for EMS to begin CPR right then at that moment. And those medical professionals will have to tell you that if it was dire enough that way, they would have had to give her CPR right then and there. They will tell you that. They will tell you that if the stress and condition that that young lady was in was so dire, they would not have waited to give her CPR once they got her on the back of the ambulance truck. So then you'll hear that Blaise was the one who ran out and met the ambulance outside and showed them where the apartment was. Because the apartment is such that you're really not going to know where the apartment is unless someone kind of directs you. So you'll hear that he went out and did that. And you'll hear that he never went back upstairs after EMS got there. When EMS left, he did too. And by then you'll hear that Jade was there, and she too followed the ambulance truck. And when they get to the hospital, it was Blaise who showed and helped Jade park. And so they go into the hospital, they rush Jade in. She's in critical condition by this time. And Vanderbilt is doing everything they can to give her the services that they need, that she needs. And you'll hear that Nigeria in the hospital starts with these allegations. This is where Nigeria starts telling the social worker there at Vanderbilt. Blaise did something to her. Blaise put something in her drink, and these are the things that she was saying. And the investigation begins. And now we're at after. Oh, I'm sorry, I went the wrong way. And then you'll hear that while they're at the hospital, Blaise never leaves. He stays there the entire time. When her mother calls, he answers the phone. When the police questions him, he answers the questions. When another police officer questions him, he answers those questions. When another police officer questions him, he answers those questions. You'll hear that he cooperated with every authority there. And not one time, while he was at the hospital being questioned, being accused of being the person who caused this, did he ask for a lawyer? Did he exercise his right to the Fifth Amendment? Not one time. He did what he thought you would hear that he was supposed to do. But what you'll hear with Nigeria is that at some point during the night, she's questioned as well. And you'll hear that those police officers tells her, we need to talk to this Keontae guy too, for obvious reasons. And you'll hear that Keontae, although he comes to the hospital, he meets Nigeria in the parking lot. And you'll hear that when police officers have told her, we need to talk to this guy, she doesn't alert the police officers that he even showed up. She doesn't tell them that, hey, that witness to my best friend's medical episode, he's in the parking lot, come get his story. Instead, you will hear that she talks to him and then he leaves without talking to anyone, without giving anyone the side of his story of what happened. You'll also hear that she left again. And what's important to know is this, that you'll hear by this time, that apartment, based on Nigeria's allegations, is a crime scene. And that even though it's a crime scene, and that even though Officer Fish, who was one of the initial responding officers, told Jade Benning's stepmother and mother, someone Nigeria was in constant contact with throughout the night, as you can imagine. Nobody in that apartment, nobody out. It's shut down. It is a crime scene. There should be no one in that place. We need to go in there and figure out what happened. You're going to hear that Jade's friend, Lauren Weber, Nigeria's friend, Lauren Weber, and another young lady went inside that apartment anyway. And that even though they weren't supposed to go in there and touch him, that she removed items out of that apartment, she locked it up, and then she brought her, Jade's purse and ID to the hospital. And you're going to hear that when the police officers hear this, And they learned that some people had entered this crime scene, that they said that that crime scene was contaminated. You'll hear that law enforcement says that themselves. And then you're going to hear that Jade and 3 more other people went inside that apartment with gloves on and removed crucial evidence and kept it for 24 hours before they turned it over to the police. They gave it to her mother. Evidence of the crime, they grabbed it, removed it, and kept it. You're going to hear now one time when Jade was speaking to those police officers, did she tell them, hey, I'm about to go over here to Jade's house, you know, the crime scene, and we're going to go over there and help you guys out and remove evidence for you. She never says that. She never tells them that. They have to find that out through Jade's mother. You're going to also find that Najee had Jade's phone during this time and had gone into the phone. And we know that it couldn't have been Jade because by now Jade was in critical condition and in the phone and was manipulating through the phone. And so you hear that at some point Najee leaves the hospital, but Blaise is still there. And he doesn't leave until Jade's mother gets there. And that you'll hear that he helped her find a parking space too. He ran out there and said, you know, save the parking space as well. And you'll hear by now, it's over. Jade's in critical condition. She's pretty much on life support. She had suffered a significant brain injury as a result of losing oxygen to the body. And you'll hear that there was, in fact, laboratory evidence, the blood, the urine. You're going to hear a lot of stuff about that. And yes, you're going to hear that there was an awful amount of cocaine in her system. But what you're going to hear is that the integrity of those vials of blood and urine were such that the results of those blood tests does not make sense. The experts are going to have to tell you that it was too much cocaine for Jade to take on her own, and too much cocaine for Blaise to have slipped in a drink and her not notice. But you're going to hear there's so many issues with the way the lab dealt with that there's not a medical professional alive who would rely on those results. They're going to have to tell you that. But what they are going to have to tell you is this, as a result of those toxicology results, is that in Jade's system was cocaethylene. And you're going to learn that cocaethylene is where cocaine and alcohol meets up in your system at the same time. You're going to hear that there is no other way the metabolite cocaethylene can appear. No way. You can't have taken alcohol at 7 o'clock and then did a bump of cocaine at 9 and you form cocaethylene. You're going to hear that you can't take a drink of alcohol at 7:30 and take a bump of cocaine at 8. It has to be at the same time that cocaethylene was present in Jade's system. And you're going to hear that it was at levels such that it would have had to have been some time that had passed for it to be there in the fashion that it was. You're going to hear that at the end of this, that the medical examiner, Dr. Aaron Carney, performed the autopsy on Jade Benning. And what you'll learn is that an autopsy is, what they like to say is that it's not done in a vacuum. And what that basically means is you can't just look at the body to determine what happened. You have to factor in surrounding circumstances as well. And what you'll learn is that there are two things that the medical examiner is responsible for doing: determining the cause of death and the manner of death. The cause of death is going to be the medical issue that caused you to die. And the manner of death, you'll learn, to be only 5 things. It can be natural causes, accident, it could be undetermined, it could be homicide, and it could be suicide. It's going to always fall in one of those 5 buckets. And because it's not done in a vacuum, you have to look at the surrounding circumstances before you come to a conclusion as to which bucket those 5 land to. And what you're going to see is the medical examiner, the medical professional, the person that we rely on to come to a conclusion professionally as to what happened in regards to the manner of death for Ms. Benning. You're going to hear that even she could not come to the conclusion of homicide. And homicide just means you died at the hands of another. Doesn't necessarily mean a crime occurred. It just means that you died at the hands of another. You're going to hear that Dr. Carney is going to get on that stand. Remember, we talked about that's where your evidence will come from. And she's going to have to tell you, I cannot rule this a homicide. And the reason she's going to tell you she cannot rule this a homicide is because of the circumstances surrounding Ms. Benning's death. And that she ruled it undetermined. What that basically means is that she could not come to a conclusion. Now you will hear from Apple Daniel. And Apple is someone that Blaise dated when he was in college, some 6 years before this happened. And you'll hear that Apple is from Arkansas, Jade is from Arkansas, Jade is from Arkansas, and a friend named Ariane Jordan is from Arkansas. And you'll hear that Ariane heard about Ms. Benning's death. She heard about the allegations that it was Nigel who was saying it was Blaise that did it. And that within days of Ms. Benning's death, she told Apple. And you're going to hear that even though Apple says that Blaise was trying to poison Xavier Winfrey, she never goes to the police right then and there and says, Blaise was trying to kill someone else. Just like this situation. You're going to hear it was months before she did that. But you're going to hear a lot of other things too about Ms. Benning. You're going to hear that just as recent as April of this year, that on her to-do list was to put Blaise in prison. And she posted it. You're going to hear that there were times that she felt Well, let me back that up. There are times that she made other false allegations against Blaise. And one of those allegations is going to be that while she was out of her apartment one day, Blaise had snuck in somehow when he was living in Tennessee and she was in Arkansas, and moved her bed over, or moved her furniture over a few inches, and then left. And she called the police to tell them. Blaise snuck in my apartment and moved my furniture to a court and just to mess with me. And that you'll hear that in spite of all of that she still said Blaise was the best thing that ever happened to her when it was appropriate to do so. And you'll hear just 2 weeks before this incident that she was on social media trying to determine who Blaise was dating. You'll learn that is Apple. So I don't want you to lose focus at the end of this trial. I want you to do what you promised you would do. That you will look at the facts of this case based on the allegations before you, and not things that the state throws in to give you a red herring to put on your heartstrings. Stay focused on the evidence about whether or not that at the end of the day, much like Dr. Carney, did you hear enough evidence, not whether it's sad and tragic, because it is, that a young lady lost her life. Because I also want you to know, and I almost failed to forget to tell you this, that there was also fentanyl found in this baby system, not just that at the end of the trial, in the same way that Dr. Carney cannot rule this a homicide, you can realistically, honestly, to lay your head down at night, get to the conclusion that it was Blaise Taylor who caused Ms. Benning's death. Because when you think about before, during, and after, because whenever it's a circumstantial case, that's what you have to do, that there's nothing that will lead you to a conclusion that beyond a reasonable doubt that it was Blaise Taylor who caused it. And so I'm asking, Blaise Taylor is asking, his family is asking, and justice is asking to find him not guilty. Thank you.
I think, let me switch tabs.
Sorry, ladies and gentlemen of the jury, not at my request, but at the attorney's request,
The
they want a
seal.
short break before witnesses.
I swear the seal just wiggled. I don't know if I was hearing. Oh, there's a head. Maybe it's in the chat. Let me see. All right, yeah, we're back in court. Yeah, I think this might be a verdict the way the chat's reacting. I think this is guilty. If we're back already with a verdict, just saying. That's my prediction. Oh, why are we back on the seal? I don't know. I don't know. Let me take this down. I mean, maybe they're told to just wait on the seal. Yeah, I can't picture this not being a conviction. I think this was quick. They started deliberating at 12:40 Eastern time because they're on Central time. So this is like 2.5 hours.
Session will remain seated.
All right, the court's staff's been made aware that the jury's arrived at a verdict, so we'll let them step down and announce it. Just out of respect to the jury, just keep your reactions, if any, to yourself, and we'll deal with it. All righty?
I don't know, this feed is all the way forward. It's not letting me go forward. I don't know why it wasn't letting me jump. Usually I can skip like 5 seconds.
All right, ladies and gentlemen of the jury, the court just, and I say this just to reference to you by numbers. We start down at the far right and run down this way, 1 through 6, upper right, 7 through 12. So, Miss Juror number 7, you are the foreperson, and the jury's arrived at a unanimous verdict. All right, if you would, please, ma'am, stand and announce that verdict on behalf of the jury.
We, the jury, find the defendants Blaise Allen Taylor for count 1, guilty of second-degree murder.
That's going to be across the board. That's the only one that I could have
For
seen
count
maybe a
2,
reckless.
Guilty of first-degree premeditated murder. For count 3, guilty of first-degree felony murder during the commission of a felony. For count 4, guilty of first-degree felony murder during the commission of a felony.
All right, if you'll turn that document in, please, ma'am. All right, ladies and gentlemen of the jury, you can back up just a second. Ladies and gentlemen of the jury, you've heard your foreperson, juror number 7, announce your verdict in this particular case, that you found Mr. Taylor guilty in count 1, second-degree murder, in count 2, first-degree premeditated murder, in counts 3 and 4, felony murder during the commission of a first-degree murder. I'll ask you if that is your individual verdict. If it is, you would indicate it is. If it's not, you would indicate it's not. Juror number 1, is that your individual verdict?
Yes.
Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes.
Juror number 7, the foreperson, is that your verdict?
Yes.
Juror number 8, is that your verdict?
Yes.
Juror number 9, is that your individual verdict?
Yes.
Juror number 10, is that your verdict?
Yes, sir.
Juror number 11, is that your verdict?
Yes.
Juror number 12, is that your verdict?
Yes.
Okay. All right, thank you very much. As you know, we'll need to discuss with the attorneys further issues in this case. Don't discuss the case any further. We'll get back with you here shortly. You can step down the hallway with the court officer.
All right, we'll listen to that discussion. While they're doing that, though, to say it out loud, the state never sought death penalty in this. So, life without parole.
All right, Mr. Taylor, you've heard the verdict of the jury in count 1. It found you guilty of second-degree murder. That verdict, as well as the other counts, guilty in count 2 of first-degree murder, counts 3 and 4, first-degree felony murder, will become the judgment of the court. In terms of counts 2, 3, and 4, will be the need for further sentencing hearing. Does the state contemplate introducing victim impact statement?
Yes, Your Honor, upon the court finding that by the jury's verdict that we would be entitled to do that.
Okay. We'll take just probably a 15-minute break and let everyone settle down in terms of initial verdict. Come back and hear that proposed testimony under State versus Nesbitt, and then see Mr. Grant, Ms. Hollins, Mr. Joyner, what mitigating factors you want to submit and find that's necessary to submit to the jury. So,
The state's position is that Nesbitt only applies in death penalty cases.
what
As far
I'm
as
talking
doing-
about as far as victim impact 403 analysis.
Under Nesbitt, if it's life without parole, there is submit no analysis.
So you
That
can,
is, there's no dry run unless it is a death penalty case.
you can just have whatever that may be overly prejudicial.
No, it will be victim impact under pain.
Okay. And does Mr. Brand, Ms. Hollins, you have prepared proposed mitigating circumstances?
Yes, Your Honor, I think there are mitigating circumstances, mitigating factors we would argue to the jury.
Okay, all right, if you'll get those,
I think we need a minute probably.
okay, like I said, we'll take a short break, but let me ask the state this, there are cases with obviously with the finding in count 1, that wouldn't be considered by the jury, but there's also, I think it's Hargis versus State, that does apply to any felony murders, that your notice that you submitted, the felony murder portion, I think it's your number 2, wouldn't apply in counts 3 and 4.
Disagree, Your Honor, because it is Middlebrooks. It is not a Middlebrooks situation. It is within the legislation that amended the statute post-Middlebrooks. So that is something the state submits the jury can consider in a felony murder sentencing,
That an aggravating factor is the felony murder.
which is based upon that aggravating circumstance, which is above and beyond just the definition of felony murder.
What do you mean by that?
Well, that the jury would have to find the aggravating circumstance that, again, that it is not a Middlebrooks situation, so that state's position is the jury can consider that as an aggravating circumstance. That was the whole issue in Middlebrooks.
But there's some that would only apply to certain counts.
Yes, Your Honor, the age of the victim, certainly.
Right. All right, we'll take 15 minutes and then come back and hear from the defense in terms of mitigation.
Yes, Your Honor, the state would like to be heard, or see that.
Yeah, let them
We have an argument
Mr.
about
Taylor, and by law, Mr. Taylor, your bond has to be revoked, so if you'll step into the back and talk with your attorney.
Welcome to 15 minutes.
All right, and real quick, we won't anyone that needs it visually, pause the feed. So 2, 3, and 4 were guilty as charged. Remember, so the second count was for the first-degree murder of the unborn baby. Counts 3 and 4 were the felony murders incurred through the perpetration, whether attempted or successful, of the first-degree murder of the other. And then we have a lesser included on count 1. So the jury did not find that there was like this first-degree premeditated, all of those elements against Jade, but they did find him guilty of second-degree murder in relation to Jade. So, and I think that's very interesting because that's the type of thing that on appeal, party will likely argue that the jury they didn't just like go in there, not consider things and just check all the boxes. They made a distinction and decided, hey, in our deliberations, we're only going with this. Oh wait, maybe he's with them. He's got a purple tie. He's like in their face. I mean, so is the other camera person, but like camera reception there. Putting us on the seal. Alright, well they said they're taking this like 15-minute-ish break. And then the jury will come back in for sentencing. All right, so there we go. Yeah, and so since we have a non-first degree, jury gets to determine sentencing in Tennessee. So because we have that lesser included on count 1, jury's gonna have to come back out and sit through another presentation. The defense said they need like a minute to prepare, so it seems like they did prepare in advance to present some of this. Oh yeah, they're not gonna let us hear a hot mic again. They got yelled at a little for that. All right, here's the judge. Yeah, okay, so felony murder is it, real quick though, Miller, do you know if it's like always, or does it depend on the predicate felony? Is there a difference depending on that? Or is it just always felony murder, no matter what the underlying felony is always life without parole? Thank you.
Yes.
I was just saying, the defendant was out, that matter.
Okay. Yeah, you can bring him up. What is it?
Your Honor, on the notice that the state filed to seek imprisonment for life without the possibility of parole, based upon the jury's verdict in count 1, the state permitted to basically strike our number 3 and what would be in the code section number 16, because that requires an intentional.
As to the...
Murder was committed against a pregnant woman.
Right.
And the defendant intentionally killed the victim. The jury's verdict was a knowing killing. I think removes that as an aggravated.
From what would...
I'm going to turn this up because the attorney's quiet, even though the judge is good volume.
If it had been instructed at all in count 3. Right.
Yes, sir.
Okay.
Yes, sir.
All right, so that wouldn't be, all right, now, any submission, Mr. Graham, Ms. Harris, on the mitigating circumstances?
Yes, Your Honor. As far as mitigating circumstances, and I've discussed this with Mr. Moore, we would submit that mitigating circumstances in section J1, that the defendant had no significant criminal history, would be appropriate in this case. My understanding is there's no objection to that.
Okay,
That's correct, Your Honor.
And then, I apologize, I don't know which number this is, but the catch-all provision that any
number
other,
10,
yes, number 10, any other circumstance essentially fairly raised by the proof in this case.
does the state care to be heard on that?
Judge Smith, under the law, that has to be specific as to what that is, like a list of that the defendant graduated top of his class and those sorts of things.
Sure,
Not just a catch-all.
Right, and so to specify, we would intend to put on proof related to Mr. Taylor's education, his high performance in school, his high performance in athletics.
You would?
We are going to.
Okay.
Yes, we are going to put on that proof today at today's
Okay.
hearing. His involvement in nonprofits, his community involvement, other essentially positive personal traits and background related to Mr. Taylor that would support mitigation.
Okay. All right, I guess we can discuss the language of the court would place in there once we hear the proof. Anything else before the jury's brought down?
No, Your Honor.
Give opening statements
A
and,
brief, yes, Your Honor.
okay.
And we would as well, if the state.
Okay. And does the state, just again for court's edification, know how many witnesses you may be calling?
3.
Okay. All right, let the jury step down. But General Moore, the states, are you in agreement that the jury would be instructed in terms, well, I can ask this later. Dealt with victim impact statement not being an aggravated circumstance.
Certainly.
Yeah.
And the jury can only consider that after they have found the existence of at least one aggravating circumstance.
And just before we get into an issue, the victim impact statements are not going to include any statement of what they want.
No,
to happen.
no, we've discussed that.
Okay. Or you can have a seat. All right, members of the jury, when we get to this portion of this particular trial, the law allows for the attorneys to give to you opening statements, then present proof, and I'll explain all this in the jury instructions. The parties are allowed to introduce appropriate, relevant proof to the issues for your determination in terms of the penalty that the state's seeking of life without parole, or whether it should be a life sentence imposed on the counts 2, 3, and 4 that you've rendered the verdict on. Or does the state care to make an opening statement?
Yes, Your Honor, just briefly. Members of the jury, because of your verdict, we are now going into the second phase of this trial. And what the state will present is based upon, like it seems long ago that I read the indictment. In this part of the proceeding, the state relies upon aggravating circumstances that are named. And there are two of those presented for your consideration. Number one, the murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. Say referring to Ivy. Number two, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Again, based upon your verdict. The existence of those circumstances have been found beyond a reasonable doubt by your verdict. That allows, at this point in the proceedings, for the state to present what under the law is called victim impact testimony, to give you a view into what Jade and Ivy's death, the effect it has had on her family, her extended family, and not going into really anything else. It's limited to that. Victim impact. And we'll be calling 3 witnesses. Jade's aunt, Brady Moran, and who would have been
Haymaker crew.
Ivy's great aunt, Andrea Browning, who you have heard before, and Jade's mother and Ivy's grandmother, Bridget Burns. At the conclusion of that testimony, and whatever the defendant chooses to present, anything, this is what this is proceeding, that is submitted to your discretion. The judge will tell you the law, and once we conclude the proof, there'll be opening argument of the state. Perhaps the defense would have a chance, or they will have a chance to make an argument, and the state would close. Again, because we have the burden of proof throughout the criminal trial. But that is the process, and that is what you will hear in this part of the proceedings, to allow you to, in your discretion, determine what the punishment should be for the 3 first-degree murder cases. Thank you. Thank you, Your Honor.
All right, any opening statement?
Thank you.
This case is and always has been tragic. Nothing that anybody's going to say in this relatively short portion of the trial is going to change that. And the thing we are going to ask you to remember is even if you find there's aggravating circumstances, and really the aggravating circumstances the state is going to ask you to find are based on your conviction. Mr. Taylor's been convicted, there's no question. It doesn't require you to give him the harshest penalty ever. He's going to prison no matter what. The best outcome today is the rest of his life in prison, 60 years in prison, with maybe in 51 years, he goes up for parole. He's 30 years now. At 80, he goes up for parole. That's the best outcome for today. You don't have to give him life without the possibility of parole. You can give him the opportunity to try for rehabilitation. You can give him the opportunity to work hard in prison. He's not going anywhere. This is a tragic case, but it doesn't have to be the worst of the worst outcome. Thank you.
All right, who's the state wanting to call?
Your Honor, the state's first witness would be Ms. Brandy Moran, and as part of the proof in this portion of the proceedings, the state would ask the jury to incorporate all of the proof that has been presented.
Okay, I mean, the law allows that. All right, let her step. Please.
Do you swear the testimony you're about to give to be the truth, so help you God?
Yes.
Ma'am, could you please state your name and spell your first and last name for the court reporter?
Brandy Moran, BRANDIMORAN.
You heard me say a few minutes ago that you were Jade's aunt and would have been Ivy's great aunt, is that correct?
That's correct.
And just so we're clear about the relationship, explain the family dynamics to us.
Well, she was my niece, but I was there with my sister the day she was born. I was in the delivery room when she was born, and for lack of not having children of my own for many years, she was like a daughter to me. My sister and I are very close, and so she was more than just a niece to me, and the same with my husband.
And just to be totally clear, who is your sister?
My sister is Bridget Benning Burks.
And so you have known or knew Jade from the moment she was born, is that
The first
correct?
breath she took, I saw.
And throughout her life, did you remain in her life?
She, like I said, was like another child, or like my only child for a long time. In fact, she was 13 when I finally had my child, and she was less than thrilled that I was bringing someone into the world to take her place, which he never did. But we took her, my husband and I took her to Disney World for the first time. I took her on her first trip to New York. She loved to travel. She was full of adventure. We traveled Europe together. And we were in each other's lives when she went to culinary school. She lived with my husband and I. So we were very, very close.
And where were you when you learned about the February 25th, 2023 incident?
I was at my home in Northwest Arkansas, and I was actually folding laundry. My sister called and said something's happened with Jade. I don't know what's going on, but we're heading to Nashville. And immediately, we talked for a little bit. She was in the car, and in the meantime, my husband was in the background. Northwest Arkansas doesn't have a ton of direct flights, and it's a good 10 or 11 hours from here. So he was getting flights for me, the earliest that we could get in Kansas City. And we actually drove all night so I could catch a first 6 a.m. flight out of Kansas City to get to the hospital.
Did you know before arriving at the hospital that Jade was expecting?
Oh, yes. I learned that Jade was expecting on November 9th, 2022, because it was my son's 10th birthday. And she had actually traveled to Arizona. I was in Scottsdale for work, and my work was wrapping up, and I was flying out my son, and Jade flew out, and my best friend, so we could celebrate my son's 10th birthday together. And so she arrived at the hotel, and I was extremely excited that my event was over with, and was ready to, relax, and, wanted to have a cocktail with her, and she kept refusing. And so she finally had to tell me without everybody being there, but she had gotten me a little bag that said only the greatest aunts become great aunts, and it had a picture of the ultrasound inside. So from then on, if you look at our text, every single communication after that was about this baby.
And so would it be fair to say you were looking forward to being a great aunt?
Oh, yes. I had already asked off work well, I didn't have to ask off work, I work remotely. I'd already informed my boss that from June, middle of June through when my son had to go back to school, I would be working remote in Nashville, helping her learn how to become a mom.
The jury has heard that she was removed from life support, she and Ivy, on her birthday. Is that correct?
That's correct.
What was that like for you, yourself, going through that time?
It was probably, I thought, when my mother passed away a few years prior to that, that was the hardest thing I was ever going to go through. But nothing prepares you for what you see as your family's future going away. And although she wasn't physically my daughter, it was like losing a child. And not in a way that was fair, and especially at a time when my very last text to her was, "I'll see you on your birthday to celebrate." And that's what I was expecting that weekend before. I didn't expect to be driving to Nashville to experience what we experienced.
From the moment you heard, got to Nashville, saw what was happening, has there been a day that's gone by that you haven't had this on your mind?
No, it's completely changed. We have a small family to begin with, and it's taken away I won't say it's taken away happiness, and I've done a lot with therapy and grief, and it's never going to go away. But there's never going to be pure joy in the celebrations that we have, because there's always going to be one of the big pieces of our joy missing. So there's...
And with respect to the family, your sister, surrounding people we have heard from, have you seen how this has affected them?
Oh, it's everything. It's how we operate in life now. It's even how I allow my son to do things, because we are a normal family. This isn't anything you ever think you're going to talk about. When I say we were boring people, and we liked it that way, and just, you can't let go of the fact that this type of thing now, really happens to other people. It happens to you too, and it can happen to you. And so it impacts every decision, every thought. There's just, across the board, with my sister, with, our father, with my husband, my son was 10 at the time, and just trying to explain to him why somebody that was, just like a sibling to him is no longer here.
I was going to ask about that, because Jade and your son would be cousins.
They were cousins, but they were
closer than that.
They fought like brothers and sisters, and she was 13 when he was born, and then she turned into his babysitter, and then, she hit adulthood, and he had a little bit of a problem with her being an adult and not just his cousin Jade. So they fought like brothers and sisters, and there's just, it's really hard for me, like I said, because we have a small family, and my husband and I had our son late in life, and we don't have a lot of other relatives, and she was his only cousin, and he's not going to have her now later in life the way I've had my sister. Like, I relied on, and she watched out for him. She could put him in his place like no other, and just, it kills me that I know that he's not going to have that anymore.
And have you seen that actually affect your son?
Oh, definitely. Our entire family has gone through therapy. He had a lot of problems right when everything happened in school, just with behaviors. And it's impacted every single day since it happened.
Prior to this, was your sister, family unit happy?
Oh, yeah, definitely. I mean, we were, you know, my husband and her husband are good friends. She and I are best friends, and like his children, like we all were just beyond just a happy, like I said, happy but boring, normal family. And there's just, I think somebody mentioned Jade's light, and that light's gone, and there's a dimness over our entire family that I don't ever see us getting back.
Can you describe, put in words, what you have seen this do to your sister, to Jade's mother, Ivy's grandmother?
It's just destroyed her. When she talked about Jade being her life, she was her life. Every day. And aside from the fear and the hurt I know she has, I've lived with the fear of like, is she going to be able to get back at us? And thinking about my sister not being here because she can't live without her daughter has been probably one of the hardest things that I've sat and just prayed and hoped that she is strong enough and will be strong enough, because I can't imagine. I look at my own child every Mother's Day and feel guilty that he's still here, and my sister doesn't have her little girl anymore.
Thank you, Ms. Moran. No further questions.
Hang on just a moment. Question from the...
No question.
All right, thank you. You can have a seat. Who's the next witness?
Ms. Browning.
Do you swear the testimony you're about to give to be the truth, so help you God? Yes, I do.
No. Why are we buffering?
Do you swear the testimony you're about to give to be the truth, so help you God? Yes, I do.
Ms. Browning, could you please state and spell your name for the record?
Yes, it's Andrea Browning, Anderea, Browning.
Ms. Browning, what was your relationship to Jade?
She was my bonus daughter.
When did you and Jade's dad get married?
2009.
When did you first meet Jade?
She was about 7 years old, which is how old my daughter is now, our other daughter, Ava.
And can you walk us through Jade's early life?
Yeah, she was a little spitfire. The first time I met her, I'll never forget, because the light everybody keeps talking about, it's so obvious. And I was just, this girl was so full of life and so full of confidence. She always had a smile on her face, and she was always ready for anything. And she adored her dad and her family. She just, you could see it all over her face, and her whole body lit up.
And Ms. Browning, do you have another daughter?
She has Ava.
How old is Ava?
Ava's 7 now. She was 3 at the time.
And can you describe Ava and Jade's relationship?
Yeah, that's tough because, like I said, Ava has Down syndrome, and so she's developmentally delayed, and she didn't know Jade because Jade was in Arkansas when Ava was born, and it was also during COVID, and we were taking lots of precautions about who we were exposing her to. And she finally met Jade in, I believe it was 2021, and they looked into each other's eyes and knew that they were sisters. There was a connection immediately. Like, it was really eerie, but also amazing at the same time. Having her here was so great for Ava because she got to know her last year. And also the toughest part about it was that's it. That's all Ava gets of her, was just that 1 year when she was 3 years old.
And what impact have you seen on Ava's life since losing Jade?
It's tough to tell her because she doesn't understand a whole lot about it, especially because she was so young at the time. But she's really into pictures, and she's always pointing Sissy out in pictures. And she asks about Sissy. Sissy, she uses an AAC for communication. She just randomly hits Sissy on her words all the time. And it's got a little picture of Jade. And Sissy's always with you, is all we can tell her, and just keep explaining to her how great and wonderful her sister is and how much she loved her. And, you know, one of the toughest things I'll have to carry with that is that the Instagram post that Jade made that said being in Nashville, one of the best things about being in Nashville is getting to watch my sister grow. And they will know her.
And can you tell us about finding out Jade was pregnant and how excited the family was?
I was so excited. I was initially shocked, and she could see that, and I think it was a short conversation, but we were automatically super supportive of her and super ready to do anything and everything, take her shopping, help her with decorating, help her with anything she needed help with. I mean, I had just become a mom myself not that long ago. You know, we talked a lot just about, you know, whatever you need, we've got you. And she didn't ask for much. She had a whole bunch. She knew she could do it. She's got all the confidence in the world.
And the jury has heard a lot about Jade's support system and how many people showed up to Vanderbilt and how many people took action that night. Can you describe for the jury Jade's support system, how many people she has here today, and what it's done to her friends?
I can't even begin to describe it because, like I said, she had only been here a year, and she was surrounded by people that were local, like at the end. I mean, obviously everyone from Arkansas came down, but the amount of people that came there that were not from Arkansas, that were there because she made an immediate impact on them. And they loved her so much, and they knew that this was going to be a huge loss to everybody.
And can you walk us through that night of February 25th and how you found out and how Jade's dad found out?
Yeah, I was actually asleep. I had a young child at the time. I had put her down a couple hours before, and I knew she was going to be up early, so I was sound asleep. And once I woke up, I saw the missed calls, and I was in such shock. I honestly don't remember a lot of like who called when, where, how. And I remember it had several missed calls from her as well as Dennis. And as soon as I talked to Dennis and got to Vanderbilt somehow on my own, that drive was awful. I could barely even operate my legs because I knew there shouldn't be anything wrong with her.
And Jade was working at your brother's restaurant back in early 2023.
Right.
Can you describe the impact that her and Ivy's death has had on your brother's staff, your brother, just the restaurant as a whole?
Yeah. It was devastating. It's been really hard to watch my brother because he hired her. I mean, he didn't even hire her. He recommended her to the head chef, and it was a no-brainer for her to hire Jade. You know, he just got her the interview. Like, but everyone at that restaurant, like, and that's the biggest thing is like, they knew Jade was not doing anything she shouldn't be doing, and they were like, always telling me that.
Yeah,
how great she was taking care of
Maybe
all
a
the
jury
things.
approach, I'm sorry.
Okay.
We're gonna lower that one. I need one of those like noise canceling machines. Good golly.
All right, what's your next question?
It greatly devastated them. I could just say that.
And Ms. Browning, is Jade's dad Dennis Browning?
Yes.
And can you walk us through the impact that Jade and Ivy's death has had on you and Dennis?
It's just been devastating, just knowing that Jade is only sister, and we know that she was always going to be around for her when we weren't, and it's ripped us apart, it's brought us closer together, but it's changed everything. We are very much more protective of Ava now, having experienced what we experienced, and I know that it's just changed everything forever for us.
Those are all my questions.
Any questions?
No question.
All right, thank you. All right, who's the next witness?
Ms. Bridget Burks. You swear the testimony you're about to give to be the truth, so help you God. Okay? Could you please state and spell your name for the record?
Bridget Benning Burks, BRIDGET, BENNING, BURKS.
And Ms. Burks, who was Jade Benning to you?
My baby girl.
And was Jade your only child?
Yes.
How can you describe Jade growing up and her light?
As soon as she walked in the room, you knew. Because she was so full of life. She's known for being very loud. She got in trouble several times for being loud. So you knew her presence, her laugh.
And Ms. Burks, does Jade have a stepfather?
She does.
Okay, and what's his name?
Lynn Burks.
And when did Lynn Burks come into Jade's life?
She was 6.
And can you walk us through the impact that Jade's passing and Ivy's passing has had on you and Lynn?
We also have 2 boys, and so it just makes it harder, makes us worry more about our other 2 boys. That was his baby girl. You couldn't tell him any different. And it's just a void that will always be there.
Is your day-to-day life different without Jade?
Most of the time. People ask, are you okay? And I always say yes. But behind closed doors, I'm not.
And did you and Jade talk almost, if not every single day?
Yes.
And Ivy would have been your first grandchild.
Yeah.
Can you walk us through the impact of losing Ivy?
Well, I'm the youngest of all my friends, and I'm the only one that didn't have a grandchild. So I was excited to be able to say I'm a grandma now. I'll never get that opportunity because it was taken from me.
And is there a day that goes by that you don't think about Jade and Ivy?
No.
question?
No question.
Thank you. Have a seat. Any other witnesses from the state?
No, Your Honor.
Any proof on behalf of Mr. Taylor?
Yes, Your Honor. Very, very briefly, I would actually call Detective Adam Reese, who I believe is in the court.
Okay.
Very, very briefly. Put a prediction and number of questions.
You swear the testimony you're not to give to be the truth, so help you God.
Detective Reese, as part of your investigation in this case, did you pull criminal history reports on Mr. Blaise Taylor?
Yes.
Do those include NCIC sort of nationwide background checks?
Yes.
In your investigation of criminal history on Mr. Taylor, did you find any prior criminal history?
No, I did not.
Thank you, that's all.
Any question?
No.
Okay.
That was legitimately quick.
All right, who's the next witness?
Your Honor, we would call Evie Taylor.
Okay.
Well, that's mom. That's Blaise's mom.
Do you swear the testimony you're about to give to be the truth, so help you God?
It's Dr. Taylor, right?
Yes.
Dr. Taylor, can you please state your full name and spell it for me?
It's Evelyn Taylor, EVELYN, TAYLOR.
And Dr. Taylor, what is your relationship to Blaise Taylor?
He's my son.
And how many children do you have, Dr. Taylor?
2.
And is Blaise your older child or younger child?
He's my oldest.
And how old are your 2 children?
30 and 28.
So, Mr. Taylor is how old?
He's 30.
Where do you live, Dr. Taylor?
I live in Texas.
Can you tell us a little bit about who Blaise Taylor is?
Yes. He's the best son I could ever ask for. He's a loving son, a loving brother, a loving grandson, a loving nephew, a loving friend. He's never given me any problems. All throughout school, he was an A student. He was always the teacher's pet. In fact, his kindergarten teacher still keeps up with them to this day. He liked to help other children with their schoolwork because it just naturally came so quick to him. And the teachers would always comment about that. He loves sports. He wanted to follow in his father's footsteps, and so he played sports. Every time we moved, he made a lot of friends. He was team captain and leadership. He was a team leader. A lot of the parents would come to me and tell me that how much respect they had for him. He was a good student in the classroom and in sports, and he was the type of boy that they wanted their children to hang around because he was never getting in any kind of trouble and was very respectful.
Where did this, I'm gonna interject for a minute. Where did Mr. Taylor grow up?
We lived all over. He was born in Texas, but because of my husband's profession, we move every few years. So we lived in Texas. From there, we went to New Mexico, and then Louisiana, and then Tennessee, then Oklahoma, and then Alabama, and then Arkansas.
And is it fair to say sports are kind of a big deal for your family?
Yes.
So you mentioned he was very involved in sports. What sports specifically was Mr. Taylor involved in?
Well, his favorite sport was football.
And that's real big in your family.
Yes.
When did he start playing football?
When he was 5 years old.
And how long did he play?
He played through college, and then he got an invite to try out for the New Orleans Saints upon graduation or after his senior year.
And he ended up not pursuing it professionally?
He didn't make the team, the Saints.
How did he, let's start with high school. How did he perform in football in high school?
He was a team captain in high school, one of the leaders on the team. He actually graduated early. He graduated a semester early so he can go to college early.
And you mentioned a little bit about his grades while he was team captain and playing football. How were his grades in high school?
All A's.
And then where did he end up going to college?
He went to Arkansas State University.
And I think we heard a little bit about that during the trial. Did he play football in college also?
Yes, he played football in college, and he actually graduated with his bachelor's and his master's degree in business in 2.5 years. He was the first college football to ever do, he was the first college football player to ever do that. And while he was there, he started a nonprofit, the Power 1 or 2. He's very passionate about helping children in underserved areas and communities. And so while in college, he and his sister co-founded that nonprofit. And they just did a lot of community events for those children, mentored them. He was a big brother. He volunteered at the alternative school. And his senior year, I think he went like 3 times a week.
Does that nonprofit still exist?
The nonprofit still exists. They've actually given almost like over $90,000 in scholarships. They help each year. They do school supply drives for kids in underserved areas. They do Thanksgiving baskets and adopt a kid for Christmas for children that don't have resources to get presents for Christmas. Pretty much whatever the needs are wherever we live in the community, they just try to serve those children and just meet their needs.
And you said Mr. Taylor's sister was involved in that as well?
Yes. So if you talk to his sister Star, she'll say that he's her role model. She followed behind in his footsteps, and she's an A student as well. And if you ask her why does she make A's, she'll say because Blaise did. Why do you play basketball? Because Blaise did. From the time she was little, he would help her put her shoes on the right feet. When I was her coach, she would be looking at him. And even though he was only in junior high, she valued his opinion and wanted to hear what he was saying, what she can do better, how she can improve. Whether it was in the classroom, whether it was with sports, whether it was trivia things or whatever, whenever she needed advice, she would say that she would go to her brother.
And is Blaise's sister here? Has she been here?
She is. She has been.
Is your family close?
We're a very close-knit family. We move a lot. We know we have each other, and then every time we move, we make several moves, but we always find like adopted families wherever we are. Usually it's through sports. Kids under sports teams, and then they become a part of our family.
I know that this process has been very hard. Does Mr. Taylor have support still from your family?
Oh yes, he has support from our family. We have family members here. It's just hard because we're not from Tennessee. And we've had lots of different moves, so people that we're close to are in various states across to us.
So when Mr. Taylor started working for the Titans, which we heard a bit about, he was in Tennessee and you were still in Texas?
No, we were in North Carolina at that time.
You were in North Carolina. Did you have an opportunity, did you keep up with sort of how he was doing it in work?
In work, yes. We talk regularly, and football's a big part of our family. That's what his dad does, so we have lots of conversations about work.
What's your impression of Blaise's work ethic?
Oh, he has really good work ethic. If you ask anybody that knows him, that's one of the characteristics they'll say. He's a hard worker. He's always on time. He'll be one of the first ones there. He's going to make sure that he gets the job done. He has a really good work ethic in everything he does, whether it was his schoolwork, an actual job where he's getting paid, whether it's a non-service, he always goes above and beyond.
Okay. How about, are there any other, we talked a little bit about the nonprofit, are there any other kinds of community involvement or examples that you can think about from Blaise's life, either recently or longer ago, that you can tell the jury about?
Well, he has a servant's heart, so he does a lot of community service. Usually wherever we live, like with his dad, the football teams usually do community service, so he would be involved in various things that they do. I know one thing, like when he was in high school, where he was actually old enough to make a decision to do those things, he was really involved with the Miracle League. And so that's something he did throughout high school, with big brother type programs, mentoring younger children, he would do that. And then when he was in college, he just did a lot of community service, like I was telling you about, like for his nonprofit, but it was primarily through being a big brother and volunteering at the alternative school. So being a mentor, he would meet, he had a little brother that was assigned to him, and he would bring him to football practice and let him watch. He would go to school and help him with his homework and do things of that nature. And then when he volunteered, I believe it was the 3rd grade classroom at the alternative school, he would just encourage them to do their schoolwork, to respect their teacher, and if they made their points for the week, he would come and he'd bring teammates, and then they would play dodgeball and things like that. And if they had a good week and a good report, he would let them come with him to, or he'd get tickets for them to come to the football game. And he was really involved with the community baskets, and we would do community Thanksgiving dinners. I think one of the things that I'm most proud of Blaise for was one time when he was in college, we were in church, and they were doing baptisms. And I didn't know this because, he didn't tell me this. I'm just watching the baptism, and all the people come up and give testimonies, and it was a young college girl. And she said, I just want to thank Blaise because he really shared about the Lord to me. And he's really instrumental in my relationship with the Lord and my baptism. And all the accolades that he had, like in the classroom or on the field, they were nothing compared to what I feel like he did for this young lady that said that she's a friend that just went to the university. And just the fact that he was instrumental in her being baptized, is those types of things that make me really proud of Blaise.
Dr. Taylor, one Thank you, Dr. Taylor. I think that's all. Well, let me ask this. Is there anything else you think you want to share with the jury that I haven't asked you about?
You're all right with objective being that open-ended.
Okay.
And that's all I
Okay.
have.
All right. Any questions from the state?
No, Your Honor.
Thank you.
That is the defense's proof.
Okay. All right. Ladies and gentlemen of the jury, if you'll step down the hallway just briefly, we'll talk with the attorneys about legal issues and then get you right back. You can have a seat. And just for the record, Mr. Bland, like we did the other phase of the trial, let Mr. Taylor step around and deal with his decision not to testify. If you raise your right hand and be sworn.
Do you swear to tell the truth, so help you God?
I do. Mr. Taylor, you understand that at the sentencing phase of the trial, you have an absolute right to make a statement to the jury.
I do.
You also don't have to say anything. You have the absolute right to remain silent.
I do.
And we have discussed that option and the pros and cons, and whether you want to make a statement at this point in time. Yes. And based on those discussions, you made the decision that you're not going to make a statement or otherwise testify.
Yes.
And that's your own decision.
Yes. All right, he can have a seat. And then, Mr. Brand, in terms of the mitigating circumstances that I'd instruct the jury would be the defendant has no significant history of prior criminal activity. Set out the other mitigating factor raised by the evidence consisting of, and what do you contemplate the court instructing the jury there?
Trying to think of how to phrase this, Your Honor.
Right. I mean, excellent student.
I might. What if we said, community involvement, prior acts of service, support system, and educational and personal achievements? That maybe in the ballpark?
Or community involvement, education, and personal achievement, and what was the other?
Acts of service.
Active service?
Acts of service.
Acts. Does the state care to be heard on that?
No, Your Honor, I think they come under the catch-all.
Okay, and I was planning on setting forth that catch-all about any other mitigating, but then consisting of and then listing.
Yes, Your Honor, I think that would be appropriate under the case law.
And then charge as to in terms of aggravating circumstances in counts 2, the murder was committed against a person less than 12 and the defendant was 18 years of age or older, and the murder was knowingly committed, solicited during the commission of the language there about another first-degree murder.
Yes, sir.
Accurate. And in 3, it would just be that felony murder type language.
Yes, sir.
And 4 would be both again.
Yes, sir.
Well, both
Yes.
again. All right, anything further from the state in terms of jury instruction?
Not without having seen that.
Do you want 10 minutes before we come back with the closing argument? And I can give you the draft.
Just want to make sure that I don't say anything that's not going to be in the charge.
Yeah,
Okay.
I would appreciate seeing the jury instructions, but we don't need much time.
Okay, all right, give the court 6 minutes.
You cut it down from 10 to 6.
Court, my brief
I don't think we were that delayed. We had maybe 30 seconds we can jump. That's it. So but yeah, they're gonna be done before the holiday, guys. Use the 6-minute break. Let's see what you guys are saying. I see a lot of discussion on bench trial versus jury trial. Your gal thinks better jury of 12 than a judge you can't choose. Where did the bench trial go? Yeah, Jane says, oh, maybe not this judge. And then I think, if that's a lowercase L, I think it's Lynn, says bench trial for me. Yeah, I don't know why that like takes me out, like the precision on how our breaks are going to be not 5, not 10, not 15-minute increments. We're going to do 6 minutes. Ooh, Danny says, I was just about to say that now that he's guilty, the judge whole attitude changed. He can hold on to his 4th of July plans, Danny. Darcy says, do you think the history of the ex-girlfriends with Blaise hurt him? Yeah, I mean, I think Apple was the mic drop. I think Apple was a mic drop. I don't think the jury cared about labs or any of that stuff. And again, I wasn't sure if it was just defense attorney running out of time and that was towards the end of her presentation for closing, or if she got the impression, got the read that this was, you know, they're gonna judge somebody for pressuring abortions previously. They're gonna judge somebody for engaging in the use of illicit drugs. And it became a, I don't know, that seemed to me to be what the both sides focused on. Oh, DB also says this. Yeah, I don't know if you guys saw like the screen blinking. I was downloading the documents. If you guys followed the Pike County massacre, that whole trial, which I did not follow that. I really got more interested in it because when we watched the Afro Man trial, people were like, oh my God, you should see the mess that Judge Hine caused in that case. Well, Jake Wagner and Angela Wagner, they took plea deals. They agreed to cooperate. They were supposed to testify against their co-defendants. And the plea agreement was sentencing was going to be held until after the cooperation, the testimony was completed. Well, Judge Hine was just like, we're just going to sentence anyway. We're going to sentence anyway. And I believe went outside the bounds. So part of the plea bargaining was we're going to take the death penalty off the table, whatever. And I believe that the trial court, I don't know the time difference between the two, but he kind of went downward from the agreement. Maybe this is a quicker summary. Okay, so Jake sentenced to life in prison with the possibility of parole. Angela Wagner gets the 30-year prison sentence. And then Jake Wagner's sentence came even though he agreed to life without parole. So that was the issue. So part of his plea deal was also a without parole condition. They're just taking the death penalty off the table. But Judge Hine handed down this with the possibility of parole sentencing. And neither parties requested this sentencing to occur. And it happened before everybody believed it was going to occur. So the Ohio 4th District Court of Appeal issued 2 decisions a few days ago. I don't know if Anisha's in the chat hanging out with us. But she's like, hey, did you see this? So I was just putting this together, downloading the documents, trying to read them. And that's what DB's talking about here. Thinks the decision's wild. So big oopsie there, big oopsie. It's okay if you pick the wrong poll answer. Nothing about the YouTube polls is scientific. They're just like a food for thought type of thing. Yeah, Bay says, hey guys, you're rooting for these bench trials. It's a higher impact of corruption, in my opinion, because you only need to get to one person. And maybe you could get to a person in a way that's like collectively, not even just on a per case basis. You can get to them and just have them steer one way, steer the other way. And I don't know if you guys followed it. There was like that food aid where there was juror tampering, like bribery of jurors. And then there was, if you guys paid attention to the Vibes Cartel case, you know, that happened over in Jamaica, but their highest court is held. They do like the white powder wigs, like British style. So that was a very interesting oral argument to watch. But there was an issue with potential witness or juror tampering in the Vibes Cartel trial as well. So they reversed that conviction, and then a decision was ultimately made not to retry Vibes Cartel, the dancehall artist. So it happens, and those are instances where not involving a judge, but a juror for a jury trial. Ooh, Mackenzie Shirilla chose a bench trial. Yep. So if you guys are interested, if you guys are following the Pike County massacre stuff, I mean, I saw Local 12 had shared an article on it, but without Anisha, I wouldn't have known. And kind of feel like that's a case that a lot of people did pay close attention to and are still kind of waiting to see it play out. And now there's more parts of it that need to play out because we've got this sentencing up in the air again. The sentencing no longer exists. So the plea deal is still in place. And maybe that will reinvite, maybe Jake or Angela will decide, look, there's this change in circumstance. Now I want to fight my plea deal. Like, what are we doing? A can of worms. Can of worms we got going on over there. And this is the exact thing, a lot of these cases where it's just like, it's crazy. Maybe they got somebody dead to rights. Maybe they don't. There's always a burden. You got to prove your case. But a lot of cases just don't interest me unless there's something like unusual about it. Like, why did they wait so long to charge somebody? Why are there these plea deals? Sometimes things get interesting to me. So maybe this is the type of thing that will make me interested in going back to the beginning for the Pike County Massacre case. As far as the next trial, so I think I'm going down to the Miami-Dade courthouse for Rashawn Jones pretrial proceedings. I'm interested in Shayna Gardner, like the series, all three of the cases. My concern with that is I think it's going to overlap with Courtney Clenny and with Rashawn Jones. So I don't know how to work that one out. But tomorrow there's a Courtney Clenny hearing, and we're going to find out if they even think they're on track for an August. That's right around the corner. We're going to find out if they're even on track for an August trial date or if there's going to be another Courtney Clenny continuance or state continuance. So maybe there wouldn't be the overlap with the Shayna Gardner stuff. I've been kind of wondering, like, when there's going to be movement. Lindsay Shriver? I thought that was an interesting case. That's been taking like a million years. Yeah, I know the Shayna case is going to be insane. And there's Anisha. Thank you. Ellie Beast is the Pike County. Oh my god, that one gave me a slight heart attack. All right, well maybe I don't want to cover that then. So, Desi, so I think it's let me check. I don't think they updated the time. You guys might have heard me say for Courtney Clenny, like throughout this week, when they pushed the hearing back a day, it was supposed to be today. And it was originally set as a status hearing. The hearing time was 9 for both, whether it was yesterday or today. They didn't change the time. But when they set these calendars, I don't know if they pushed this back just because somebody was unavailable or if they pushed it back because they're like, hey, we have more time to handle different matters. If you guys have more motions or whatever to argue, I have more calendar availability on the 2nd, so let's take that up. So part of me wonders if they moved it to tomorrow because there's less other cases tomorrow on the judge's calendar, and maybe today was busy. But typically with these hearings, at least for the past few hearings, it starts at 9, but the judge goes through her other cases first and then calls Clenny because she expects it to be more time consuming. So it's supposed to start at 9. But we'll see. We'll see. And also, I haven't seen anything filed since the defense's response to the state's notice of intent to rely on Williams rule evidence, which in Florida, that's like 404, wrong acts, prior wrongs, all of that. Bad character stuff. So. Okay, wait, another bench trial for Penny McGee was the case, and the judge was Judge Bonnie, who was on trial for murdering her husband, found innocent, which was the correct verdict, but a bench trial. Oh, like you think like Judge Bonnie. Oh wait, was this supposed to be Judge Beverly? And not Judge Bonnie? Okay, Shriver with an R. There we go. And that one's it's like so far beyond my realm of awareness now. Cause it's just gotten kicked back. Yeah, okay, it was supposed to be Judge Bev for the Penny McGee. I was like, Judge Bonnie. Oh, goodness. Kimberly suggesting the Clancy trial. Killed 3 children, then jumped out the window. Do you think there's anything interesting in that one? Like, they didn't charge her at first? There was, like, anything odd about it? Oh, Kathy, the cakes are like the lemon pound cake from the Afro Man trial. Keith D trial coming up in August. For me, that's AV to the 7th power is the first person I would recommend for Keith D coverage. Keith D. So that's what I mean by that is I'm following it, but I trust AV's coverage and totally recommend, like, if you want a place to go watch it, that is my recommendation. Let's see. Yeah, DB says Clancy's not that interesting in my opinion. Yeah, I mean, I wouldn't have been interesting in a typical, like, boyfriend killing girlfriend trial, which is how I would classify this one, but I really thought it was interesting that they didn't charge Blaise for a year. Thought that was a big deal. I thought it was interesting that he was granted bond, although I considered, maybe that's just how they do it in Tennessee. Maybe it's not that unusual. And then I thought the attorneys coming from out of town and the potential dispute with the lab work would be very interesting. But otherwise, like this plain, like, couple murdering, I don't know. Not really up my alley. And then Raul Valley. I think that one might be one I look at a little bit more. I followed his, like, some of the hearings post-conviction, and I did watch some of the trial. What trial was happening when his trial was going on? When was that? July of last year. What were we watching last summer? There's like a certain point in time for me where it's like the months following the end of the YSL trial are just a blur. Like, I know I covered ASAP Rocky the end of January, beginning of February after the YSL trial. But then after that, I don't know anything else for like a few months. I don't know what time, like my sense of time is just morphed and warped because of how long that YSL trial went on. Sarah Grace Patrick, if you guys know the channel Infamous Sylvia, she boots on the ground for a lot of Georgia area cases. She's been going to Sarah Grace Patrick proceedings, and she plans with August any of the pretrial hearings and then, of course, trial. She plans on going. She just posted about it yesterday. So, yes, Kelsey Fitzsimmons was also bench trial. Another interesting one we watched recently over here, it didn't make it to trial, so I don't know if it would have been a jury trial. But it was Max Shart, attorney, if you guys watched the YSL trial, you might remember Max Shart, representing a woman named Tamika Clark. It was a self-defense case. accused of killing her partner. State, of course, said it wasn't justified. And we watched the immunity hearing. So not the trial stage, but we watched the immunity hearing in front of Judge McBurney in Fulton County, Georgia. And I thought that was a great hearing, great immunity hearing. All right, judge is back on the
Jury
bench here.
instruction.
No, Your Honor.
Mr. Brown, okay. All right, let the jury step down.
Was July Custodes? When was the Custodes trial? Months ago. Yeah, I think it might have been the Custodes trial. Oh, what a time.
All right, you have a seat. All right, any closing argument on behalf of the state?
Yes, Your Honor, thank you. Members of the jury, we're down to just about the last decision you have to make. And that is, what is the appropriate punishment in this case? I'm going to start out by saying that, yes, the judge will tell you that a life sentence in the state of Tennessee today is 51 years before parole eligibility. That's a long time. It's a really long time. But, contrary to what Mr. Brand said about life without parole being the harshest penalty, the harshest penalty wasn't asked for, the death penalty. So, there are 3 punishments for first-degree murder in the state of Tennessee. One wasn't on the table. Life without parole is the next step down. And life imprisonment is the minimum sentence for first-degree murder. The state submits that while there might not be a quantitative difference, who knows how long someone is going to live, but there is a qualitative difference. That is, what does the crimes that you have found Mr. Taylor guilty of, what do they deserve? And you can consider, I submit by your verdict, where you mentioned this, you found the aggravating circumstances by your verdict beyond a reasonable doubt. That then allows you, and Judge Dozier will read the instructions, not nearly as long as the first one, that upon that finding, you can consider victim impact testimony. What this man's actions have done to the people who loved Jade Benning and would have loved Ivy and did while she was in the womb. She never got a chance. She never got a chance to know how much she was loved. Mr. Taylor, the judge will tell you, consider mitigating. Yeah. Before this, he had no criminal record. That doesn't mean he is not deserving of life without parole under the facts of this case. And again, going back to everything that you heard during the trial, Apple Benny. Apparently, Mr. Taylor was fine with helping out other people's children. He was a good student. No doubt about that. Very smart man, comes from a very well-educated family. A good athlete. Community service. And like I said, good to other people's children. Not his own. That qualitative difference is that life without parole, the state submits to you, is the appropriate punishment. And you'll really have to decide that and come to on each count. But it is your decision, your collective judgment. There's no, oh, we have to prove this, we have to prove that. Once the existence of an aggravating circumstance is before you, and here we have to, then it is your call. And one of the things, victim impact, and you've got, certainly, his parents didn't raise him to be like this. But the decisions that he has made were his alone. His family choose to do so, visit him, so long as he's alive, talk, communicate, whatever. Because there's a saying, where there's life, there's hope. He's going to be alive. He's going to have hope. He's going to have that sense of living and associating and being, granted, not an environment that any of us would want, but it's of his own choosing, his own making. Jade, Ivy's family never have that opportunity. He took that from them about 3.5 years ago. February 25th, 2023. He took something that no one is able to give back. And for that, on behalf of the state of Tennessee, submit that whatever hope of freedom that he should have, he does not deserve, and that he should not receive the minimum punishment for these offenses. Thank you very much.
Any argument on behalf of Mr. Taylor?
Thank you.
Life imprisonment is an appropriate punishment for Mr. Taylor. And punishment is what it is. It is not a minimum get off easy kind of sentence. It is life in prison. 51 calendar years at best. That's if you make parole at 80, if he's 30 right now. Yes, in opening I said it's the harshest you have is life without the possibility of parole, and there is death penalty, but this isn't a death penalty case. We knew that at the beginning. It's the harshest option you are considering today. And life imprisonment is incredibly harsh. Living in a concrete box for the next 51 years, that is punishment. He's not getting off. He's not getting off easy. You're not letting him go. He's not walking out of this courtroom. Likely for the rest of his life. Now, Looking at the jury verdict, it occurs to me that maybe there is some consideration from the jury that you all think Mr. Taylor intended to kill baby Ivy and maybe didn't have the intent to kill Jade. But he knew he was killing her, or some version of that. Obviously, I'm not in the jury room. I don't know if that matters in your deliberation for this part of it. But if we're talking about what are the worst of the worst of the worst crimes that you get the worst of the worst of the worst punishments, this was a long, incredibly detailed, complicated trial. And you guys heard a lot. You can consider all that when you're making your determinations. The reason that we put on some proof about who is Blaise, what was his family like, what's his upbringing like, what's his community involvement like, is there's kind of a, I don't know if it's a saying, it's something that's talked about in work when you defend someone sitting at that table, that we are more than the worst thing we've ever done. We're people. Blaise is a person. He's got a family. He had a great childhood. He did well in school. He was an all-star athlete. Yeah, he did something horrific. Nothing that can happen here is ever going to change that. Nothing. And he's going to spend the rest of his life in prison no matter what. So you all can go home and rest assured that no matter what you do here today, he's going to spend the rest of his life in prison. It doesn't require life without the possibility of parole to send that message, to send that punishment. It's not either we let him off easy or we have to punish him the worst of the worst of the worst of the worst. He's being punished. He's getting the message. But he is not someone who has spent his entire life as a criminal. He is someone who's had a good life, who's done good things. I don't have anything to say about it. Did something terrible. There's, let's call it what it is. When you hear the jury instructions, there's going to be a lot of talk about aggravating and mitigating factors. And I said this in my opening, and I'll say it again. If you find aggravating factors, you don't have to find that he gets life without the possibility of parole. It's just something you can consider. Life imprisonment is punishment. It's life in a box. It's life in a prison. It is a message. It is a lot. It is enough. And we would ask you to return for your sentencing that be the appropriate sentence in this case.
All right, any rebuttal from
Just
this?
very, very briefly, it's time to have this jury determine, does he deserve the minimum allowable? Or does this crime, these crimes, Mr. Brand argues this is not the worst of the worst. What could be worse than killing your own child and your own child's mother? That is my life without parole. Is an option in this case, and is an option the state of Tennessee would respectfully request you consider and return. Thank you. Thank you, Your Honor.
All right. Members of the jury, you've now found the defendant Blaise Taylor guilty beyond a reasonable doubt of murder in the first degree as charged in counts 2, 3, and 4 of the indictment number 2024A49. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that a person convicted of a murder in the first degree shall be punished by imprisonment for life without possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt, and any mitigating circumstances which may have been raised by the evidence throughout the entire course of this trial, including the guilt-finding phase or sentencing phase or both. The jury is the sole judge of the facts and of the law as it applies to the facts in this case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given the evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or physical effects of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravated circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. You may consider this victim impact evidence in determining the appropriateness of the sentence only if you first find the existence of one or more aggravating circumstances as has been proven beyond a reasonable doubt by evidence independent from the victim impact evidence. Count 2, statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. And 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempted to commit any first-degree murder. Knowingly means that a person acts knowingly with respect to the conduct or circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. The defendant has no significant history of prior criminal activity. And 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character, any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. Count 3, the felony murder involving Jade Tristan Benny, statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or is fleeing after having a substantial role in committing or attempting to commit any first-degree murder. The definitions of knowingly, intentionally, which apply to this offense have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether imprisonment for life without possibility of parole would be an appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity, and 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspects of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant, which is supported by the evidence, consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. Count 4, felony murder involving the victim, the unborn female child of Jade Benny, statutory aggravated circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more statutory aggravated circumstances, which shall be limited to the following. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Definitions of knowingly and intentionally which apply to this offense have been previously explained to you in these instructions, and you should refer to those definitions as they apply to this offense. Members of the jury, the court has read to you aggravated circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravated circumstance in deciding whether the imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include but are not limited to the following. 1, the defendant has no significant history of prior criminal activity. 2, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or any aspect of the circumstances of the offense favorable to the defendant which is supported by the evidence consisting of A, community involvement, B, education and personal achievements, and C, acts of service. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance or that you agree on the same mitigating circumstance. The defendant has not taken the stand to testify as a witness during the sentencing hearing, but you should place no significance on this fact. The burden is on the state to prove any aggravated circumstance or circumstances beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. You will be provided a verdict form consisting of 6 pages. You have 2 sentencing options to consider on each count, and you are not required to deliberate on these sentencing options in any particular order. The options are as follows. Verdict, life imprisonment or life imprisonment without possibility of parole. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravated circumstance or circumstances have been proved by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory circumstances or circumstances proven by the state beyond a reasonable doubt, and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravated circumstance or circumstances so found, and shall return your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravated circumstance or circumstances beyond a reasonable doubt. Here on the verdict form, you would list the statutory aggravated circumstance or circumstances found. You shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. You will be provided with a form for all possible sentences in this case. The jury will check the appropriate verdict on the form for each count and complete the form as directed and each juror will sign the verdict form. The other forms are to be left incomplete and unsigned. Your foreperson will preside over your deliberations, and when you have reached a verdict as to the sentence, you will turn to the courtroom and your foreperson will announce it. You must not imagine that the court has any opinion in regard to the facts. It is your duty to find them, and have attempted to read this charge to define to you the law without indicating any opinion about the facts whatsoever. Members of the jury, the charge in this case is herewith handed to you, together with the verdict forms for the punishment for each count and the exhibits. You may now retire and consider your verdict. You can step down the hallway with the court. Anything further from the state?
Judge, I know that there need to be a hearing, sentencing hearing, and if we had a date, we might also be, will be in our
Yeah, in
calendars.
terms of merger and count one,
And,
whatever happened.
yes, Your Honor, and,
And we can look at like the week of the August 3rd, like the 5th maybe, or somewhere around there. Discuss that.
yes, that's awesome.
Anything further on the jury charge, Mr. Grant?
No, sir. Oh.
All right, we'll be in a recess.
I don't know if this one will take much time.
Court to recess.
We do a prediction poll. They do have to select that there are aggravating factors found.
Yes, that was merged, but, you got that.
This is the penalty phase, Ally. So
Merges that the court should impose a sentence, so we don't have, if for some
I'm
reason.
gonna ask to go further on August 5th. I can't imagine.
There's, yes, pretty much more.
I would say like maybe, is that crazy? Are we in any rush for this? Is that like?
Yeah, we just, yeah, what, yeah.
started a
That's why I
stopwatch.
was asking, did you get a confirmed date, so.
That's what I mean. I mean, we're not like in a rush, right? Like, we don't have to
Yeah, they took 2.5 hours for the guilt phase deliberations.
That would be our preference.
But this is deliberations for determining whether or not to recommend life without parole or just life.
He gets to do it themselves. They need like 50 days or more. They're like stacked.
That's kind of what we're thinking, that's a little quick.
Yeah. It's like, I was like, and they just asked for 45 days like a couple weeks ago. So now they need about like 30 days. Yeah. So I was like, let's see what
Alright, maybe they're trying to pick a date that they can do. Now there's too many people talking over. I'm trying to eavesdrop. I'm actually surprised they didn't turn the sound off, because the camera guy the other day with the hot mic. Take care, Jade Flower. They're finally quieting up there. I'm gonna turn this down a little. If they start whispering, we could turn it up and eavesdrop again. Are we back? We're only at like the 6-minute mark. Alright, there's a poll on the timing. Kind of weird, because I'm trying to use like ranges, that way everyone can kind of place their vote. Heck yeah, J Hud says, let the eavesdrop. I appreciate the +1 on that.
We all want to know. Please don't. Right.
Right. They'll be fine. Yeah. I know I was ready to jump up. Because that was definitely a feeling. What?
Just a little bit, but I see how I figured it out.
They are.
Well, did somebody say something? Sorry. At this point,
Are they coming back?
You're gone.
you want to make it? Yeah.
Been like 12 minutes.
Yeah. Lights.
see that happen.
It's just been wacky. I was just counting Sunday is,
Oh,
it's just
yeah.
been dragging.
No, I literally lost count. Well, that's
That is something to be.
Yes, yes.
Did you go to sleep?
Yeah, I was gonna say. Did you get hooked? I said 3:30.
I was up at 4 too. I said I was up at 4 too, and I thought that was
Yeah.
It worked.
I mean, he is. Right, because the mentally would not have been. She's been gone for 6 weeks.
And just, again, maybe walk good. No, we did it. Now, Raven and Andre Johnson. Well, one thing too, though.
Hopefully it's not.
Okay, let me see. We can do that. Murder and potential felony or serious.
Let me hop on here and say big thank you to Melanie Berry for the 10 gifted. If you guys are just listening in, check your screen because you might have just turned green. Big thank you to Melanie. Oh, wait, are we? Okay, they're shutting us out. I was gonna say that'd be crazy if like Melanie comes in here, gifts the 10 super generously, and then suddenly we have action in the courtroom. But it actually seems like they're cutting us out. So no more eavesdropping. That was not me that lowered the court volume. That was the media person. So big thank you to Melanie here. And also, Bench Jammin' became a member earlier. It was Bench Jammin'. It was your birthday earlier this week. Hope it was a good one. But yeah, so my timer, by the way, I start my timers like not exactly when the judge says, all right, I'm gonna like release you. I wait until we hear shuffle out of the courtroom. So I'm at 49 minutes and 30 seconds. So coming up on the hour. Coming up on the hour. So we've knocked out. All right, I have a poll going, right? Let's see. I was wrong. I was like 10, 15 minutes. I was wrong. So 23% of us, we didn't guess right. And then the 15 to 30 minute interval is also out. That was 34%. And we've got right now 16% that predicted an hour. Now don't come in here and steer the poll just because you only have 2 viable options left. Don't slant our poll. Type in the chat what you're predicting over under the 1 hour mark. So 27% putting the 30 to 60 minute range. Factual lie is volunteering her concession. You could have just adopted the 30 to 60 minute range, but you're like, no, honestly, it was 30 to 40, so I'm out. Yeah, it is interesting, right? I mean, what are your food for thought? If deliberations took about 2.5 hours and like, let's just round it up and say it takes them an hour to make this decision. Is that interesting to you? Are there any like reading of the tea leaves there? Gloria's also 15 minutes. I'm out. Yep, me too. Yeah, we got Catherine in the 1 hour plus hanging on in there. DLM's like, I may have to leave you. They gotta hurry up because we want them to come back with DLM here. I think it's an important decision to make. I mean, to be honest, I think someone's life being in your hands really comes with the guilt phase, right? The determination of the guilty verdict. But maybe the reality of that weight hits home when you as jurors now have the sentencing decision on your shoulders. In a lot of cases that we watch, it doesn't, we just watched a death penalty case. That was interesting the first time we watched a death penalty case from start to finish through the penalties. And somewhat similar, there's a penalty phase where, it's the jury's decision. This is a Florida case and they only need to be 8 of 12 in Florida. Here, I think it needs to be all 12. But with that, same thing, right? You put on this penalty phase, the state will say, here are the aggravating factors that we feel that we've proven beyond a reasonable doubt. And the defendants are multiple co-defendants, so they put on each, respectively, their own mitigating circumstances and had testimony, and they argued, and jury had to deliberate again, and they returned with no recommendation for the death penalty. And in Florida, that means the judge can't decide, okay, well, I'm going to sentence someone to death penalty anyway, it constrained the judge to the life without parole option. And it was just interesting to see that process streamed and played out. You read about things like that, but I don't know, it's like interesting to have the cameras there for the whole process. And then here, it just makes me wonder, like, does it have, I think serving on a jury is a heavy load. Especially like sometimes jurors, they'll look at pictures that are sealed from the media. Like the media can't display certain pictures for every single trial. Some trials, the gory stuff gets on the screen. But a lot of the time, a lot of these trials will say like, look, we're going to keep certain things under seal, especially things that involve children, which I think is the right decision. As much as I am for transparency, I have my exceptions that I think are agreeable. And, maybe when there's a sentencing decision on the juror's shoulders, it's a heavier decision. That's my food for thought. That's kind of where I think about it. And really, I mean, the option, it's life with the possibility of parole, life without parole. I mean, those are the two options here. It's not like the jury can decide, we know we just convicted him, but you know what? We say, let him free. Like, that's not on the table, in case anyone's concerned. I'm pretty sure the way the sentencing works is it's not, so for a guilt phase, you need to have all 12 unanimous, or like it could be 6 depending on what type of case it is. But you need to have everybody in agreement to convict. But once you have the sentencing, I think if they don't agree, they just stick with that. They're not going to put forth a recommendation. So like, in other words, I think it would just default to not being a recommendation if they can't get the agreement. And I don't know, that's actually making me think of when Josh Brand, the attorney for Blaise, got up, and he's like, you guys, it seems like you guys were thinking, well, maybe not. I don't know. Can't really tell for sure. Is that the judge? Do we have some action? My clock is under an hour. We're like right at the 56-minute mark. So our third tier guessed right in the poll.
Court staff's been made aware the jury's arrived at a decision in terms of the punishment phase, so we'll let them step down and announce it. And was there an agreed on date on any sentencing issues?
I think the clerk was looking at possibly a date in September.
You want to do the 9th?
August 9th.
Check that, let us know if it's not good. All right, all right, juror number 7, you are still the foreperson, and the jury's arrived at a verdict in terms of the sentencing issue. All right, if you would, please, ma'am, stand and announce that verdict from the jury verdict form.
We, the jury, unanimously find that the state has proven the following listed main circumstance or circumstances beyond a reasonable doubt. 1, the murder was committed against a person less than 12 years of age and defendant was 18 or older.
I guess they could
2,
still recommend
the murder
otherwise.
was knowingly committed, solicited, directed, or aided by defendant, while defendant had a substantial role in committing first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life.
And that is
Count 2.
Okay.
For count 3, we, the jury,
Life?
unanimously find the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt.
Oh,
1, the murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing or attempting any first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life.
life? What about, I'm
And count
actually
4,
surprised.
we, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. 1, the murder was committed against a person less than 12 years of age and the defendant was 18 or older. 2, the murder was knowingly committed, solicited, directed, or aided by the defendant, while the defendant had a substantial role in committing any first-degree murder. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life.
Yeah.
All right, and that's signed by
He has-
each of the jurors.
Correct.
All right, you can turn that document into the court staff.
He'll have the opportunity for parole.
Anything further from the state?
No.
Anything further on behalf of Mr. Taylor?
No, Your Honor.
All right, ladies and gentlemen of the jury, I appreciate very much your service for the last week plus to the court and your community. You'll be discharged from this case and from your jury service. You can step down the hallway with the court officer.
I'm honestly like, I swear, when she first started speaking, I felt like her voice had such an oomph. I did not think it sounded like there was going to be parole option.
All right, Mr. Taylor, you can have a seat. Mr. Taylor, you've heard the verdict in terms of the punishment. Counts 2, 3, and 4, that the jury's imposing a life sentence in each of those counts. That verdict will become the judgment of the court. We'll set this on 9/9 for any sentencing issues, merger issues. And if that date doesn't work, Mr. Brand, just let us know in advance.
Yes, thank you, Your Honor.
All right, let Mr. Taylor step in the back. All right, we'll be adjourned.
All right, so September 9th is the date that they said. And let's just make sure nothing interesting happens here. Yeah, so if it was life without parole, it would have to expressly be stated as without parole. So he will, at least according to the recommendations here, in theory, if he lives however long for the minimum, he will be eligible for parole consideration. And a lot of people are saying 51 in the chat. So when it comes to sentencing, though, and how this is all coming together, I mean, we heard that there might be some merger issues as a matter of law. I don't know if that's going to be complicated by count 1 having a lesser, and we have a felony murder conviction with a predicate of attempted or successful first-degree murder. I don't know if that's going to be anything complicated, but sentencing, we're going to hear all those issues by people that know better than me on September 9th. So, and Peter, you know, the why no cuffs thing, there was an appeal I saw recently in New York State where I forget the nature of it. I think it actually involved like arraignment, either a bond hearing, arraignment, like something like that. But the idea that when a judge's decision is to be made, unless there's an explicit finding that there is a reason to restrain a defendant that wasn't otherwise present, to suddenly cuff someone who wasn't previously cuffed can prejudice the finder of fact or the person who's about to make a decision. And something like sentencing would still be a critical phase of trial. Maybe next time we see him after he's been fully booked into custody or whatever. I don't know. I don't know. But yeah, there are some appellate issues, and I feel like it's raised all the time, where even though it's a judge and you think that they can distinguish, there are still arguments that can be made that suddenly seeing a change that's unwarranted, unnecessary restraint could be argued a matter of prejudice. So I don't really know exactly how Tennessee handles stuff like that. I've seen Texas cases appealed over similar issues with like ankle shackles being referred to out loud, not even visible to the jury. But like one case, I think it was the 13th District Court of Appeals in Texas. A detective was on the stand and they were asked to identify the defendant, and he pointed and was like, the woman in the green dress with the ankle shackles. And the Court of Appeals determined that even the mention, even though it wasn't something the jury was able to see with their own eyes, prejudiced the jury and affected the outcome, affected their decision. So, and a lot of cases say that you can't just have a blanket rule that everybody needs to come into your court restrained. You need to have like specific criteria. Again, could be something with Tennessee's rules. I don't know how they play there. But other than that, guys, just to specify again, the jury did not recommend life without parole. They went with life instead. And I don't know what to make of that. I think the jurors could have come up with their own reasons for reaching that decision. Maybe a lot wanted to go with the life without parole. Maybe only one did. Maybe none did. Maybe some wanted to go with just a life recommendation because they just didn't want it on their own shoulders, that they took away somebody's chance permanently, right? Maybe others decided, well, we want life because maybe the way we're thinking about this second-degree murder charge, maybe it's, I don't know. I think everybody, you never know what mix of the jurors, how they think, how they break it down, what they ultimately decide unless they choose to speak. And really, when a juror speaks, they're not supposed to speak on what any other individual juror expressed in that courtroom. They can speak generally about, hey, we did this, or some of us were thinking this, but they're not supposed to be like, well, I did this, and then juror number 2 said this, and juror number 3 said that. So our best insights would come from the jurors deciding to speak on their own. So Rox says, I wonder if any jurors will speak with the media. I feel like they will. I feel like it's probably more likely than not with a case like this. Mostly because I think there's media actively seeking out interviews with the jurors. So opportunity, right? And then I think a lot of jurors will want to explain. So. Oh no, there's no, they revoked his bail already here in this case. So anything else I was just saying was just speaking of other issues that I've come across that have been raised because, you know, a judge decided now I need a defendant shackled and I didn't give an express reason that justifies it. Like he tried to get up out of his chair or like move his arms in a weird way at somebody else in the courtroom. So now we need to put shackles on him where he otherwise wasn't previously shackled. I wouldn't be surprised if when he's sentenced, he's brought in like handcuffed and then maybe they take him off. It doesn't seem like they thought he would cause any harm to anyone in the courtroom. What's our next case, guys? I'm trying to make the decision if I'm going to go down to Miami-Dade on Monday for the Rashawn Jones hearing. That's it's a gag order hearing, sort of. It's also a media restriction hearing, sort of, but might not be. It's kind of unclear, and I think ultimately I think the judge might use some caution in restricting public access to the Rashawn Jones trial. I think she'll try to restrict it in some way, maybe ending like Zoom access for people who want to observe the proceedings through Zoom. I'm not sure I can picture her restricting public access, like if you go in person to the courtroom, which is why I feel like got to take the trip down to Miami. It's a long drive, and I just know it's going to be a nightmare with the holiday weekend. So I'm trying to make that decision, and if that's the case, I'll probably be too tired Monday night unless something really goes crazy. I'm trying to think positively. If you guys haven't heard, I've been named in that case. I was wrongly accused of recording inside the courtroom and posting it to YouTube, even though it was law and crime and I restreamed law and crime. So I'm also a little hesitant to go in person in case they try to like give me a hard time. Because a good First Amendment attorney is they don't come cheap. But so I'm wondering. I'm hoping they're not going to give me trouble if I go down there. But yeah, there's a whole time. And defense tried to point out like, hey, we believe that was law and crime, and the one prosecutor was like, no, it wasn't, and the other prosecutor chimed in like, it had to have been Kat. We don't know how she did it, but we know it was Kat, not Williams. It just defies common sense. So I feel like I need to go down in person because otherwise I don't know how we're going to know what happens on Monday at this hearing. But then I also hope they don't try to mess with me. So that's kind of the next thing. That's the Rashawn Jones case, you guys. That is a cold case down in Miami-Dade County. A lot of the other cases I'm covering, I don't know what's going on. I do live in Florida, but this wave of Florida cases that seem to be coming onto the radar recently, it's purely accidental. And a lot of these cases are actually in the Miami-Dade courthouse. So if you follow the George Pino trial last week, that same courthouse is where the first Rashawn Jones trial took place. He reports there for all of his hearings to a different courtroom. Courtney Clenny's in that courthouse. Antonio Brown's case is in that courthouse. Like there's just like 1,000,001 cases in Miami-Dade County that I have an interest in, and it's just by total accident. So, oh my goodness. Yeah, so jury decided they did not recommend life without parole. They just recommended life. So yeah. Factual lie, if needed, I will absolutely reach out to Lisa. I'll show you guys the motion. I'll show you guys. I put up a quick banner that we're doing like a sidebar discussion on Rashawn Jones. Discussion on... And they didn't accuse me in the motion the way that I was accused in open court. So the motion that they filed isn't specifically for media restrictions. It'd probably be easier if I downloaded this and then pulled it up, but oh, let's see how this displays. Why is it looking like that? Let me just download it and open it. That way it plays nice. All right, so this was filed shortly after the last hearing, which I went down in person for. Or I think it was filed the morning of the hearing or whatever. State's motion to preserve written communications and compel defense to provide discovery for an in-camera review. So they are seeking a gag order against the defense attorneys in the case, but during the hearing there was also discussion of restricting access to the public, to observers, and to the media. There was an attorney present for ESPN at the last hearing I was at who was like, hey, we'd like to be able to speak. And the judge was like, no, you need to come on July 6th. So I anticipate Miami Herald, NBC 6, which is a local Florida channel, Local 10, ESPN. I feel like they'll probably have attorneys there. But I'm not quite in that same category. So Their access, they might have approval for certain access that I might not fall under the umbrella of access that they get if they successfully fight. But as far as this request to gag the attorneys, real quick on the headers, I will do a full stream with the updates on this. I've just been waiting for this hearing to pass. But they're seeking communications with attorney Jeremy McClimate, who you guys might remember if you followed the Alicia Andrews trial. He is her attorney. They are seeking any communications the defense had with the media. And so they list here ESPN reporter Paul Levine, Local 10 reporter Leon Morjan, and anything related to an interview with ABC's 2020. They say this is not an exhaustive list. It's not limited to this. There were other names too. Where's Christian? I think Christian was named. Let's see. I think Christian Cologne was named. I thought he was named, but maybe not. Yeah, so I think NBC6 then was mentioned in court and not in this motion. And that would be Christian Cologne. And then here, you'll see that this is a little bit different. They're not naming me as like media, but they're saying that unbeknownst to the state and in violation of Florida Rule of Civil Procedure, defense counsel received the audio of the deposition of George Jones, no relation to Rashawn Jones. On June 9th, 2026 at 12:08 p.m., defense counsel filed defendant's supplement to renewed motion to dismiss, containing a link to the audio of George Jones's deposition. On the same day, an account entitled Catnot Williams recorded a live stream on YouTube where she played the audio of the deposition and displayed text of the audio. So they didn't put in the motion what they accused me of in open court. What they're talking about here is it was included in a motion that was filed relating to the disqualification of the judge. And it went up on a petition to the Court of Appeals. So I got it from that public filing, and that was that. But in court, in person, they accused me of recording from inside the courtroom. You're not supposed to record things in the court. There's rules against it. And like, my feed was uploaded after Law and Crime published the hearing. You can see their built-in subscribe button sitting there on the screen. It's just a lot. Just a lot. So I didn't see. Let me double check. I don't think I saw a response. I saw that the state replied to the habeas petition that's up at the Court of Appeals, and then they asked for an extension to reply to the petition for writ of prohibition in relation to the denial of the disqualification of Judge Christina Miranda. Oh, wait, I think they did. They filed today. Good call, Michelle. Is this from the defense? Yeah, it's from Sarah Alvarez. All right, so this might be the next thing I do a stream on. I want to talk about this, but I don't want to do this at the end of the stream where anybody that actually might be interested in Rashawn Jones' case and the proceedings will find it. Plus, I want to make sure I'm not tied into it in any way. Like, I'm not trying to give myself open exposure. I'd rather know if I have to be ready to fight against anything, I'm prepared for it. But yeah, there will be updates. We've got a lot of updates to do in the Rashawn Jones case, including some deposition transcripts of Juan Segovia. There's currently an ongoing internal affairs investigation against the lead detective, Juan Segovia. Some stuff involving Michael Von Zompt. So if you followed any like recent happenings over the last year and change in the Miami-Dade State Attorney's Office, there's been a lot of happenings with disgraced former prosecutor Michael Von Zompt. So there's some filings that we need to read about him still. There's a lot. So there's plenty of streams. Am I the new Young Thug? I mean, the prosecution team in this case might be the new Fani. What Fani was to Young Thug might be this prosecution team to me. So, but yeah, that is, and I'll drop a link to this. I don't know. This is kind of a long link when it's like this. So I think it's going to break in the chat. I don't know if I think it's going to be too long. Well, okay, guys. So if you've never, here's what we'll do. I'll drop the link if you want to go to the site. It's really great the way that the documents are accessible through this Miami-Dade, their clerk. Let's try this one. This one should take you to the docket for Rashawn Jones, and then you can just find the most recent document at the top there. So the new link I just pasted that didn't break halfway, use that one if you want to go read that motion. It should take you there right to the docket. So that's what we've got. That's what we've got. Yeah, and Michelle's like, I'm trying to defend my own First Amendment right in Miami. Man, they're trying. They're trying. Florida versus Catnut Williams would be hilarious. That'd be hilarious. So I'm going to think about that over the next few days, you guys, about whether or not I'm going to go down. If I do go down, I'll probably go down Sunday night. But yeah, do I need Mr. Steele? This is communist Russia. Yes, email me. It is cat@catnotwilliams.com. Got to get Jim to pro hawk for me. Fly him out to Florida. And let's see. There we go, you guys. I'm going to end the discussion on this one with Rashawn Jones. I promise there is a lot we still need to cover. Right now, his trial's tentatively scheduled for September 14th. I want to say 18th, but I think it's September 14th. I don't know if that's going to stay on track. If you missed what I think is big news, on the 23rd of June, Rashawn Jones got arrested, a new arrest, for contraband in his cell on March of 2024. So he's been fighting for bond. I have suspicions about the timing of this arrest for contraband in his cell from March of 2024. I think we've got a dogfight going on between the defense and the prosecution in this case. But yeah, if you missed it, he was arrested with a new charge of having this contraband in jail, relating to like they found him with like cut up papers inside a sleeve. So there's that. I posted about that as a community post, but we'll include it when next time we do a stream on that case. We'll go through the documents. So if you're looking for that, go check my community post and you can see it. Other than that, before I just make this into a whole Rashawn Jones stream, thank you guys for hanging out and sharing your thoughts and experiences on the Blaise Taylor trial. Especially as a kind of a polarizing case. I think it was tested the patience, but thank you guys for being kind, being open to different perspectives, changing perspectives, and sharing what your perspective is. And obviously now my mind is right now focused on Rashawn Jones because we were just talking about that. If you want to go back and look at that case, if you're looking for something to watch right now that this one's over, I have a playlist. It's called 15 Years Cold. I went into it trying to figure out why we were having this retrial, what happened at the first trial. And I think you'll see by episode 5, I'm like ready to pull my hair out and think it's like, I'm up in arms about what's going on in that case. So there's one if you're looking for something new, check out the Rashawn Jones case. And then other than that, guys, maybe tomorrow, Courtney Clenny hearing, probably the next thing as long as nothing gets delayed with that hearing. And then was there anything Friday happening this week? No, I don't have anything on my calendar for Friday. But next week there's an Antonio Brown hearing scheduled for the 8th. If I go down for the Rashawn Jones thing on Monday, I can just stay till Wednesday and go in person to see the Antonio Brown hearing. So yeah, paper dope, Michelle. That's the way to say it. So love you too, Peter. Always good to see you. And I always feel compelled to bring out a YSL reference when you're around, which brings me fond memories of our like the origin of a lot of, the reason people come back to this channel. I think a lot of us met through the YSL trial. Bench Jammin', you be careful. You be careful. Enjoy your birthday celebrations. Green emojis. And big thank you to the mods again. Difficult trial where emotional, sometimes opinions cross the line of being emotional and become personal. And big thank you to the mods for making sure this chat stays a place where people feel welcome and feel like they can not be in the majority opinion on every single case that we watch. So big thank you, and see you guys next time.